What would you do if one day when checking the mail, you found a note from your husband saying he needed to get away for a while? And what would you do if months passed and then years and he never returned? And what would you do if you later found out that your husband wasn't who you thought he was? In fact, law enforcement had no idea who he actually was. And what would you do if 30 years later, neither you or the authorities had any idea of his true identity? I'm not sure how I would feel. Hurt, angry, sad, enraged. But most of all, I'd want answers, which is why I became involved in this case and why I'm bringing it to you now. Myself, along with the detective on the case, and a group of researchers have invested hundreds, if not thousands of hours trying to find this man and to bring his wife the answers that she deserves. There's one simple way we can do that, by finding someone who knows him, which is where you come in. Take a minute, like this video, share it here on Facebook, Twitter, Instagram, all the socials. I don't even know all the socials, just share it on all the socials. And help us spread the word about this story so we can find that person that can help identify him. But enough about that. Let me tell you this fascinating story of what some have dubbed the Invisible Man. In 1991, around Sheridan, Indiana, in the suburbs of Indianapolis, a man claiming to be Paul Raymond Herod was working in what we would now consider an aide position at a children's home, assisting with physical therapy for the kids. A woman, who we'll call Mary for the sake of her privacy, was also working there. She supervised the kids in the playroom. Mary had been married for over 10 years and had a preschool-aged son at the time. Things weren't great at home, so when Mary met Paul, they started chatting. When they'd pass in the hallway, she was kind of drawn to him. In November of 1991, Paul helped Mary file for divorce from her husband, and he moved her and her son into the home he was renting to own on Worman Street in Sheridan. Within 6 months, they decided to get married. They filed for a marriage license with the Hamilton County Clerk of Courts. Paul listed his age as 50, although he certainly didn't look it. His place of birth was Illinois, and his parents were Paul L. Herod and Margaret Coletti, both born in Chicago. Paul listed one prior marriage that ended in divorce in November of 1985. Paul told Mary his previous wife's name was Diana Ray, spelled R-A-E. Her maiden name was unknown, or Mary couldn't recall. Mary thought that he had said she was living in Topeka, Kansas, or Wichita, or Kansas City, Missouri, somewhere in that area. Paul and Mary's wedding was reportedly a very small affair with only several people attending, all family and friends of Mary's. It was held at Mary's mother's home in Michigantown, Indiana. Paul's best man was a co-worker of Paul's, whom the priest had asked to stand in for him, since he had no friends or family in the area. Mary described Paul as always working. While they were together, in addition to working at the children's home, he worked as a janitor at St. Vincent's Hospital in Indianapolis, and also delivered newspapers for the Indianapolis Star. Mary described Paul as being very secretive about his past, many other aspects of his life. Things like the large scar on his head went from the crown all the way down to the back to the nape of his neck, went without explanation. When she would ask, he would just shrug it off. Although he did happen to mention to her at one point that he had a hair replacement surgery, but he never said that that was where the scar came from. Paul shared several tidbits about his life with Mary and her family over the time he was there. He mentioned that he had previously worked at a casino in Las Vegas. He said the name of the casino was Harrods, like his last name. Although Harrods is the department store, the casino is actually Harrah's. And Harrah's did not have a casino in Las Vegas at that time. It was actually after 1992 before they expanded to Las Vegas. They were previously in Reno. Paul also mentioned that he was in the military. He didn't say which branch, but he specifically mentioned Greenland. Mary was unable to recall exactly what he said, whether he was stationed there or he flew over the base, but she felt confident from the way he talked that he was probably in the Air Force. Paul told Mary that he was born in Illinois, which he also put on his marriage license, but that he grew up in the Bronx. He said that his mother's family was Italian. Mary would later tell the detective that while he said certain words strange, it didn't really sound like a New York accent. He said words like water and order funny. I did a little research on that, and the only accent in the United States that says those words funny is actually a Philadelphia accent. Mary also recalled him being a good cook and preferring to eat at home rather than going out. At some point in 1992, Paul purchased a brand new white Geo Metro. Woo! He was previously driving an old white wagon-style car that was on its last leg. Paul, with his secretive nature, wasn't one for pillow talk. But one night, while they were laying in bed, he says to Mary, "I could just disappear, like the wind." Mary recalls being pretty stunned by the comment at the time and said it gave her chills up her spine. Then came Thanksgiving, November 26, 1992. Paul and Mary attended a Thanksgiving dinner together at Mary's grandparents' house in Frankfurt. This photograph was taken that day and is the last known photograph of Paul. After dinner, Paul left for a while, presumably to go on a walk. Many people go for walks after big, large dinners, so it wasn't anything out of the norm. Mary later thought about it and recalled not far down the street there was an old motel that had a payphone, and she thinks perhaps he went to that payphone to make a phone call during his walk. He came back, and the afternoon proceeded as normal. They had driven separately. She can't recall why, but it wasn't anything abnormal. And Paul left early while Mary stayed and visited with her family. There was literally no way for Mary to have foreseen that when Paul drove out of the driveway of her grandparents' house, that was the last time she would ever see him. When Mary got home that evening, Paul wasn't there, and he didn't return for several days. She recalls not being concerned about him not being there. She wasn't interviewed until almost 20 years later, so it's understandable that she doesn't recall specific details. She thinks perhaps he was supposed to be at an Amway convention in Atlanta. It wasn't until the following week. Mary went to check the mail and found a handwritten note addressed to her in the mailbox. The mail carrier had scribbled an admonishment on it for improper use of the mailbox. When Mary opened the note, she found something very unexpected. A handwritten note from Paul saying he needed to get away for a while. And there was a $100 bill attached to it. He wasn't at the convention. He had left. Mary waited for him to return, assuming he needed a few days, maybe a week, 2 at the most, but time kept passing, and there was no sign of him. After a month or so, Mary started receiving phone calls from the finance company regarding the missed payments on the Geo Metro, which was missing along with Paul. Those were actually the only 2 things missing. He left with the clothes on his back, as far as Mary could tell. When Mary explained the situation to the finance company, GMAC, they assigned the case to an investigator. The investigator did some research and informed Mary that Paul had another social security number, but she didn't give her the number or any other name associated with it. This was May of 1993, and Mary finally came to terms with the fact that Paul was not coming back, and she went to the Hamilton County Sheriff's Office to file a missing persons report. She called the office frequently to see if any progress had been made on the case, but there wasn't, because they weren't actively looking for Paul. He was an adult who was voluntarily missing. Believe it or not, as an adult, you're allowed to disappear. Paul's missing person report was eventually listed as a cold case and overlooked for nearly 20 years. When the cold case of missing person Paul Raymond Herod was discovered in 2013, it was assigned to Detective Greg Lockhart, who began working on it immediately and hasn't stopped for the past 10 years. There wasn't much to go on other than the police report Mary had filed with Paul's basic information, and that he just left. One of the easiest ways to track a person is with the Social Security number. It's required for so many things: employment, credit cards, bank accounts, pretty much anything to do with money. Plus, by this point, Paul should be old enough to start collecting Social Security payments. After all, he would have been 71 by the time Detective Lockhart got the case. So one of his first actions was to try and research Paul using his Social Security number. He worked with the Social Security Administration and determined that the number Paul was using was fraudulent. So was the date of birth, and even the name. Paul had stolen the identity of a young boy that died in 1947 at the age of 5. That young boy, the real Paul Raymond Herod, was nicknamed Skippy. He was born in Evanston, Illinois on February 2nd, 1942, to Paul Monroe Herod and Mary Eleanor Condon. On December 27th of 1947, the family finished their holiday celebrations at their home in Bloomington, Indiana, and they traveled to Eleanor's parents' home in Cedarville, Ohio. Skippy was so excited, he jumped out of the car before it even came to a stop. Tragically, a passing car didn't see him and hit him. He was transported to a local hospital, but died shortly after. He was buried in the town of Herod, just outside Lima, in Allen County, Ohio. Detective Lockhart reviewed Skippy's information and discovered a discrepancy. Fake Paul had listed his parents as Paul L. Herod and Margaret Coletti on the marriage application. If he was using Skippy's information, it should have been Paul M. Herod and Mary Eleanor Condon. So was this a mistake in remembering the details? Or did fake Paul accidentally put the correct information on the license? Due to his secretive nature and just the few obscure details that he told Mary through the years, there wasn't much information for Detective Lockhart to go on in tracking him down beyond the use of Skippy's Social Security number. It was determined that fake Paul applied for the number in 1987 using an Eagletown, Indiana address. Eagletown is just outside Sheridan. Fake Paul had used Skippy's number for his employment at the children's home, St. Vincent's Hospital, and the Indianapolis Star. There were additional hits on the number, showing he had worked as a delivery driver for Chesty Chips. He's wearing a Chesty Chips jacket in the last known photo of him, and one of only several photos even available. He also worked at a liquor store in Westfield, Indiana. Detective Lockhart obtained a copy of fake Paul's application for employment at St. Vincent's Hospital, and on the application he listed his education as Roosevelt High School in Yonkers, New York. Detective Lockhart contacted the school, but of course they had no record of anyone by that name ever attending, since Skippy never got the chance to attend high school. There was another very interesting hit on Skippy's Social Security number. It was used to open a bank account in Hoven, South Dakota, not long after Paul disappeared. A small amount of money remained in the account at the end of 1992, according to the year-end statement, but there was no further activity on the account. There have been 2 legal actions filed against the fake Paul Raymond Herod, a civil judgment in Hamilton County in the amount of $9,087 in 1993, presumably for the Geo Metro, and a second judgment in 1994 by Midwest Credit Services. It was dismissed in 97 due to not being able to locate him. Detective Lockhart then turned his search to the Geo Metro, which was still missing. He was able to obtain the VIN number, and a search showed it had been sold by a dealership in Inglewood, Colorado in January of 1994. This is a little over a year after Paul went missing. Since almost 20 years had passed, there was no record of the transaction, other than the car had been purchased at auction. And at this point, there's no way to know when, where, or by whom the vehicle was recovered prior to being taken to the auction. Although it's safe to assume a vehicle worth less than $5,000 wouldn't have been transported very far at the auction. The highest in Geo Metro brand new was worth $10,000. And by the time it was recovered in Colorado, it had 40,000 miles on it. This is when Detective Lockhart hit the end of the paper trail left by fake Paul Raymond Herod. Detective Lockhart next turned to his valuable law enforcement resources. They used the information provided. At this time, they didn't even have a photograph, and they were able to compile a profile that came up with several hits on possibilities for the identity of fake Paul. He ran each one of them down, even traveling to other states, but none of them were him. So he started his interviews. He met with Mary, with her sister, and even with Skippy's sister. Skippy's sister didn't recognize fake Paul and had no idea why he would possibly steal her brother's identity. Mary and her sister were able to finally provide him several photographs and what little information that they had on him. Unfortunately, none of the information provided could actually be corroborated in a way that could lead to figuring out his true identity. The Hamilton County Sheriff's Office was able to obtain a search warrant for several items that Mary still had in her possession. Some of them included cards and envelopes that Paul may have sealed himself. Despite the passage of time, everyone was hopeful that DNA and fingerprints could be lifted from these items. It took months for the reports to come back, and there were no results obtained. After quite a few years with no forward movement in the case, Detective Lockhart began to think outside the box. He teamed up with Purdue University's Forensic Science Club to review the case file and help generate possible new leads. He posted the story on the Hamilton County Sheriff's Office Facebook page as a cold case profile. This action in particular led to locating the best man in the wedding photographs. Mary didn't know him, remember him, or have any idea what his name was. But after seeing himself in the photograph, the man contacted Detective Lockhart. Sadly, though, he has no recollection of Paul or the wedding. Since that time, he has been in a car accident and has several health issues that affect his memory. So Detective Lockhart pushed on, and he decided to turn to the web sleuths community to see what they were able to dig up on the case. This was in 2019. Meanwhile, he continued to run photographs of fake Paul through facial recognition software and regularly received hits. Many of the hits were easy to rule out, with the subject either being deceased or incarcerated at the time Paul was in Indiana. One hit several years ago looked very promising. The photographs were super similar. The man had attended Roosevelt High School in Yonkers, which is what Paul put on his application for employment. He had ties to Colorado, Las Vegas, and Kansas, all places that were tied to Paul. And he was currently in Alaska, about the furthest off the grid you can get without leaving the country. It took a little over a year for authorities in Alaska to respond, and when they did, it was to inform Detective Lockhart that the man was confirmed to be in the state of Alaska at the time Paul was in Indiana. So, another dead end. I personally became involved in this case through web sleuths. They had questions about genealogy, and once I answered those questions, I found myself immersed. I spent countless hours scouring the internet for clues, looking up every detail I possibly could. It is one of the most intriguing cases I have ever come across, and trust me, I have come across a lot of cases. I have learned so much about different things while looking into this case, but let me tell you about a couple of the rabbit holes I have been down. The first question everyone has in this case is, why did fake Paul show up in Indiana in 1987 and vanish in 1992? And there is no way to know for sure, unless we're able to track him down and he tells us. However, we've developed several theories. One of the first was that he was in witness protection. That is the most common theory. It took a while, but I was actually able to rule this one out, based on the fact that he was using Skippy's identity. The Social Security Administration does not ever reuse a number. You can actually change your number, although it is rare and it is a very difficult process. Unless, let's say, you're in the witness protection program, in which case they'll issue you a new number. So there's no way they would have issued him Skippy's number or allowed him to reuse it. Another theory is that Paul was running from something. This is probably the most likely theory, although it brings about many more questions as to what he was running from and how serious it was. If he was running from, say, a child support obligation, that just makes him a crappy person, but it's a possibility and not very serious, and not something he has to run from. He just has to pay for it. But maybe he witnessed a crime, or someone was after him. And while he probably should have gone to law enforcement, there's lots of situations where people don't feel comfortable doing that. The True Crime Garage podcast did an episode on this case, and I'll link it down in the description. And they worked with Glace PR, and I'll link that as well. And they developed a theory that fake Paul was actually Joe DeRose Jr., also known as Little Joe, a Youngstown, Ohio mobster who supposedly was killed in 1982 in a car fire, although his body was never found. There is a resemblance in the photographs between Paul and Little Joe. The problem with this theory is that someone confessed to killing Little Joe and is currently serving time for it. Another theory is that he witnessed a crime, and this is a definite possibility. This theory brought me to missing person Stephen Hedgers. Stephen went missing in 1986 from El Dorado, Kansas, not far outside Wichita. This is one of the places Mary mentioned Paul's ex-wife may be. She also mentioned Topeka and Kansas City, all of which are near this area. Stephen supposedly witnessed a drug deal between co-workers at a trucking company he worked at. Paul was actually a truck driver. Stephen's young son had died the year before, and his wife and his daughter were out of town. When they returned, there was no trace of Stephen. There was speculation that he was killed and buried in a gravel pit. That pit was excavated fairly recently, but no evidence was found. While this is a massive reach, you can't rule out the fact that perhaps Stephen was shot in the head, the same place Paul has a massive scar, and fled and changed his identity. Again, very unlikely. Another factor against this theory is that Stephen wore prescription glasses. Mary said Paul never wore glasses or contacts of any kind. There's some resemblance in the photos, but the photo of Paul is a little grainy, so it's really hard to get a good read on his facial features. Paul didn't leave us much to work with in the way of breadcrumbs, but the fact that he chose Skippy's social security number has always baffled me. Getting a new social security number wasn't that difficult back in 1987 compared to now. I did some digging and I talked to several people who were somewhat familiar with that kind of thing. They didn't want to go on the record, but they told me that you simply picked a deceased person, went to the records office, and got a copy of their birth certificate. Anyone could go do that at that point in time. You then mailed in the Social Security forms along with the birth certificate you obtained. There were very few checks. One thing they mentioned was that Cook County was known as the place to go to do this, as they were notorious for having a poor record system. Evanston and Chicago are both in Cook County, ironically. As for how to pick a person, they said the most common way was to visit a graveyard. This theory doesn't necessarily hold up in Paul's case, since Skippy was buried in Allen County, Ohio, but he was born in Evanston, which is where Paul would have to go to get his birth certificate form. There's quite a bit of difference between these two places, when there's probably a dozen graveyards in Evanston alone that could have been used. Also, by looking at the grave marker, he wouldn't necessarily have known that Skippy was born in Evanston. He could have gone to the local library and looked through old newspaper articles until he found a child who had died. Skippy's death was covered in many local newspapers. Interestingly, the details of his death were misreported according to his sister. The newspaper reported he was out playing in the street with an airplane versus her version of him jumping out of the car. I question this theory because in my mind, surely there were other children he could have chosen that had birth dates closer to his own. This is pure speculation on my part, but Paul definitely does not look 50 years old in his wedding photos. Another theory is that he knew someone in the Herod family, a very large family, and they lived mostly in Allen County, Ohio. There's even the town named after him. Skippy's parents moved to Chicago, and according to his sister, they moved to Bloomington, Indiana before his death, then eventually moved back to Ohio. It's possible Paul worked at a hospital or one of the assisted living facilities where Paul or Eleanor spent their last years. If they told him the story of their son, all he would have to do would be to go take a road trip over to Cook County and get a copy of their birth certificate. But then the question arises, how did he end up from Ohio to Sheridan? There are several other breadcrumbs left by Paul, like the name Margaret Coletti on his marriage application, his ex-wife named Diana Ray, Roosevelt High School in Yonkers, New York, the Greenland military base. I have spent so much time looking into each one of these things, hoping to find some kind of trace of him. I still work on it daily. There's many other little hints of things. We have no idea whether they're true or not. We could be wasting our time running down all of these leads, but if we don't, how do we rule them out? Which is why I'm hopeful we can spread the word with this video. Who knows what this man did before he showed up in Indiana or after he left? How many other lives has he impacted? How many women has he done this to? And how long does Mary have to live without knowing who she was married to? So help us solve this crazy mystery by taking a moment, share this video, ask your friends and family to do the same. There is no telling what part of the country or even the world that fake Paul is in by now. So share it everywhere you can. And hopefully someone who knows him or knows something about him or has some little piece of information will see it. And if you are that person, please contact Detective Lockhart at the Hamilton County Sheriff's Office. And I want to thank you very much for taking the time to view this and hopefully share it and spread the word and helping us solve this crazy mystery of the Invisible Man. So the question for today is, should kids be forced to go with the other parent when it's time?
Michael LaRue?
Okay, Michael LaRue?
Yes.
Okay, this is in the matter of Michael LaRue versus Carrie Ann Danielson, file number 17-044246. We are here on a parenting time complaint, which states that Michael alleges that he only got parenting time with his son, not his daughter, on the weekends of May 5, May 19, and April 21. This complaint was done through the front of the court. Let's see. All right. You stated that Carrie kept Kensley because of softball. I've not seen my daughter in 7 weeks. All right. And sir, are you able to take your daughter to softball?
Yes, I am, Your Honor.
Okay.
I was just never
so-
given the opportunity to.
Okay, hold on. So Miss Danielson, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so ma'am, you understand we're here today because he's stating that you withheld the child for quite a few weekends in violation of a parenting time order. Do you understand that?
Yes.
Do you understand the contempt of court for failure to comply with an order could result in you spending up to 93 days in jail?
Yes.
Okay, so ma'am, so even if she has sports, she has to go to parenting time and he has to take her. Do you understand that?
Yes, if he would take her.
Okay. And let's see.
Your Honor, I don't know if I'm allowed to interrupt or say anything, but
how old is Kensley?
She will be 9 at the end of September.
Okay, so Mr. LaRue, she's on, she plays travel softball and travel hockey. Do you understand if she's involved in these sports, you're required to take her?
Yes, I do, Your Honor, and I have when I did have her.
Okay, and then do you understand that if you're unable to take her, you need to return her to mom to take her?
Okay.
All right, Miss Danielson, that's pretty standard. He would be required to take the child or the children. And then if he's unable to, he would just return her to you to do that. All right.
Correct. Yes.
All right. So going forward, ma'am, do you think, are you willing going forward to provide, to make sure that she's provided to her dad for parenting time?
I will do my best, but my daughter doesn't want to go because he continuously
So
doesn't
it doesn't
show up for
matter
her.
if your daughter doesn't want to go. All right. So Miss Danielson, if your daughter doesn't want to go, you tell her, listen, you have to go. It's your dad's parenting time. You can always file a motion, but if you go against the court's order, you can go to jail. Do you understand?
I do understand, but I also don't think that kids should have to go through this.
Well, that's what happens when parents aren't together. So Ms. Danielson, it doesn't matter. You don't have the right to not send her. Do you understand? If you want to file a petition for a referee hearing or go through the courts to change that, you can. But right now, there's an order in place that she has to go for her parenting. And if she doesn't want to go, then you could go to jail and then she'll end up with her dad full time.
Okay, Your Honor, how do you obtain a full copy of the complete order as of right now? Because I've tried to obtain it and I have been unsuccessful at this time.
You go to the circuit court clerk's office on the 3rd floor, you ask to see your file and you tell them which things you want copies of and they charge you $1 a page.
So there's not an actual direct order that I can go off of and actually see which thing is in full effect at this point.
As I said, you can go to the courthouse, go to the 3rd floor, ask to see your file, look through the file, find whatever order it is. I don't have your file. I just have the front of the court show cause. And then
Okay, I'm
whatever that you want to make a copy of, you make a copy of. But in the interim,
I understand that, but unfortunately, the problem that we're running into is that there's a lot of old court orders and we don't know exactly which one is the correct one to
all
go
court
off of.
orders stay in full force and effect. So even though you get a new order, if it doesn't contradict an old order, the old order stays in place. All right. So I'm going to adjourn this out to, let's see, September 18th at 8 a.m. to make sure parenting time is taking place. And sir, you understand you're required to take her to all sporting events?
Yes, I am.
You understand if you're not able to, you need to get her to her mom the day before, okay?
Yep.
All right, so we'll see you back on September 18th to monitor this. All right, thank you both.
Thank you.
Related to the 14-year-old son.
Yes.
So what I'd like to do first is address the contempt motion first. So Mr. Sorensen, you're the moving party in that motion. So you can lay out. I've read the pleadings that both parties have submitted, and they were not short. So I read all of them last night. So I read everything that you have submitted, and so I'll hear from Mr. Sorensen first, and then we'll hear Ms. Fike's response to the motion. Mr. Sorensen.
Your Honor, I'm here today to hold Ms. Fike in contempt to regain my.
Oh, Mr. Sorensen, I apologize to interrupt. Just as you guys go
statements, what I filed and asked for. The parenting plan is not.
So, Mr. Sorensen, when you first started speaking, your audio was terribly garbled, and it was just little bits and pieces, and then it started speeding up and kind of putting everything together again. So I missed pretty much everything that you said at the beginning.
Okay. Basically, I'm here for contempt as the parenting plan was not obeyed. The violations were all.
Oh, Mr. Sorensen, sorry to do this to you again. It looks like we're having that same audio issue.
Your Honor, I'm here today to hold Ms. Fike in contempt and regain my residential schedule with my son. As you can see from the filed statements, what I have filed and asking for. The parenting plan was not obeyed by the mother, and the violations are as follows. Did not follow the residential schedule in Section 8, Paragraph B. I was denied visitation on 6/25, 6/26, and 7/7. Ms. Fike disparaged the parent myself in front of the child, which occurred on 6/25 pickup day, which violates Section 14 paragraph restrictions in the parenting plan, where she discussed adult issue matters, badmouthed me and my wife and slandered me, used profanity towards me, refused my visitation, and kicked me off her property in front of our son. She asked the child involved to make decisions or requests involving the residential schedule with which violates Section 14 paragraph restrictions. Ms. Fike and our son clearly discussed changing the residential plan. Ms. Fike requests our son to discuss and to make a decision on attending visitation where he chose not to. She discussed changing the residential schedule with our child outside of already agreed plans, which violates Section 14 paragraph restrictions. She encouraged the child, it was his choice to change his primary residence and his choice whether or not he attends, which violates Section 14 and the paragraph restrictions. She did not construct a regular and consistent responsiveness and cooperation during refusal of visitation, which also violates the Section 14 with restrictions. Tiffany did not attempt to reach me in any way on June 25th to discuss, resolve, or inform me of any disruptions to the schedule, even after being instructed to do so by LPD. She tells my child he does not have to attend visitation, that she is not going to make him, goes and files a plan for supervised visits, and tells me he should stay with her until the 20th. Then, after being informed of contempt, states she can't physically make him go. That contradicts all her claims and that she is following the parenting plan and keeping him from me. Ms. Fike did not notify me prior to pickup to inform me of Christopher's refusal. She had hours to do so and did not. She also did not discuss any resolutions with me, asked me to get help Christopher to attend, did not ask the police to enforce their help, did not ask me to attend a conversation at pickup time. Instead, she had Christopher contact me informed me he was not attending visitation 4 hours before visitation was to occur. She had plenty of time to contact me during the 4 hours before pickup time to occur and didn't. I attempted to contact Ms. Fike and she denied both phone calls, which puts our child in decision making. I had no choice but to contact LPD for help. LPD then contacted Ms. Fike when she answered for them, and she was instructed to follow the parenting plan and to make sure my son came home, and was also instructed to contact me. Neither one occurred. Ms. Fike never made contact with me. After being informed by Christopher he was not to attend visitation and speaking with LPD, I attempted to pick Christopher up that evening. I was met at the door with Tiffany trying to facilitate an ambush against me in front of my son and Coach Christopher, not once telling Christopher he is to attend visitation and go with me, or to get in the car, which should have been the only issue we were discussing. Instead, she was allowing my son to tell me he is not attending and he shouldn't have to, with his mother in agreement. That she's not going to make him. Christopher was disrespect me and defying my wishes to get in the car. She also instructed me to read a letter Christopher wrote to the courts, not to me, but to the courts. I read the first few lines and it was talking ill about me and my wife and tired of having to obey our rules, again placing him in the middle of involving him in court decisions. She wanted to control the narrative and shame and slander me in front of our son. It was a non-constructive environment, not suitable for any discussion. I ended up being told by Miss Fike to get off her property and to leave without my son. I tried the following day to get Christopher and was met again with text from Christopher that he is not attending. I tried calling Miss Fike, who did not answer, and received text that she is not going to make him. I tried to regain my visitation on the second week I was to have Christopher. I set up counseling for him to attend and tried to contact Miss Fike that Christopher needs to attend visitation. She did not want to hear anything about it. She refused communication about the second visitation to start on 7/7. I did not in any way approach Miss Fike combatively or maliciously. I simply informed her Christopher needs to come home, attend counseling, and offered a non-conflict way to get him home. She ignored my text. The following day, however, she threatened harassment charges on me if I were to continue talking about receiving my son. She told me we needed to wait for court and that Christopher should remain with her until then. I contacted LPD, who tried to get Miss Fike again to follow through with the parenting plan, mentioning multiple times it's in her best interest to do everything possible to follow the parenting plan, and she told them as well she was not going to force Christopher to go. LPD then instructed me to continue with the contempt. She supports any and all alienation of involvement and sees no issue with it at all. Ms. Fike, in the midst of this, used her personal server, be that of her mother, Jill Hall, the grandmother of Christopher, who for the better half of 3 years, it was ordered by the courts she is not be around Christopher until she can attend drug counseling and pass a hair follicle test, since she is a known drug addict and has placed Christopher in danger in the past. A woman who is not allowed around my son should not be allowed on my property or near my family. Jill Hall came to my residence twice, both times relentlessly banging on my door and ringing the doorbell for over 5 minutes at a time. Jill Hall is a very dangerous and unpredictable individual that should not be involved in this situation or around in any form. I told Jill Hall when I retrieved the papers to not come back to my property, where she then screamed, "You've been served." Ms. Fike utilizing her mother in this situation is very concerning and puts our family in danger, which only solidifies malicious intent. The constant problem at hand is Christopher feeling pressured and coached to evade my house. He is discouraged from loving myself or a lifelong bonus mom. Christopher voices this time and time again and asks for help on the issue. Every 2 to 3 years, Tiffany tries to find ways to manipulate the courts and change the schedule, use baseless false accusations to attain that. This case is consistent with the previous ones. Christopher displays the same antics at our house, however, it is handled appropriately. Christopher voices major and concerning issues about his mother's home weekly. So we utilize the school counselor when he has an issue. We set up a meeting there to discuss it. We don't ambush Miss Fike or harass her via text, name call, disrespect, or make Christopher feel he has to choose. We pick a professional setting suitable for all parties involved. Your Honor, Christopher refuses. He does not want to attend his mother's visitation almost every week and voices concerns on Fridays. However, we encourage him to spend time with his mother, tell him he is to attend. We run through problem solving, give him problem solving tips. We do not keep him home from her or make him choose to involve him in the court matters that are trauma causing. We always try to facilitate a constructive in-house resolution without slandering Tiffany or causing Christopher to fill in the middle. I myself initiated and asked the court's last custody case to hire a GAL to help with the ongoing issue. I knew involving a professional who works to find the truth would, and she did. Rhonda Larson did an amazing job. She is also available to call on as she is still on our case. I also have been working with the school counselor and Christopher about this exact problem Christopher has with his mother making him to choose sides, lying about my wife and myself, making false allegations. I also attained an outside counselor outlet for Christopher through the school council to help with these issues at Northwest Psychology. I cannot comprehend how Ms. Fike thinks complete annihilation of our family is a good plan. She feels the need to constantly destroy me, my wife's relationship, and family. She uses Christopher in order to do so, not realizing she's destroying him in the process. Christopher has been forced by his mother to write letters, make false claims, and statements about my family, which I know fills Christopher with guilt and embarrassment, as he states. A time my son should have been spending with myself, attending youth group, Christ for the Court basketball camp, collecting his volunteer hours for high school. We have scheduled on our time, attending his job he acquired, family vacations, 2 of which were canceled due to these circumstances, missing a sister. Instead, he spent a better portion of almost a month away from me with no communication at all, under the impression he is prepared to take his father to court. Stressed, sad, and unequivocally involved in adult matters no child should, my son has never gone 3 days without talking to me or 7 days without seeing me in his entire life. While I've been dedicated to following the instructions of the court and parenting plan, Ms. Fike has been creating an environment of paranoia and fear for Christopher, taking him away from his family and disregarding the instructions set forth by the courts and law enforcement. I'm asking the courts to bring my son home immediately for the lost time to be awarded, where he needs to attend counseling, get back into his schedule he lost, and attend his youth group, prepare for school coming up. He desperately thrives on this schedule that has been robbed. I'd like Ms. Fike held accountable so this situation is to never occur again. Thank you.
Okay, thank you, Mr. Sorensen. All right, Ms. Fike, I'll hear your response in relation to the motion for contempt, please.
Yes. So, like you said, this is my 3rd attempt to change the parenting plan. Well, 3 years ago, my son threatened to run away. He's threatened to run away from his dad's house multiple times due to mental and emotional abuse from his dad and stepmom, and more so physical, as you know, Mariah has pushed Christopher before. The reason why I've put this motion into place, because Sunday, June 25th, we got home from my sister's house. It was my nephew's birthday party. He was to go to his dad's at 8 p.m. At 6 p.m. that night, he comes to me or calls me into his room and says, "Mom, what would happen if I refused to go to my dad?" Is he muted? What would happen if my mom, or if I refused to go to my dad's house? I told them, I'm not sure what would happen, but why don't you want to go to your dad's? Like I said, this was 6 p.m. It was 2 hours before he would have went to his dad's house. I'm talking to him about it, why he doesn't want to go to his dad's. He says the same reason for years. He said he was in the middle of writing a letter to the courts. I did not persuade him. This came out of nowhere, that he refused and wants to write a letter to the courts. Did I submit that letter? I did not submit that letter. He wanted his dad to read it because everything on there pinpoints the majority of what's been going on and how he feels about it. My son is mentally and emotionally abused over there daily. He's never wanted to go to his dad's house. He has blatantly said it every single week, but this is the first time he's actually refused to go. I told him I'm not going to make him, but that he needs to go. I feel like he does. But in the back of my mind, from what's been happening over the years, that nobody's been listening. Like, I feel like this, like I said in my declaration, this is his final cry for help. I'm hoping he wants to talk to you, the judge. He wants his voice heard, not what, because the back and forth saying what Christopher says at his dad's house and what Christopher says here, like somebody else needs to be that middleman. And as of counseling, I didn't hear about him putting him into counseling until, let's say, I didn't get served with his papers till the 4th of July. And that's when I read that he had an appointment at Northwest Psychological, which we both should have been informed on that as well. And then the next day on July 5th, Joseph texted me and said that Christopher will be going to that appointment, that he made this appointment, this and that. Well, I already also made him an appointment at Core Health. He has an appointment on August 1st at 1 p.m. Christopher filled out the intake. Christopher filled out all the questionnaires as it's his counseling session, and he turned it in. So my question is, why or how did he get that appointment with psychological without telling or talking to Christopher about, or having Christopher fill out the child intake? Because that's what that other courthouse says, you know, it's for him. Since he's over the age of 13, teens have a little bit more rights than parents know of. And I said, okay, that makes more sense. So I read the child and intake form that would have been filled out for psychological. And one of the questions were, for you as a parent, why do you think that your son needs counseling? Well, I'm not sure what they put on that piece of paper, but my son is refusing to go to his dad's house. So whatever they put on that paper is what they're telling you. So my thought is Northwest Psychological already has a different version of what Christopher's really going through, because his dad wrote whatever he did on that paper. The intake that Christopher filled out for Core Health is all of his words, all of his answers, all of everything for Christopher. I didn't even read it. I just took him to turn it in. Like all that is, I didn't read it because I want people to realize I'm not the one making him do this. I'm not the one bringing court into him. I'm not the one who's bringing any of that up. Christopher is pretty much fed up. And what happened at the airport after his, his DC trip with his stepmom, I think that might have been the last straw, because it's just too much. I'm really hoping that somebody's actually going to listen. It's not me holding Christopher away from his dad. It's Christopher refusing to go. As my part, yes, I should force him. I'm not going to physically force my son to go somewhere where he's not safe or doesn't feel safe until somebody else says so, which I feel counseling is going to make that tremendous leap. And or talking to the judge or getting that input, because Christopher is suffering. He's almost 15 years old. We've been going back and forth to court since he was little because of everything Christopher has told me. And everything I've written is what my son tells me. And I believe him 100%, 100%, regardless of what people say that he's embellishing stories to get the parents to believe what they want to believe. That is ridiculous, because he's still refusing to go. With Joe saying that they haven't been any contact, Christopher has a phone. He hasn't even tried to contact his son to even ask him why he doesn't want to go. He still hasn't asked him why. He could have put that effort into talking to his son too, because he has a phone. But regardless, I've never ignored his text messages. All the police says their advice is to go with the parenting plan. And I told them I was doing that as best as I can. 6 p.m. is when Christopher brought that up to me about refusing to go to his dad's. I get a call from LPD by 6:20 because Christopher also says, oh, and I text my dad I wasn't going. I never told him to text his dad. He did that all on his own. 6:20, no, around that time, Joe calls me. I didn't answer because I was in the middle of a discussion with my son trying to figure out why he doesn't want to go, because he had till 8 p.m. to go. So I'm trying to talk to my son. So then he calls the police and says, I'm not responding. So the police call and I explain to the officer, yes, that I didn't answer his phone call because I'm in the middle of talking to my son about why he doesn't want to go to his dad's house. So that shouldn't be put on me because I didn't answer his phone call. I'm trying to get down to the bottom of it. And he just, nobody's listening. I don't know. When he came over after, him, Christopher saying and not going, Joe shows up around 7:55 that evening, demanding Christopher to come out. Christopher sitting on the chair. He would not come out of the house. I'm like, Christopher, you need to get up. Christopher, you need to come talk to your dad. It took my husband telling him, Christopher, you need to get up. Go talk to your dad. He got up, went to the door, did want Christopher to read that, or Joseph to read that letter that he did write. He did admit to the police that he only read the first sentence or two and nothing was slandering or anything about anybody. He didn't even get to read the letter. And with my mother, who's, yes, been 3 years since she was, 3 years ago, Joe and Mariah brought my mother up in our custody case for some weird reason, because my son and my mom are inseparable, inseparable. My thought is they brought my mom up into my court case because They didn't have anything to go against me. Long story short, Judge Basher ordered for her not to see my son in person. They can still contact, FaceTime, and talk on the phone until she does what she was supposed to do, which I did submit the hair follicle tests and stuff too. I'm hoping to address that at this court date as well. My mother has always been the person who serves for me. That has nothing to do with my malicious intent, because I don't have anybody else willing to go over there because of how they are. And my mom's the only one willing to do it, then I need to serve. And I'm not going to pay $40 for a sheriff to do it because that's ridiculous. My mom banging on their door 5-10 minutes at a time, that's because you're not answering and she's trying to serve you papers. Long story short, everybody is trying to pinpoint all this on me when I hope people open their eyes and realize my son is in not a very good place. He's very sad. He's depressed. He wants people to listen. He's tired of nobody hearing his story.
All right, thank you, Ms. Fike. I appreciate your input. What I'd like to do now, I want to hear from each party on the motion to modify and the motion for adequate cause that has been brought by Ms. Fike. So Ms. Fike, if you want to address your motion, then I'll hear from Mr. Sorensen, and then I'll give you a ruling on both motions. Ms. Fike?
Yes. My order on adequate cause. Let me find my paper. Has, with my son refusing visitation at his father's home, he's tired of nobody listening. He's scared. He uses the word scared. He doesn't want to go to his father's house. I feel like either limited time or supervised visitation needs to happen until a counselor or somebody can actually open up their mind to listen to an actual 14-year-old. I don't know.
Okay, any additional input other than the pleadings and then those comments that you made there?
No, I mean, I'm sure there is. I'm just, there's a lot. I'm drawing a blank and I apologize.
Okay, it's okay. I read your pleadings and I read Mr. Sorensen's
you.
pleadings. So, Mr. Sorensen, I'll hear from you on the motion for adequate cause and modification of the parenting plan.
Well, as right now, I am in the middle of trying to seek counsel for that. I have a meeting on the 15th. Is the soonest that I could get in to talk to counseling about, or to an attorney about if I need to acquire an attorney for that or not.
Yeah, the motion is properly noted for today, and we're hearing the motion today.
Okay. And then can I go back as far as the counseling that I have set up for him on the 26th?
You can touch on that briefly. Go ahead.
I did not give an intake. The appointment for the 26th is for Christopher to go there to do the intake. I didn't answer any questions or anything. I just simply made the appointment for him to go to there to do the intake. So I just want to make that clear that I didn't answer any questions for Christopher or spoke for Christopher. I just simply made the appointment for him to go and to do the intake himself.
Thanks. Okay, do you want to address the motion for adequate cause and modification?
As far as the adequate causes, I feel that this has kind of been an ongoing thing, as I stated in my statement for the contempt. I mean, I've hired a GAL. The GAL has you said you've read through it, so you've read what her report. We're kind of running into that same thing to where Christopher is playing both sides.
So just so you're aware, Mr. Sorensen, I did not read all 222 filed documents in the file. I read all applicable and relevant motions related to the two motions today. So I see that Ms. Larson filed the guardian ad litem report back in January of 2020. I have not reviewed that.
Okay. She had found what her findings were is everything that I'm stating, that Christopher was found to have to choose sides over at his mother's house, and that he is involved in adult conversations and in these court matters. I feel like, I mean, that's all we have is Christopher's best interest. And right now, I have a lot of rules. I mean, I hold him accountable, and he gets away with a lot more at his mother's. So it's kind of Disneyland versus somebody that has, I have rules.
Okay. All right. Thank you. Okay. So at the outset, it's, Christopher is, he's at a really interesting age. He's 14 and sounds like he's almost 15 years old. And it's a tough place to be as a teenager. Number one, it's a tough place to be for a teenager caught between two homes with different parenting styles, it sounds like, and different approaches to parenting. So here the motion is brought by Mr. Sorensen for a motion for contempt related to the June 25th visitation. The parenting plan calls for a 50-50 plan, roughly. Well, it's a 50-50 plan with exchanges on Fridays. It sounds like the parties have kind of modified that a little bit to make it easier on them for whatever reason. So that's the motion. The indication is that Mr. Sorensen indicates that there was a refusal of Christopher to come to the visit. There's an indication by Ms. Fike that Christopher has some thoughts about what's happening, what he wants and what he doesn't want. And there's an indication that there was not a clear push or edict, if you will, or direction from Ms. Fike that he needed to go with his dad. Her focus tended to be more on listening to what he had to say. Dad's focusing to be more on there's a parenting plan and we need to follow that. So these situations are challenging because both parties have a lot to say. And I think that was noted by the variety of pleadings that were filed by the parties. And there's a lot of information that needs to be heard. So the issue is that there's a parenting plan. The parenting plan says it's a 50-50 plan. Life is not static. Children change, parents change, and the court system is kind of slow to change. We're not the most nimble of organizations. And so when there's a change, there's a feeling of immediacy. We need to make a change quickly. Things may have been brewing for some time with Christopher, may have been thinking about some things for a long time, but it kind of came to head on this June 25th date. The difficult part is accommodating that and accommodating the parenting plan. There's kind of a natural tension there. So what needs to happen is that there's a court order. The court order controls. The parties have been unable to come to an agreement themselves, and so they've turned it over to a third party, the court, to resolve and guide the issue. So the court said those parenting plan needs to be followed, and the parents are to make sure that it happens. And 15-year-olds, certainly you can't pick up a 15-year-old or 14-year-old and pick them up and put them in a car. Not going to happen and would be inadvisable. There's other ways to persuade and encourage. And so I will make a finding of contempt. I think there was a clear indication, whether it was stated explicitly, I think it was the implicit message was clear. I'm not forcing you. You don't have to go. I don't think those words were specifically said, but I think the message came across clearly to Christopher that he did not need to go. And it was more important that his father engage with him, listen to him. And the parenting plan indicates that when I looked at that earlier today under paragraph 14, it says the following. I think this is important to note. Where it states, each parent agrees to encourage the child to directly discuss with the parent in question any grievance they may have with that parent. I think that was appropriate. Ms. Fike indicated that Christopher had written a letter and he had wanted to share that with his dad, and it sounded like she encouraged Mr. Sorensen to speak to his son about that issue. It also indicates it's the intent of both parties to encourage a direct child-parent bond of communication. So that's there. So what I'm going to do, I'm going to impose a $100 civil penalty that contempt can be purged by following the parenting plan for 6 months or until there's a change in visitation. So I also think, and both parties recognize this, that Christopher needs some support through counseling. Sounds like both parties are cognizant of that and working towards that end. That's encouraging and good. And both parents can provide input to the counselor for the benefit of the child. So there's 2 counselors. I don't know if I need to rule on which counselor is gonna go, who Christopher is going to attend with. A lot of counselors, it's a personality fit, and sometimes it's you meet with one counselor and it's just not a good fit. So I'm going to leave it to the parties to figure out which counselor, he goes to, but he needs to be seen by a counselor. He needs to have that outlet. I'm also going to order this because I think both parents here have a lot of information to share, and there's a lot bottled up that's just needs to come out. So I think I'm going to require both Mr. Sorensen and Ms. Fike to engage themselves with the counselor for at least 3 sessions to discuss how your actions contribute to the situation. It's going to be a self-focus, self-reflective to better determine how you are contributing to the issue. I'm also going to require, I'm going to appoint a guardian ad litem. So the guardian ad litem can interview and speak with Christopher so his voice can be heard. And then both parents can have their opportunity to be heard also. That guardian ad litem's duty is simply that, to address the issue of a 14, almost 15-year-old boy as far as residential schedule. That's the sole focus. And to make clear that Christopher is not allowed to make the decision of where he goes. He's required to go as the parenting plan requires, and he should be disavowed of that false notion. It's gonna be a lot slower than a 14-year-old child wants things to happen. But we're going to get input from the guardian ad litem. He'll have an output with the counselor. Both parents will have opportunity to do some self-reflection under the guidance of a counselor to see how they're contributing to the issue, because it doesn't happen in a vacuum. Sometimes it's hard to see that without the professional help. So that's the contempt motion. As far as the motion to modify and the motion for adequate cause, I'm making a finding that there is not adequate cause at this point. So I'm denying the motion for adequate cause and denying the motion to modify the parenting plan. So with that said, I'll ask the parties if you have any questions or clarifications of the court's ruling.
As far as my lost time of the 2 weeks that I missed out on, is that just chalk that up as?
Yeah, good question. I thought about that, and I think under the current circumstances, I'm going to let that ride. I'm not going to order makeup time. I am requiring that the parenting plan pick up this Friday at the Friday or whatever. If it sounds like it was Sunday, maybe what the parties had kind of agreed on. But the parenting plan, if the parties can't agree, it'll be Friday at 5 p.m. That's when the exchange needs to occur. If the parties had been doing a different schedule, you're free to do that, but it has to happen this weekend. The exchange needs to occur.
Okay.
Ms. Fike, do you have any questions or points of clarification?
No, not at this time. Well, actually, when will we hear about the guardian ad litem?
Yeah, thanks. So I'm going to ask the guardian ad litem to do an accelerated review with a review in 30 days is my hope. And for guardian ad litem, that's a pretty quick turnaround time, and we'll have a hearing in roughly 30 days. And so let's go ahead and look at the calendar now and see what we have. Yep. Yeah, thank you. Let me take a look at the calendar. 1, 2, 3. Let me ask the parties, as far as your schedule on August 24th, how do your schedules look on August 24th? That's a Thursday at 9 a.m.
I'm recovering from back surgery, so I'm pretty free.
Okay, Ms. Fike?
That's fine with me as well.
Okay, we'll set it for that day. And then the guardian ad litem, it was mentioned Ms. Larson, and do the parties know if she was formally discharged from the case?
He told
No.
us that this was her last case and that she was retiring, so I have no idea.
She was never discharged, but I don't believe that she is doing child item work still. But
Right.
she is still technically, I think, the last when I reached out to her, she said that she is still on the case.
Yeah, I don't think she's been formally discharged, and I think she's no longer on the guardian ad litem, what we call the registry. So she's not accepting new cases. So Madam Clerk here has a list of the next 3 available guardian ad litems. Each party has the opportunity to strike or get rid of one of the guardian ad litem that have been presented. So I'll give you that list, and then each of you can tell me what your thoughts are as far as what your preferences are as far as striking. Oh, the review, 24th of August.
Next 3 names are Twyla Corey,
Okay, Twyla Corey,
Keith Lawrence,
Keith Lawrence,
and Heather Kale.
and Heather last name,
Kale is Kahl.
and Heather Kale. So those are the 3 proposed. So with Ms. Fike, you're the petitioner. Do you want to strike any one of those 3?
I mean, no, maybe the second one.
Keith Lawrence?
Yeah.
Okay, we'll strike him. And then Mr. Sorensen, any of the remaining 2, Twyla Corey or Heather Call?
I don't know any of these, so no, not really.
Yeah, it's kind of operating in a vacuum. It's difficult. So generally, it's a hierarchical order in which they're listed. So Twyla Corey is first, and then Mr. Lawrence was stricken, then Ms. Call was listed. So I'll appoint Twyla Corey as the guardian ad litem. She will be reaching out to the parties, and it's important that the parties respond to her promptly. I think it's that there's a brief packet that she'll have you fill out. But the sooner you can get in touch with her, the better, so we can move this along. And then as far as the payment, let me ask, was Ms. Corey, was she paid by the court, or was she paid by the parties?
Londa, I think I had to pay, and
We
then
each paid half.
Each paid half. Okay.
but I believe that hers was waived.
No, it was not,
Okay.
but regardless.
Okay. So what I'll do, it'll be a 50-50 split as far as the payment. And then, so she'll get that order. She'll be in contact with both parties, and you'll have opportunity to chime in, and Christopher will have opportunity to chime in. And I will draft up an order memorializing today's rulings on the motions, and get that out to the parties. Do you both have access to Odyssey?
Yeah.
I think so, yeah.
Okay, that's where you can access the case file and look at all the pleadings that have been filed. So I'll file it there, and the parties are welcome to look in there and take a look of the order.
And can you spell Twyla's name first and
Yeah.
last, please?
Yeah. Yeah, Twyla is Twylla, and Corey last name is Corrie.
Perfect, thank you.
Let me check with the parties before we end today's session. Mr. Sorensen, do you have any final items?
I don't believe so, Your Honor.
Okay, Ms. Fike, any final items?
No.
Okay. All right, I appreciate both parties' time and input, and that will conclude today's hearing, and then we'll see everybody on August 24th at 9 a.m. for the guardian ad litem report related to a residential schedule. Okay, all right, thank you.
Thank you.
And we're back on the record, Your Honor.
Fabulous.
And Your Honor, this is Miss Lockridge here. This is case Y180522139, set for a review here today following a booking on a warrant.
And what are the allegations?
Defendant failed to serve 30 days of jail as previously imposed by this court. There are subsequent potential law-abiding behavior issues.
Are we dealing with those today or setting another hearing to deal with that?
Well, I'm sorry, the city's request, given the age of the case and lack of other affirmative conditions, So we don't necessarily need to address the new law-abiding behavior issues. So he's just asking that the court reimpose a 30 days as jail time, defendant's 8 days credit for time served, and no objection to file closing upon defendant's completion of that jail time.
Mr. Boltinghouse?
Your Honor, I believe the court issued its former commitment. I don't believe that there's a basis for reconsideration. I would be asking the court to consider, however, that Ms. Lockridge be allowed to attempt to set that commitment up. I understand, given her failure to appear, that is a lot to ask. However, Ms. Lockridge did want me to indicate to the court at the time of her former commitment, her mother did unfortunately die. And she did ultimately go through a relapse event, causing her to basically lose track of where everything was. She went through a very tumultuous period of her life, and her dad is presently in the ICU, having lost his sight. She is a caregiver for an animal at which and does have housing with wraparound services. She asked me to bring this information to the court's attention in an attempt to give her another opportunity to be able to set that commitment up so that way she does not lose that she presently has. She acknowledges, certainly given her failure to appear at the last date, that is a lot task of this court, but nonetheless wanted to ask regardless, knowing where the posture was. We thank the court for its consideration. Thank you.
How much credit for time served, Ms. Chenweller?
8 days.
Okay, that's what I thought I heard, but then I couldn't remember, because the last one was also 8, and then I was conflating. Ms. Lockridge, will you lose your housing if you serve an addition? At this point, it would be 12 days.
I think so. Like through Plymouth Housing, they have a long waiting list, and a lot of people are waiting to get on it. So we have obligations that we have to, fulfill. And I think I might, it'll set me backwards. I want to. I've accomplished a lot,
Right, but you also are you were ordered to serve this time a while ago, and you didn't do it.
Yeah, my mother died, and I didn't even, the covert happened, and I had so much going on, I didn't think about it. I also have 3 children, and when my mom died, my 10-year-old is like with my cousin who is missing, and I don't even know how to get in touch with my daughter, and I just got a lot going on. I just lost track. I apologize for that. I just lost track of everything that was going on. So much was going on. I had a lot of trauma issues, and I had lost a brother also. My mother died, my brother died, my dad's in ICU, and I got a daughter in limbo, and I got 2 kids in Atlanta. I just lost track. I just got a lot going on. But I got help. I got wraparound services. My counselors will bring me. I got a sponsor that I hold on tight to. I go to Cherry Hall, go to DOA and University Place. I went to Clean and Free, and so I've been trying to get, clean and get my sobriety back, and so I can take care of my family.
How long have you been sober now?
Not long. I'm not gonna say it's been long, but it's been almost 2 weeks, and it took me a long time to get that 2 weeks, because when my mom died, I just wanted to take her place, because when she died, I wasn't clean. So she wanted to see me clean, so I got clean. I don't know. I just, and I just stopped loving myself for a minute, and I'm starting to get that back again, to where my life matters, and like things are important, and I got a schedule board that I put my schedule on, and I put affirmations up, and wake up and say positive affirmations, and I'm getting myself back together, and I just feel like I can just take care of things better. And
Ms. Lockridge, I'm really proud of the steps that you've taken. It sounds like you're really, really trying to turn things around, and I applaud you for that. I'm wrestling with the fact that I think it may be better to get this behind you rather than having it be one more thing that's hanging over your head. And
I'm sorry, Your Honor, just for the record, the city does have to object. I understand defendant has best intentions, given all these factors, the high risk, he's not going to be able to comply with another commitment. She does have pending charges out of Renton, Seattle, Tukwila.
We got those squashed today.
Charge
We already got those
was
squashed today.
recently of July
those squashed
18,
today.
2003, so she's picking up new charges.
No, we got those
Ms.
squashed
Timmo,
today.
I don't think you knew where I was going. Or at least not yet. I think it's best that you serve this commitment now and get it over with, because then you
But
can.
I don't want to lose my housing.
I wish, if everybody would please let me finish
Okay.
talking.
I'm sorry.
What I want to do is set this over till tomorrow. I want information from Pioneer on whether you will lose that housing or not. Plymouth, sorry.
I don't want to set this over till tomorrow. I want this to be done now.
Then I'm gonna.
So do you want me to do my commitment? I just want it over with. I'm tired of coming. I'm just tired. It's just, I'm dealing with my mom in my mind, and it's too much for me. Just finish it.
Okay.
So 30 days is 14 days on 30?
On 30 days, you'll serve 20, but you have 8 days credit for time served, so you'll only serve 12. There are 12 more days.
No, I can't do that.
So ma'am, I'm trying to give you a way around this, but you don't want to take it. I said we can set this over till tomorrow. I would like information on whether you will lose your housing or not. That would be very meaningful to me.
I'm telling you I will. I'm telling you it's Plymouth housing. You should know
And
that
I
all those
don't
people
know
on the
that.
streets-
Okay, I'm imposing the jail time. You're not giving me an option.
I'm sorry, I'm trying to tell you, all those people that are waiting on the streets, that's what they're waiting for, that housing. Through Reach and the LEAD program, they're waiting for that particular housing. All those homeless people out there they're reaching, they're waiting for those people to put them in housing. Can we drop it down to 20 or something? I've got a lot of obligations.
You've had this, this was imposed 3 years ago.
Do you know that we've had
my predecessor who imposed it?
But you know, we have COVID. We weren't even going to court with COVID was.
We did have court during COVID.
Yeah, that had a lot to do with it though.
Okay, I'm imposing the jail time. And the case will close upon completion.
Can we drop down the jail time just a couple of days or something? I just don't want to risk losing my housing. I don't want to be set back. I want to get my kids back. I want to get my life back, please.
If you receive information that you will lose your housing, if I have some documentation to that effect, I would reconsider.
I don't know. I don't know who to call. Like I haven't called anybody.
Okay. This hearing's over, ma'am.
Do you have a counselor I can talk to that can help me call my housing?
Ma'am, as I indicated, Pierre Kent is in the jail. If you talk to programs, they have the card. They are free to call from SCORE. So if you
can I
ask
say one thing, please? Can I please just say one thing? I know, I'm telling you, I will. I'm telling you, 12 more days in here, I will. And I have another obligation. Seattle Muni is holding me. And I have the third, I have another court date through Auburn. I have a court date on Auburn on the 3rd in here. And after that, I have an obligation to Seattle Muni. So I'm asking you, please.
And I've made my decision. If there's more information available, I will reconsider.
But I'm telling you.
I need.
Why can't you reconsider? It's been 4 years.
I need no, that works against you and would make me, if your situation were different, I would likely impose more jail.
Like what? What do you mean?
Ms. Lockridge, we're done. Can you please let the guard know you're done?
So what does that mean?
Ms. Lockridge, this hearing is over.
No, I just want to know how long do I have to do in here?
12 days.
12 days on 30, you do 12?
No, on 30, you do 20, but you have 8 days credit for time served. So 8 of it has already been served. That leaves 12 days.
Can you drop it down to 8 more?
No, thank you.
What, can you speak for me, attorney? I've
I
done a
did-
lot more than a lot of these people in here joking around, playing around, acting like it's a joke with their life. I don't understand that.
Madam Clerk, can you please
understand
call
that.
SCORE and let the guards know this hearing's over? Thank you.
Okay, thank you. So what date am I out on here?
12 days
12
from
days.
now.
So that's what day?
I don't know.
Can you guys please tell me,
Yeah, 1 second.
just so I could call my housing and let them know? Or does anybody have any?
Thursday. Tuesday, August 8th, and as I indicated, Ms. Lockridge, you can speak with Pierre Kent. They will assist you. They are free to call from the jail.
Oh, I think he's coming to visit me tomorrow, Friday.
Perfect. Then
Okay.
talk with them there. They can assist you with that.
Okay, so on the 8th.
Okay,
Yep,
thank
on the
you.
8th.
I can do that.
Thank
I
you,
can
Ms.
do that.
Lockridge.
Yeah, thank you. But you know what? You guys need to give people a chance sometime for real.
Ms. Lockridge,
Like
the
for their
hearing's
life, for
over.
real. It's not cool. People got kids, obligations.
Can we call score? If she's not, there she goes.
I've got Kenneth Harker here. Good afternoon, Mr. Harker.
Good afternoon, Your Honor.
I've got Gary Feynman here. Are you here on the Fannie Mae case?
No, I'm here on the 1-800 Hanson's LLC. Mr. Harker's the defendant.
Oh, yeah, that's the 145 case. So let me get that. Switch from landlord tenant to general civil for a minute. Mr. Feynman, what's your P number?
Good afternoon, Your Honor. P41-655.
We were here earlier on June 26th. Matthew Kuipers was here for the plaintiff at that time. Mr. Harker was here. The parties were put into a breakout room to discuss things. 1-8 Hanson's was hired to install some gutters and do some other work at the defendant's house. The defendant was dissatisfied and contended that they didn't provide the product they said they were going to. And they gave a credit of, I think, $513. The company, 1-800 Hanson's, is now suing for $4,655.00. We did discuss the matter, and we had settlement discussions on June 26th, but the matter was continued for the summary disposition motion here today. And here we are. Has there been any further discussion?
Well, Your Honor, I'm just covering this matter today. You can ask Mr. Harker if there has been.
Yeah, that's always a problem. He discussed it at some length with Mr. Kuipers, and then somebody else comes in from that doesn't have the background. Are you with Velo Law Office, or you're just covering
No, I'm not. I was asked to cover this hearing.
Yeah, the rules changed, and people were supposed to provide an appearance for a temporary assignment, but then when COVID hit, it all just fell apart. So I get people to show up. I have no idea where they're from, what your address is, what your phone number is, whether you're with a firm or not, and you don't have any background information. So, Mr. Harker, what's your position?
Well, Your Honor, I'm going to start from the beginning. Hanson sent a salesman to my home.
Well, listen, I don't have time to start at the beginning, at least not right this minute. They filed a motion for summary disposition. Do you know what that is?
No, not totally. I'm not a lawyer.
No, that's common. Lay people are very unfamiliar with the concept. They did file a brief and pleadings, and so I'll ask Mr. Feynman to speak to that first. He contends that there are material issue of fact. What's your position with that, Mr. Feynman?
There are no material issues of fact, Your Honor. As you know, this was a contract to install gutters. Defendant's answer, he admits entering into the agreement, but he states that it was a different gutter grade system that was installed. I think that's what the essence of the issue, but my understanding is the plaintiff was unable to install the gutter grades requested, so they were substituted for a product of similar quality, and that's per paragraph 1 of the terms and conditions of the agreement. The operative language is contractor or its manufacturer may at its sole option upgrade a product to similar or higher quality. And then as you referenced, Your Honor, the plaintiff did credit the defendant $513 for the substituted product. And also procedurally, defendant listed no affirmative defenses to their answer. Plaintiff mailed defendant requests for admissions on or about April 18th, 2023. Plaintiff has failed to respond to those. I don't need to cite the case law that says that if you don't answer, they're deemed admitted. So for all those reasons, Your Honor, there's no issue of material fact. Plaintiff is entitled to judgment as a matter of law pursuant to MCR 2.116C9 and 2.116C10. And we would request that an order be entered granting the motion.
All right. Now, Mr. Harker, what do you want to tell me?
Okay, the salesman should have known when he came and looked at my place that the gutter grate system couldn't be installed with my steel roof. Never said a word about it. And I was never notified before installation that they were changing from a gutter grate system to a gutter RX system. And the gutter RX system is not an upgrade. The gutter grate system had a 100% clog-free guarantee with it. The gutter RX system had a flat aluminum that sat down inside the gutter, 3/4 of an inch or so. That is not a gutter protection as far as I'm concerned, because all it did is fill up faster. And there's a picture, exhibit 2 in the paperwork that my lawyer sent. And it explains that it's sole option to upgrade. It is not an upgrade in any means. Now, if they had told me they were changing from the gutter grate to the RX system, I would have said, no, I don't want any of your stuff. And I told them to come get it because I didn't want it. And they refused to come get it. So I offered them what I thought was a fair price, because the outfit that put my my gutter protection on, a good gutter protection, they would have installed me gutters for in the neighborhood of $1,200. So I think I'm being way overcharged for their gutters.
Well, that's not a defense. We talked about that last time.
Well,
you signed this contract.
I know
and
that.
So if you go out later and find out you could have found the product cheaper. Now, did Hanson's actually install the gutters?
Yeah, they installed them, but they never told me that they were putting
All
up
right, so you believe you don't owe them anything? You just get to keep them and they don't pay anything?
No, I offered them what I thought was a fair price for the gutter.
Well, are you an expert in home construction where you just decide what a fair price for this is?
Well, do they get to just decide what a fair price is? They have
a contract that you signed and initialed in about 25 different places. One eight Hans, 1-800-HANSES didn't just show up one day and decide to go into this business. They've got a contract. He also mentioned something that kind of went over your head. They sent you a request for information and you didn't respond to it. When you don't respond to it, everything in there is assumed to be correct as they allege. So they filed a discovery request and you didn't answer it. So the motion for summary disposition is a motion that says the defendant has not stated a defense and there is no material issue of fact. That's what their contentions are. That's 2.116C9 and C10. Mr. Felt helped you file this original answer, but then things have happened since you filed the answer.
And I didn't understand that part of it.
I'm sorry, go ahead.
I say I didn't understand that part of it.
Well, I know when you're at a disadvantage, they've got a lawyer and you don't. And there's certain court rules that apply to this and you haven't complied with the court rule. And this motion for summary disposition, I deal with this a lot. Regular people don't understand it. In fact, a lot of lawyers don't understand it. But 2.116C9 and C10 are both very common. The most common reasons people seek to enforce a summary disposition motion.
Okay, can I ask something else here?
Yes.
It states right here in the agreement, it says this agreement cannot be changed by any conversations between owner and contractor. Any changes must be in writing.
What clause are you in?
I'm in the same, it's exhibit 2. It's the same
one.
one.
What paragraph?
Paragraph 1.
All right.
And that's where it goes on to say any changes must be in writing and signed by owner and contractor. Contractor or its manufacturer may at its sole option upgrade to a product, which that was not an upgrade. Similar higher quality.
Yeah, the problem is this is cut off. So the copy that I have, it starts on page 1 and goes to page 2, and some of the important language is missing.
See, that's my whole point with this whole thing here is they never let me know they were changing anything. They just came and did it, threw it up, and then said, and then they never told me even after they installed it. I had to get up there with a ladder and find out that they had changed it. Otherwise, they would have charged me the full price.
Well, they gave you a credit, but it says unused materials. So I'm not sure what that is.
Well, they claimed that was a difference in cost between the two. So if it's an upgrade, then why does it cost less than the better one? It's all, there's no upgrade whatsoever to it. And if they had let me know before they installed they were changing it, I would have said, no, I don't want any of it. They never gave me the choice to back out on it. They just went ahead and put up what they wanted to put up. And it's that I got a picture in exhibits here too that shows it was less than a month and it was completely clogged full of junk. That is not 100%. It's exhibit 6. You can see how well it works. I might as well not had anything in the gutter. It might as well just been open, and that's not what I wanted. The whole reason that I ordered the thing from them is because they had the 100% clog-free guarantee. That's the kind of stuff that I wanted. Now they're forcing me to pay their outlandish price on just gutters, and I don't want just gutters.
Your Honor, as you mentioned, improper defendants are subject to the same court rules as everybody else. There was no response to this motion, no response to the request for admissions. He can't just keep this for free. He got the gutters. He signed an agreement. There is a clause that says they can provide a product of similar or higher quality, and he got a $513 credit for that. And there's really no issue here, Your Honor. This motion ought to be granted for all the reasons you stated and for the reasons I stated.
Well, it sounds like he did not get what he wanted, but you're right. We're not in small claims court, Mr. Harker. We're in general civil court, and the rules of procedure and evidence apply. And you didn't comply with either of those. They filed this motion. You didn't make any response. They requested a production of documents or information for admissions, and you didn't respond to that. So those admissions are accepted as true. So I don't have to like this. I don't think you got what you contracted for. I think you paid a very high price for it. I don't think it works. And you can certainly appeal this, but the same rules apply as if you had an attorney. And because of the fail to answer the request for admissions, there is no material issue of fact, and you failed to state a defense. You can review this with Mr. Felt, but I don't have to like this. In fact, I don't like it, but I have to follow the law. I find summary disposition for the plaintiff. Defendants that are unrepresented in general civil cases have been big corporations, often end up on the short end of the stick. There was settlement discussion that went nowhere. You decided to pay them what you thought was fair. I don't know how that was determined. I don't know. They did have lengthy discussion to settle it, which failed. Now I heard this motion. You owe them $4,655, $154.41 in costs, and a $75 statutory attorney fee for a total of $4,484.41.
No, it's $4,884.
4,884. I couldn't see it. The print's so small. 4,88441.
Your Honor, will the court be preparing that order, or would you like?
There is an order here, and I'm signing it.
Okay.
This is not a rousing advertisement for 1-800 Hanson's.
And the court will mail that out to the parties, Your Honor?
Yes. Mr. Harker, I suggest you might want to share that with Mr. Felt. He can watch this proceeding on YouTube if he wishes to, but I find on their behalf, I don't have to like it. All right, that completes this matter.
Thank you, Your Honor.
Thank you, Your Honor.
Hi, everyone. We all know some people make mistakes. Some people's mistakes are worse than others. And some people are just, well. So let me introduce you to Adam Brackett. He's what we call an yeah, one of those. You see, Mr. Brackett was arrested in 2021 for possession of meth, but he failed to appear. So he ended up forfeiting his bond and serving 90 days in jail. He was ultimately sentenced to 2 years of probation in 2022. But by early 2023, he had violated his probation. 10 counts to be exact. That was May 2023, and now we're to his sentencing. And wait till you hear what he's being sentenced on.
This is case number 2112850, People versus Adam Brackett. He is represented by Attorney Prysock. We're here for a probation violation hearing. There's been a recommendation made by the probation department such that if he enters a plea to a non-technical violation, the recommendation is that he be sentenced to jail for up to 11 months, credit for 104 days, and his probation be revoked and terminated as unsuccessful. And Mr. Walburn, do you adopt that recommendation as an offer in this case?
We would, Your Honor.
And Mr. Prysock, is that your understanding of the offer?
Yes, Judge.
And does your client wish to take advantage of that offer, or does he want to have a contested hearing?
Judge, he'll take advantage of the offer.
Is that correct, Mr. Brackett? Yes, it is, sir. Would you raise your right hand, please? You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I do. Put your hand down. So do you understand the allegations here are that you were placed on probation in this court for the 10-year felony offense of possession of methamphetamine, and that your probation began on July 12, 2022? You understand that the charge that you're entering a plea to is that that you violated condition number 1, that you not violated any criminal law of any unit of government, and that on or about December 16, 2022, you gave a controlled substance to a minor. You understand the allegations contained in this is count 10. Yes, sir. Understand that the agreement in this case is that if you enter guilty to that, that you would get sentenced up to 11 months in jail with 104 days credit. You'd be off probation. Yes, sir. Is that your complete understanding of the plea agreement in this case? Yes, sir. Have you had sufficient time to consult with Mr. Prysock about your charges, the right to contest is at a hearing, and this plea agreement? Yes, Your Honor. Subject to the plea agreement, how do you wish to plead? Plead guilty. Understand that if I accept your guilty plea, that you're giving up your right to contest these allegations at a hearing. I understand. You also understand that you are giving up certain rights that you have at that hearing. Yes, Your Honor. We've listed those rights for you on a written advice and right sheet that you signed when you were arraigned, which I think that was July 21st. Did you read that document? Yes, I did, Your Honor. Did you understand it? Yes, I did. And did you sign it back on July 21st? Yes, I did. You also understand that if I accept your guilty plea today, you may be giving up the right to appeal any appealable issues you would have if I went to a contested hearing and I found you guilty. I understand. You understand that you're giving up your right to appeal this conviction and sentence. If you wish to file an appeal, it'd be by application, you have to appeal in the Court of Appeals. I understand, Your Honor. You now give up your right to have a contested hearing and all the rights that you would have at that contested hearing, and do you affirm your guilty plea? Yes, I do, Your Honor. Is it true then that on or about July 12, 2022, that you were placed on probation to this court for the 10-year felony offense of possession of methamphetamine? Yes, Your Honor. Is it also true that a condition of your probation was that you not violate any criminal law of any unit of government? Yes, Your Honor. Did you violate that condition on or about December 16, 2022? Yes, I did. Did you deliver a controlled substance to a minor? What'd you do? Gave it only to my son that was sick. How old was your son? 9 years old. And this was a marijuana chewable that contained THC? Yes, it was, Your Honor. All right. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor. Nor none.
Is the defendant competent to enter this plea?
Yes, Your Honor. Yes, Judge.
Has the court required the court for taking a plea in a probation violation?
I have, Your Honor. Court has.
The court does accept the plea. I do find if you know understanding voluntarily and accurate. There's been an updated report prepared. Do the parties wish to proceed to sentencing today?
We're fine with that, Your Honor. Yes, Judge.
Was the report timely made available to you?
It was, Your Honor. Yes, Judge.
Mr. Price, have you had the opportunity to read the report and discuss it with Mr. Brackett?
I have, Judge.
Do you have any additions, corrections, or challenges?
I do not.
Is there anything that you want to say on his behalf?
Well, the original report, Judge, this is his first felony. I know that they're recommending to terminate his probation and sentence him to about 8 months in jail if you give him a balance of his 11 months within the guidelines. So we're asking the court to sentence within the guidelines and to consider a sentence less than what the maximum is called for.
All right, Mr. Brackett, have you had the opportunity to read the report and discuss it with Mr. Price?
Yes, I have.
Do you have any additions, corrections, or challenges?
No.
Anything that you want to say on your own behalf?
Yes, Your Honor. I would just like to ask the courts to please give me some leniency in this matter as far as doing the remainder of my time. I recently lost my father to lung cancer, and I am trying to take and help out my mom for a period of time. Now I just beg the courts to please I would be willing to do any program, anything in order to please make my jail stay as short as possible. If you would,
When did you lose your father?
the day before Father's Day.
Okay. All right, and Mr. Welborn, any additions, corrections, or challenges?
None, Your Honor.
Anything that you want the court to consider?
We just ask the court to comply with the terms of the plea agreement.
All right, well, Mr. Brackett, you know, you come to the court, the offense that put you on probation, it was your only offense on your record. Well, you had 6 prior misdemeanors, no prior felonies, but you absolutely blew probation.
I did, Your Honor.
You know, you're asking for the court for leniency, and I would say that the court or the probation department was very lenient with you. They tolerated, it's my turn to talk. I asked you if you had anything to say, and you were done. So now it's my turn. You failed to report. You consistently tested positive for methamphetamine, heroin, fentanyl, and marijuana. And they tried all different treatment programs. Salvation Army Turning Point failed to complete. Health West outpatient treatment failed to complete. You did do kind of a detox at Gilmore Community Center. Then you were sent to follow up with New Beginnings, failed to complete. KPEP failed to complete. So your request to go to any programming or counseling falls on completely deaf ears. I mean, you've had more opportunities than most people that come to court in your situation. When you add on top of that, for some way of thinking, you think it's okay to give an 8-year-old controlled substances because they're sick. Now, to me, that is absolutely inexcusable, especially with your history of addiction. To give an 8-year-old addicted to substances, absolutely inexcusable. I wish your sentencing guidelines were higher so I could send you to prison. That's how strongly I feel about how you failed probation, you failed your family, and how you put your child at risk. Understand that? So no, you're not getting any leniency from this court. I'm giving you the most that I can. The court recognizes that your advisory guidelines would suggest a sentence between 0 and 11 months. It's going to be I'm going to exercise my discretion and sentence consistent with the plea agreement, consistent with the advisory guidelines. It's a sentence to the court that you serve 11 months in the Laredo County Jail. I'll give you credit for the 104 days that you've already served. I'm terminating you from probation as being unsuccessful. You still owe $549.60. So you need to pay that to the court within 90 days of your release from jail. So When you get out of jail, you're still gonna have all the addictions that you had before you went in there. Right, the difference is you're gonna have no support from the probation department, nobody to try and set this stuff up for you. So if you're gonna kick it, you're gonna have to do it all on your own. You have the right to make application to appeal your conviction sentence. You cannot afford an attorney. The court appointed attorney will represent you on the appeal. The request for lawyer is to file with court within 42 days. That's all for today.
Thank you, Your Honor.
23 CP 218069, 91 days without indictment, theft by taking felony driving, fleeing, attempting to elude driving, hit and run, reckless driving, driving improper erratic lane change, driving on wrong side of the road. Go ahead. What says the state?
Yes, Your Honor.
Officer's been sworn.
Good afternoon. How are you?
I'm well. How you doing?
Can you tell the court where you're employed at currently?
City of Atlanta Police Department.
And how long have you been there?
3.5 years.
Were you employed there on April 27, 2023?
Yes, ma'am.
Are you post certified?
Yes, ma'am.
Are you familiar with the circumstance, the case that brings you here to court today?
Yes, ma'am.
Can you tell us what happened on April 27, 2023, when you came in contact with a Desmond Mosley?
On the day of April 27, 2023, myself and my partner, we conducted a traffic stop on the blue Kia for a traffic violation. Upon notice of that traffic violation, myself and my partner made contact with the owner of the vehicle. The owner of that vehicle then fled our traffic stop. While canvassing for that vehicle, we noticed that the owner of that vehicle leaving out of a package store parking lot at the intersection of New Jersey Ave or New Jersey Road and Joseph E. Boone Boulevard. That driver noticed us. He then exited the vehicle and fled on foot. I gave chase to that particular driver. As I was chasing that male, Mr. Mosley exited a 4-apartment building, looked at the person that was fleeing, which was the owner of the vehicle, looked at me, and then looked towards the parked vehicle in the middle of the street. As I was detaining that driver, Mr. Mosley, as I was detaining that driver, I heard the door to the vehicle close on the street, and the vehicle then sped off. As I got the owner in the vehicle into my vehicle, I asked him if he had any tracking on the car. He told me to call his wife because his wife had all the information for tracking. I informed his wife. His wife then began to give me updates on tracking, which at that point I was able to advise other officers to be in the area where the car was pinging to. As the officer seen the vehicle at Greenbrier Parkway in 166, he attempted to pull the vehicle over. The vehicle then sped away from the officer, hitting a few vehicles and then fleeing from that stop. As the officer gave chase to the Kia then made an abrupt turn to go left and end up making contact with the officer's vehicle, disabling the patrol vehicle, and then the vehicle began to continue onto Greenbrier Parkway, where the vehicle crashed out into a pole and caught fire. The driver of the vehicle then fled and was caught a short time later. The driver was identified as Mr. Desmond Mosley, where he was taken. Afterwards, he was taken to Grady Hospital to be treated there on scene.
No, sir.
Did you make contact with Desmond Mosley yourself?
At the hospital, yes.
So are you able to identify him?
Stand up if you need to.
Yes.
Can
You can stand up if you need to.
All right, can you stand? Oh, you are standing up. Can you tell the court where he's sitting in relation to you?
Hold on. You need to use your inside voice and whisper. I can hear everything you're saying, and you don't want me to hear everything you're saying. If I can hear it, she can hear it. Okay. Go ahead.
Yes. Can you describe what he's wearing, his facial features, and where he's sitting?
He's sitting the table to the left, has a blue shirt on, gray undershirt, and afro, mini fro.
To your left?
To my left. Yes.
Okay. You're not like the record to reflect that identity has been established.
All right, noted.
Which city did this incident take place in?
Can you repeat?
Which city did this incident take place in?
Atlanta.
Which county is that?
Fulton.
You're not like the record to reflect that venue has been established.
Noted.
So to go back to kind of break down the charges, you took out a warrant against Mr. Mosley for theft by taking. And what was the probable cause for that?
Getting to the Kia K5 that did not belong to him and fleeing the scene.
All right, did he have permission to be inside of the Kia?
No, ma'am.
All right, you took out a warrant also for driving hit and run, duty of driver to stop or return to the scene of accident. Why did you take out a warrant for that against Mr. Mosley?
For hitting and fleeing the scene of one vehicle that he hit to flee from the officer that was behind him on Greenbrier Parkway.
How many vehicles did he hit during this chase?
Total 3.
Right. Did any of the vehicles belong to an officer, a patrolman?
One of them did, yes, ma'am.
All right. You also took out a warrant for driving, fleeing, attempting to elude a police officer. Can you just briefly tell us what's the probable cause for that?
The officer got behind the vehicle at Greenbrier Parkway, initiated his lights and sirens. The vehicle then fled. The officer gave chase to deploy a tracker on the vehicle so they can track where the vehicle would go. And that's the basis of that charge.
And who was the driver during that?
Of the police vehicle?
During the fleeing?
Mr. Mosley.
Was he the driver the entire time during this incident?
Yes, ma'am.
Was anyone else inside the car with him during this incident?
No, ma'am.
Okay, you also you took out a warrant for reckless driving, a misdemeanor. Can you give us the basis for that warrant?
Driving at a high rate of speed. I do not remember the actual speed, but driving above the speed limit, posted speed limit in the area, which is about 35 miles an hour. Also changing lanes erratically.
Okay, and did he do anything else that you was deemed as reckless driving?
Nothing other than that.
Okay. Did he hit patrol? Did he hit cars, strike cars?
Yes, ma'am.
All right, you also took out a warrant for driving improperly, erratic lane change, and I believe you just went over that, but could you elaborate on what the probable cause was for that charge as well?
The first basis for that charge was the initial flee from the officer on Greenbrier Parkway. He exited a lane and then began to drive at a high rate of speed, as well as not maintaining his lane. And then the erratic lane change right before the accident, where he appeared to go to maintain his travel on Greenbrier Parkway. Then suddenly he tried to make a left turn or straight towards Continental Colony Parkway. And that's when he collided with the patrol vehicle. And then he maintained his way towards Greenbrier Parkway.
At any point, did he drive on the wrong side of the road?
Yes, ma'am. After the accident happened with the officer.
All right. Court's indulgence.
Sure.
Why did you go to Grady Hospital who did you go visit in Grady Hospital pertaining to this incident?
Mr. Mosley, he was laying on the hospital bed in the Grady detention area.
And where did you learn, or what did you learn about his injury as far as like the cause of his injuries? Where did they come from?
When I was there, there wasn't a doctor. It was a nurse there, but there wasn't a doctor. But the injuries that I've learned were based off the accident. I'm unsure if any officers used force. I'll have to read through my report to just maybe use any recollection, but I'm not unsure off the top of my head if any officers used any type of force against Mr. Mosley.
Okay. Nothing further, Your Honor.
All right, Cross.
Were you the officer viewing the tracking information on the vehicle?
Yes, sir.
At any moment did the vehicle stop in the tracking?
No.
And you observed the vehicle as it was driving, correct?
There wasn't like a GPS tracker. I was on the phone with the owner as she was en route to the scene, and she was giving me updates every 10 to 20 seconds of where the vehicle was.
How were you able to ascertain the speed of the vehicle?
The dash camera footage of the officer that was behind him. They were driving at a high rate of speed, and it has the posted speed on the vehicle.
And you said there was a collision between the vehicle and a police car?
Yes, sir.
All right. Who was driving the police car?
Officer Adams.
Okay.
Atlanta police officer.
Do you know how the collision occurred?
Yes, sir.
Could you describe the collision?
I stated earlier that both vehicles were traveling, you say south on Greenbrier Parkway. Greenbrier Parkway goes straight south, and then it curves to the right, and the park, there's a road that goes straight that turns into Continental Colony. The vehicle that Mr. Mosley was driving was in the right turning lane to go towards Greenbrier Parkway. Officer Adams was in the lane next to the turning lane. The Kia that Mr. Mosley was driving then made an overt movement to go straight onto Continental Colony, where the both vehicles collided at the intersection of Greenbrier Parkway and Continental Colony.
Are the police officers trained in disabling maneuvers with vehicles?
Yes, sir. Myself and Officer Adams are trained in that, but we didn't attempt to do any pit maneuvers at all.
All right. Does the police cruiser have video of the incident?
Yes, sir.
Is that video available for discovery?
Yes, sir.
All right. Nothing further, Your Honor.
Anything else on direct?
No, Your Honor.
Anything else for this officer?
No, sir. No, ma'am.
All right, stay safe out there.
Yes, sir.
All right, go ahead with argument.
I'm not sure who, I can't remember if you.
I mean, you can go first. You can wait, we can go, I don't care, 6 of 1.
Okay, Your Honor, based off the officer's testimony, the state field has met its burden for death by taking. The officer testified that the defendant, Mr. Mosley, did not have permission to get inside the car and drive off. That he didn't have permission from the owners of the car to drive off in the car. Also with the misdemeanor traffic conditions, we heard plenty testimony about how the defendant fled off at a high rate of speed, crashing into not one, not two, but 3 cars. One of those cars being that of a patrol patrol car. A patrolman was also inside of the car when that crash took place. We heard that the defendant ended up crashing the car itself, and the car basically flames was set fire to the car because of the crash. We heard testimony that he was driving on the wrong side of the road, that he was driving recklessly. So we feel that we have met the proper cause burden for all of the traffic citation as well as the death by taking. And what's particularly interesting about this case is that while an officer was detaining another person, that this defendant took that opportunity to take this car, the other person's car. And then he did so, causing putting the whole community at danger. So I would just end on that the state feels that it has met its burden for all the charges listed.
All right, go ahead, Mr. Showalter. All right, I'll find probable cause on everything. I got 35-5 as a previous bond as 4/29/23. So I'll go ahead and address bond on everything.
Judge, in regards to Mr. Mosley, 7 prior arrests. He currently is on probation, hijacking, armed robbery, firearm, doing pistol under the age, sentence 11/4/19. 4 years confinement, 6 years probation, 17 SC 154676. A prior simple battery, family violence in 2018, and a prior battery, family violence in 2018 out of Clayton. 2 arrests for probation violation, nothing further.
All right, go ahead, Mr. Showalter. Mr. Mosley, please, he's trying to argue for bond. Go ahead. Okay,
I would like to make that.
go ahead.
It's currently at $35,000, and if we can get a lower bond, Your Honor, it would help Mr. Mosley to continue to live his life, get out of jail, and make something of himself.
Right, you need to go to the podium. They can't. He can't. The court reporter can't hear you. That microphone's not working. Sorry.
Your Honor, we would like to try and make a lower bond for a chance for the opportunity for Mr. Mosley to leave incarceration. It'd be one less guy in the jail. It'd be a chance for him to go and live a normal life and make something of himself. Nothing further, Your Honor.
Is he still gonna live in Covington? Where you gonna live?
PAD program, PAD gave probation some type of information to reinstate me.
So you don't have an address yet, is what I'm hearing, right?
So after you release the PAD program.
All right, there you go. All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no further contact with, no driving unless this bond is modified. Stay away from, you can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. 5,000, 5,000, 5,000, 3,000, 100, and 100. 5, 5, 5, 3, 100, and 100. Best of luck to you, sir.
Good morning, Your Honor.
Good morning.
All right, we are here today on a citation that was issued on June 21st of this year on some private property there in Layton Township, County, state of Michigan. These are civil infractions involving a nuisance animal. All right, and so, Mr. Chang, you are here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened, or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I'd like to contest it, Your Honor.
All right. Deputy, if you just want to come up to a table, just so you're near a microphone. So first thing I would do then is to swear you both in. If you could raise your right hands. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do. I do.
All right. Mr. Chang, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why he issued you citations in the first place. But after that, you'll have an opportunity to either ask questions or testify in your own behalf. All right?
Sure.
And with that, Deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Your Honor, I got called by an individual who lives in the neighborhood as Mr. Chang, and he had said that he had multiple pictures and video of his cat defecating in his landscaping and constantly on his property and running around the neighborhood. And he is really particular about his landscaping. So my partner actually had talked to the cat owner on the phone. We had left a note, and I was able to talk to him in person after multiple pictures and videos. I ended up issuing him one citation for promiscuous defecation. And then because it was kept reoccurring, I felt that it would fall under the being a nuisance animal. So I met with Joseph and explained to him the situation. He asked to see a picture of the cat because I told him I had pictures. I put that on my computer. I showed him that, and he had admitted that it was his cat. His cat was sitting next to him, and he said, "I'll pay the fines." That was roughly the synopsis of what happened that day.
All right. Mr. Chang, what is it you'd like to tell us?
Yeah, Your Honor. Yeah, and I acknowledge that I had the conversation with the officer, and unfortunately, when we received the original, the yellow note that I believe had been left in our door, we were actually on vacation. I will say that, and I had communicated to the officer the issue and the reason why this is happening with our neighbor John is his cat goes into heat and he refuses to take the cat, and address the issue with heat. And so there's a neighbor cat that he has right next that also almost identically looks like our cat Tippy, which repeatedly goes around his area as well. And so I think he also recognizes that there are multiple cats. And I think I communicated that to the officer too, that go to him on a regular basis for that within that house during the moment that his cat is in heat, and that cat sits right at the window. And I did try and talk to John to ask him, is there a way to address it, because all the other cats in the neighborhood actually go to his house as well. When I was looking up a nuisance, when the officer gave me the ticket, I said I would pay it, and I was under the assumption that the ticket was about defecation, which I acknowledge, and we've been trying to address that with our cat, right? We had not seen a instance, or had seen a lot of instances, because we've been actually keeping him in the garage until he actually goes to pee and then also to poop. And then we finally let him out because he does not like being kept in all the time. The reason why I'm fighting this is because when I actually looked up and called the circuit court in terms of what was the citation, they said nuisance. And then when I looked up nuisance in the pamphlet that the officer gave me, it was aggressive dog barking and causing issues. And then when I read up at least understanding in nuisance in terms of being able to address or impact his personal enjoyment of his property, I don't think our cat is doing that and falls within that level of criteria from a nuisance standpoint. It is a cat. It does, most of the time it sits in our, outside, but sometimes, when, his cat is in heat, my cat does go, but so does every other cat is what I found out. So I would like to clarify that. The other thing is that, I have a neighbor who would testify as well. And I communicated that to the officer that he's actually trying to capture these cats. He's actually captured my cat and tried to keep my cat from actually leaving his property. So, but again, that's in essence, and I do have a picture of his front lawn that he's saying that is impacting his ability to enjoy his lawn. And it's literally right there. It's a plant. He keeps on communicating because my cat and other cats pee right in front of his lawn, right where his cat is in heat. It keeps his plant from growing, and that's why he gets so upset. So I don't know if you can see that or not, Your Honor. It's hard to.
Well, I can't. There's a number of issues going on here. First of all, when you keep referring to his cat going into heat, is his cat indoor, outdoor, or just inside? And I think I can't tell you because he didn't tell me. So, all right. Here's the problem, though, is cats. Well, first of all, we have little or no idea what it is they're doing all day and all night outside. All right. So here's the problem: is most of the time this is not a problem with cats for two reasons. One is they'll bury their defecation and nobody knows where it is. That's just a natural thing that cats do. But two, just because the cat is small, think of it the other way. Think about it, this is your dog that roams around the neighborhood and then is constantly leaving, larger issues in your neighbor's yard. Your neighbor has a right on their own property to not have to pick up after your cat and or have any, landscaping is important to people at various levels, but you can have someone be finicky about their garden and say, hey, I don't want to deal with this with, cat turds all the time. The other thing too, unfortunately, as far as trapping your cat, if the trap was on his property and he trapped your cat, he's not doing anything wrong yet because it's a trespass. And the problem is we can't explain to your cat, you can go anywhere, you can go to these other neighbors who don't care, but you can't go to this neighbor that cares. So you have a problem here in that. I wouldn't say your problem is you're the only person whose cat roams around at night. You're the only person whose cat uses the world as their litter box. That's every cat. 99% of the time, it's not going to be a problem, but it's actually your neighbor's choice. And if your neighbor is choosing to make it an issue, I would side with them every time in that they have a right to not have your animals going on their property and doing this. That's the problem. So in other words, do I have this issue all the time? No, it's generally a breakdown between neighbors. But the problem is, even if 7 other cats are doing it, that just means that 7 other owners could also get these tickets if we could establish that those particular cats are doing it. The problem with your cat is there's an actual corroboration that we know that your cat is one of the cats doing it. So the promiscuous defecation kind of speaks for itself. I think you understand that citation. The nuisance animal is supposed to be a little more in general. In other words, Is this mostly always dogs? Yes, because they're bigger and they'll dig up a garden or they'll leave more obvious problems. The cat is probably operating under the radar vast majority of times, but you know, once it triggers your neighbors involving law enforcement, as far as what the laws are, yeah, they have every right to have their property, just like your property, you know, not have animals come on it and you know, complicate their landscaping for whatever, however they want to rate that. So the thing is, this is supposed to be a deterrent to you, meaning it sucks to pay fines and costs. And so you'll do something. I think you have an interesting theory going on with, you know, sort of the cat gets let out after it goes to the bathroom, but I really don't know how to correct this problem for you because I don't necessarily see it stopping. Like I said, it's not like we can explain to your cat, don't go in that yard. And if this person continues to have issues and continues to be able to show your cat's one of the problems, if law enforcement's writing this citation, this hearing's gonna play out the same way it is right now, where I would find you responsible as the owner of the cat, that the cat is doing this on the neighbor's lawn and they have a right to not have that happen. I'm not sure about the whole in heat thing. I'm not sure. I mean, I know that's certainly why cats have come around. I'm not sure if because they're hanging out there and then have to go to the bathroom, they're going to the bathroom there. It almost seemed like maybe you're implying they're purposely doing this because that cat's in heat. I can't speak to that. I just don't know enough about cats.
Well,
but I do know your neighbor has a right to not have to pick up cat turds all the time that are coming from not his cat. All right.
Your Honor, I recognize that, and that's why I acknowledged the defecation piece. Does this, and this is the question I would ask, does this rise to the level of at least the definition around nuisance?
Well, you know, that's sort of you ask yourself, would you consider it a nuisance after X amount of times where what you had to do was tend to fecal matter of an animal in your own property that wasn't yours?
So when we received the notification, because we had come back from vacation, I think, and he had been looking for multiple different cats. Yes, I acknowledge the fact that he did capture the cat, the picture of the cat. He's had a camera up for the last 2 years on his property, and that's the first time he's actually captured a picture of my cat. And so, you know, I would say one, and you can, again, you can see the camera that he set up there. I don't know if you can see that or not. And he's also got another camera on the side of the window. And I think he's got another camera on the side of the house. And so that's one of the first pictures that he's ever been able to show. And
that's why you're going to have a little bit of a break here, Mr. Chang. What I'm going to do is find you, because you have 2 citations here, find you responsible on promiscuous defecation, and I'll find it not responsible on nuisance animal, because even though this may be a nuisance to the neighbor, I think this is the first time the officer had to come out, first time I'm hearing it. Now, what will happen is if this continues to happen, then as the same thing is called nuisance, that argument's going to get stronger and stronger. And promiscuous defecation is always an option. They're very similar tickets. I think they cost the same. But the bottom line is, I don't know. I guess I can't tell you to go talk to your neighbor because I don't want to be responsible for that. But I just don't see what the solution to this not happening is if your neighbor is going to keep being bothered by it, especially because you're the cat that he has, let's call it proof of. And if it bothers him, he's gonna keep calling law enforcement. Law enforcement's gonna keep issuing tickets, and you're probably gonna keep coming in here going down in flames on them.
yeah,
But
just for your awareness, Your Honor, because we are trying to take corrective action. Not only have we done that, we also got a shot collar for him in terms of trying to maintain him in our so we are actually trying because we obviously it's not my cat, it's the kid's cat. And so I'm struggling here, Your Honor. And again, I think there's a history with this neighbor. I think I communicated that to the officer of multiple instances where he's brought multiple people in his immediate area to court in regards to them just putting up a pool. So it's an issue that I'm dealing with specifically in terms of a gentleman.
Well, and here's what I'll tell you. I think you're presenting this as well as you can. That's why I think I'm going to give you a break on that nuisance ticket. I will say this: the gentleman doesn't get to say, because I found cat turds, Mr. Chang's, it must be his cat, write him tickets. But he has the technology to provide some sort of corroborative evidence. And you're going to take the hit every time that he can provide that corroborative evidence. But all I can do is encourage you to continue working towards a solution, and hopefully it's the last time we hear about it. I do need to let you know that you do have a right, because you had a contested hearing, to say you don't agree with what I just did. You could appeal this finding. But you would have to do that in writing and within 7 days of today's date. Do you understand your rights on appeal?
Yes, Your Honor. And I think I've already paid and acknowledged the defecation ones. I'm all done there. And then this was the entire nuisance thing. I didn't understand. So I appreciate that. And thank you so much.
All right. I'm going to go ahead and release you. Thank you.
All right. Thank you, Your Honor.
All right, Mr. Garza, can you hear me?
Yeah.
All right, I'm Magistrate Garwood. I'm going to be handling your case today. Before we get too far into your case, 2 bits of housekeeping. First of all, we're doing this hearing by Zoom. If something happens that you can't hear or see me, let me know right away. Otherwise, I will assume our connection's working just fine. Secondly, the courthouse is closed to the public. The public has the right to hear and see what's happening here in the courtroom. So all of our cases are being broadcast live on our YouTube channel. When we are done here today, everything's going to come off of the YouTube channel. Do you understand?
Yes.
Very good. Then we are going to proceed. This is case SPD 23-4042. Mr. Garza, tell me your full and complete name for the record.
Barry Lee Garza.
So yeah, technically it came off their YouTube channel, but not mine, because there was like half a dozen of us watching it. And I really think everybody should see this total piece of human garbage and what he did, and know that evil exists in the world, and this is it. So I'm going to show you the whole story, since they flashed it up there for, 5 whole minutes and then deleted it. Like, that's supposed to be enough for the people to understand the court system.
Thank you. And Mr. Garza, I want to advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority for them to make investigation as to representation. You also have the right to a probable cause conference within 14 days of today and a preliminary examination within 21 days. And you have the right to a trial. Do you understand your rights as I've explained them to you, sir?
Yes.
Thank you. I will have Mr. Bellinger from the Public Defender's Office assist you today, and then I'll sign the order referring you to the local appointing authority upon presentation thereof. With that, we will proceed with appearances by counsel. We will start with the people. Ms. Blanche?
Jessica Blanche, appearing on behalf of the people.
Thank you. Good morning. Mr. Bellinger, you're muted.
Of course I am. Apologies, Your Honor. Assistant Public Defender Jay Bellinger appearing with and on behalf of Mr. Garza, who appears via Zoom from the jail. Your Honor, with regard to the charges, we would waive a formal reading and stand mute at this time.
Of course, they're not going to read the charges into the record, so let me give you the backstory. Or rather, let the Detroit News give you the backstory.
An unbelievable morning and day here in Saline. Now, earlier today, when that call went out to police, it went out as an active shooter at the assisted living home facility behind me. So you can imagine that police response when you hear active shooter in such a vulnerable population. And ironically, police officers in the area, they were doing an active shooting drill at Saline High School. They all came here to this area at Woodland and Maple in Saline, quickly realizing the actual shooting scene was this parking lot, a UAW hall right across the street from the assisted living facility. And sadly, a 40-year-old woman, an employee of that facility, had come out for a smoke break, walked over here with a friend when she was ambushed by an ex-boyfriend who she had a personal protection order against.
It's not common for our 911 lines to just keep going off and going off.
Very unusual in sleepy Saline to hear active shooter from 911 dispatchers. Even more alarming, right across the street from the Linden Square assisted living facility.
Thankfully, we were actually doing a training exercise for active shooter over at the Saline High School, which is in Pittsfield Township. So we had a lot of cooperation very quickly.
Police presence like some have never seen in this area raced to the facility and the UAW hall across the street on Woodland Road near Maple. Around 11:30 Thursday morning, a 40-year-old woman who is an employee of the facility apparently walked outside with a friend for a smoke break at the UAW hall.
When she was walking across the street with another male acquaintance, the suspect was waiting and just started opening fire.
She was shot multiple times by the suspect, an ex-boyfriend who she has a personal protection order against. She's in critical condition, and the friend she was with, a 55-year-old man, is stable. The shooter drove off, crashing head-on into this yellow SUV 2 miles from the scene.
I was just inside and I heard the loud crash, and then I heard people shouting.
A good Samaritan stopped the shooter from getting any further, blocking him in with his SUV, and the cops, they were right there.
A bunch of sheriff police from Pittsfield, Saline, the state trooper, they all came rushing down, and they came out with weapons drawn and told me to get in the house.
They made the arrest, recovering the accused shooter's weapon.
I actually saw the police officer tase the man and subdue him, and then wrap him up, tie him up so he couldn't move.
Thank you. Mr. Garza, I'm not going to go through the details of the complaint with you because you've had a chance to review that information with your attorney, and he's indicated that you are going to waive formal reading. He has you standing mute. That means you'll remain silent as to the charges. I will enter a plea of not guilty on your behalf. I will schedule you for your next court date. That will be a probable cause conference. That will be in front of Judge Simpson on August 17th at 9 a.m. or as soon thereafter as your case can be called. That will be by Zoom. We will send you a notice to appear, and you will receive additional information from the public defender's office. Do you understand?
Yes.
Very good. The next thing we'll need to address in this matter is bond. There are two parts to bond. Bond conditions, those are things the court tells you you can and cannot do. If you violate a bond condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own personal recognizance or whether you'd have to post a bond in order to be released. Before I make any decisions regarding bond or bond conditions, I will hear from Ms. Blanche if she wishes to be heard. I will hear from Mr. Bellinger on your behalf. I do have a written request from law enforcement and the prosecutor. Additionally, I did have a chance to hear testimony from the Saline Police Department regarding what allegedly took place on the day in question, August 3rd. All of that information goes into my evaluation. You'll get a copy of your conditions when we are done today. Ms. Blanche, would the people like to be heard?
Yes, Your Honor. This defendant's been charged with 1 count of open murder, 1 count of assault with intent to murder, and 1 count of felony firearm. The female victim in this case had a PPO, which was granted on 7/28, but had not been served on the defendant. He showed up to her work, shot her in the neck, and then shot a male victim who was near her. He got into his car and fled from the scene and police. He purposefully crashed his car into another vehicle, which ended the flee. He made terrible statements on the scene, which showed his intent, like, "I'm not sorry I killed that fucking bitch." Based on the charges, the fact that this defendant is an absolute threat to this community, and the fact that he's a flight risk, we're asking for you to deny the bond. Thank you.
This is absolutely a horrendous case. This poor woman was at work in the parking lot doing nothing, and her psycho ex comes up and shoots her. What is wrong with people?
Well, an update now. We've learned a woman has died after being shot today in Saline. It happened outside the Linden Square assisted living facility. The female victim and a friend were walking across the street to apparently take a smoke break when they were ambushed. The woman was shot several times. Her friend also hit. We're told the suspect is the woman's alleged ex-boyfriend, a man she had a personal protection order against. The shooter drove off and crashed head-on into an SUV before a Good Samaritan blocked his path. Police were then quickly able to get to the scene and take him into custody.
When she was walking across the street with another male acquaintance, the suspect was waiting and just started opening fire. Thankfully, we were actually doing a training exercise for active shooter over at the Saline High School, which is in Pittsfield Township. So we had a lot of cooperation very quickly.
Tonight, the woman's friend, a 55-year-old man, is listed in stable condition.
Thank you. Mr. Bellinger.
Thank you, Your Honor. I have had an opportunity to meet with Mr. Garza. Your Honor, understanding the provisions of 6.106 B1A.
It's probably a little hard to read here, but Rule 6.106 is pretrial release. B1 says the court may deny pretrial release to A defendant charged with I, murder or treason. He's charged with murder. Denied.
I understand that this court has the right to deny a bond in this matter. We would be asking for some sort of monetary bond here so that he may start accruing some sort of credit. I understand that these are life terms with a max. However, if for some reason there are defenses here, we would just ask that he'd be able to start accruing some credit while he is in. So just any sort of monetary amount we would be asking.
I'm sorry, but this beautiful woman needlessly lost her life for no reason, all because that guy is an absolute piece of garbage. So he deserves nothing.
Thank you. Anything further, Ms. Blanche?
No, thank you, Your Honor.
Okay. So, Mr. Garza, I know you had a little bit of time to talk to Mr. Bellinger. I want you to understand and want the record to be clear. Under the Michigan Court Rules, Section 6.106B1, the court may deny pretrial release to a defendant if they are charged with murder or treason, and continues on with various other matters in that court rule. I'll be honest, I'm not particularly concerned whether you're getting credit for your time in jail.
Most of you probably know what they're talking about, but for those of you who don't, when you go to sentencing, you get time knocked off your total sentence for whatever time you sat in jail prior to sentencing. This guy's probably not going to have a trial for months, if not years, depending on how much research and back and forth goes into it. So they're talking about giving him credit for it. The thing that I'm not quite getting is him not getting credit if he doesn't get a bond, which I've totally heard them talk about in courts before, specifically in the Washtenaw County courts, in the district court and Judge Simpson's. I pulled up the Michigan Code of Criminal Procedure 769 Section 11B, and it's credit time served prior to sentence, lack of bond. And it says, whenever a person is hereafter convicted of a crime within the state and has served any time in jail prior to sentencing because of being denied or unable to furnish bond for the offense of which he is convicted, the trial court in imposing sentence shall specifically grant credit against the sentence for such time served in jail prior to sentencing, which is basically saying he gets credit even if he's denied bond. So I'm trying to figure out what superseded that in order to prevent him from getting credit, but I couldn't find it anywhere. So if anybody happens to know that, send it over to me because I'm very interested to know.
I heard the testimony from the police department regarding what allegedly took place on the day in question. Someone has died. Perhaps there's some defense, but quite honestly, at this point with the information presented to me, I can't imagine what that would be. In addition to the loss of life for of Ms. Thomas. There was another individual who could have died as well. And then we have the following then a flea, and then a car crash where another person was injured, and then another attempt to flee. I don't see any reason to do a cash bond over a denial of bond, a large cash bond over a denial of bond. I don't think there's any viable, reasonable cause for me to do that. I just don't find that to be justified in any way. This is a devastating case. So I am going to deny bond outright according to the court rule that I have just cited. And no bond will be set. You will be held until your next court date, which again is your probable cause conference, August 17th at 9 a.m.
Fox News' Jessica Dupnack is live now with the very latest. And what else could have been done in the situation, Jessica? Unfortunately, she was doing everything right. As you said, Taryn, we knew that the victim, Amber Thomas, had a personal protection order against her ex-boyfriend, the accused shooter in all of this. But we learned today that that was granted by a Lenawee County judge just 6 days before the shooting. Now, police have not said much in the way of a motive definitively, but it is very possible that that accused shooter being served with that PPO could have set him off and led to the shooting. A family in mourning at the death of 40-year-old Amber Jo Thomas, murdered across the street from her work in Saline, the Linden Square assisted living facility. Thursday morning, she went to her car with a coworker. That's where police say her ex-boyfriend was waiting with a gun. The 58-year-old man opened fire on her and the coworker. He is okay. Amber died later that day at the hospital. The facility where she worked releasing this statement to us, saying they're deeply saddened by her death and that over the course of her time at Linden Square, Amber Thomas was a dedicated employee. She always put the residents first, and many of her coworkers looked at her as a mentor. It turns out Amber had a personal protection order against her ex, approved by a Lenawee County judge less than a week before the shooting.
This is just a piece of paper. If this person is determined to hurt you, he or she will likely try to do it anyway.
Former Macomb County Circuit Court Judge Carl Marlinga was in charge of granting PPOs during his time on the bench.
Remember, when it's served, a person who is already unhinged, who is already a threat, might go the other way. It might cause a person to go off the deep end.
Unfortunately, he says, it's the only judicial recourse someone like Amber could take, and they're not always granted.
It has to be a credible threat, evidenced by some type of overt act.
A PPO serves as a warning to stay away, but with that can come a false sense of security.
Don't do anything on the assumption that this piece of paper is ultimately going to save you from a very violent person.
So let's break that down a little bit. A PPO or TPO or a dozen other names, a protective order in any acronym that they used for it, isn't going to protect you. I mean, unless the person is, outside your house when they're not supposed to be and you can get them in trouble for that. But actual physical danger, if they're intent on hurting you, they're probably going to do it whether or not you have that piece of paper. So the main purpose it serves is getting them in more trouble when they break it. And the only way to protect yourself is to actually protect yourself with some form of violence, I guess. What other way is there? Unless you go into hiding, which isn't going to do anything because they're not going to be convicted of anything until they actually hurt you or try to hurt you. So what do? You get a gun and they come after you, and you have to be quick enough and know how to use it enough to shoot them, and it has to be justifiable or else you go to jail. So I guess the lesson here is pre-screen for crazy before you hook up with someone. I really don't know how you can survive a situation like that. Maybe a bodyguard? It's really frustrating for women who have psycho exes that are intent on killing them, and they really have no protection. And it's sad. and frustrating and scary as hell.
Just in case, I am still going to set bond conditions. And it's important that you understand your bond conditions and you comply with your bond conditions. Just in case, I am still going to set bond conditions. And it's important that you understand your bond conditions and you comply with your bond conditions. You are, and I appreciate some of these are irrelevant while you're sitting in custody, but I'm going to set them all now in case there's some kind of change in the future. You're not allowed to use alcohol, illegal drugs, or marijuana. You're not allowed to leave the state of Michigan while your case is pending. You're not to purchase or possess any firearms, ammunition, or dangerous weapons. You are not to be with anyone in possession of any firearms, dangerous weapons, or ammunition. You are not to assault, harass, intimidate, beat, molest, wound, or threaten anyone. You are to have no contact with any immediate member of Amber Thomas's family. You are to have no contact with Nancy Thomas. You are to have no contact with Richard Edwards. You are to have no contact with any immediate family members of Richard Edwards. You are not to go to any home, work, school, house of worship of Richard Edwards, Nancy Thomas, or any immediate family members of any of those individuals. And I just want to clarify when we talk about no contact, because you'll likely have the ability to potentially access email, have phone access, potentially be able to see people, have visits while you're in the jail. You cannot direct anyone to be in touch with any of the people I have said you can have no contact with on your behalf. You cannot have access to people by phone, email, telephone, any kind of internet or social media, no writing to anyone. No contact means no contact. And certainly if it's found that you have any contact with any of those individuals, any privileges that you have at the jail, telephone and such, they can certainly be revoked. Again, you're to commit no crimes while your case is pending. All of your conditions, they will exist whether you're in custody or out of custody and remain in full force and effect until changed by the court. Ms. Blanche, anything else we need to address in this matter?
No, thank you, Your Honor.
Mr. Bellinger, anything else we need to address in this matter?
I do not believe so, Your Honor. I'm just checking through my notes real quick, if you don't mind.
That will just make sure. Mr. Garza, do you have any questions for the court?
No, ma'am.
All right.
We have nothing, Your Honor. Thank you.
All right, very good. Upon presentation of the order referring Mr. Garza to the local appointing authority, I will sign that. You may have already sent it. I just don't have it yet. And with that, this case is done. Mr. Garza, you can stand up and go to the door to let the jail staff know that you are done. We'll get your paperwork to you later today. Thank you.
Thank you, Your Honor.
Thank you, Ms. Blanche.
Thank you, Your Honor.
The accused shooter who ambushed his ex-girlfriend in Saline this week faces a judge for the first time. And new details come out in court about what he said to police as they arrested him. Take a look.
Perhaps there's some defense, but quite honestly, at this point with the information presented to me, I can't imagine what that would be.
For the first time, we're seeing the accused shooter who allegedly murdered his ex-girlfriend Amber Jo Thomas this week in Saline. 58-year-old Barry Garza in court Saturday, charged with open murder, assault with intent to murder, and felony firearm.
He showed up to her work, shot her in the neck, and then shot a male victim who was near her. He got in his car and fled from the scene and police. He purposefully crashed his car into another vehicle, which ended the flee.
This was the aftermath of that scene Thursday morning at a UAW Hall parking lot across the street from Amber's work, the Linden Square Assisted Living Facility in Saline. After the shooting, Garza allegedly drove off, purposely crashing his car 2 miles from the scene. Washtenaw County Sheriff's deputies quickly made an arrest.
He made terrible statements on the scene, which showed his intent, like, "I'm not sorry I killed that f***ing
Investigators say Amber was doing everything right to get away from Garza, who has a history of assault and domestic violence convictions.
The female victim in this case had a PPO, which was granted on 7/28, but had not been served on the defendant.
Magistrate Tamara Garwood said Saturday the focus should be on the loss of life, not on if Garza is getting credit for time served, which he apparently asked about in open court.
I don't see any reason to do a cash bond over a denial of bond, a large cash bond. I am going to deny bond outright.
This piece of garbage will be in front of Judge Simpson, probably repeatedly for quite a while, with pretrial conferences and exams and everything else. So I will follow them and bring you updates as they come. Until next time, see you then.
Maida versus Jackson.
Yes, sir. This is Ephraim.
Good morning, Your Honor. Gary, absolutely learning how to unmute his phone. Good morning, sir.
All right. Okay. Where are we on this case? My understanding is the property wasn't certified.
That's correct, sir. And I had the lady from the Pittsfield, right here, Lisa Schmerich, draft a letter, which I forwarded over to your clerk, confirming that the property was never properly registered nor certified to be a rental.
So is he going to pay back the rent this tenant paid him?
Wait, can you hear me?
Mr. Jackson?
Can you hear me?
Yes, sir.
So can you repeat what was said? I'm sorry.
Say that again.
I said, can you repeat what was said? I'm sorry. I didn't hear what was said.
Well, he's indicating that a letter was sent over. I don't have it in front of me, saying that the property's not certified, so it shouldn't have been rented, and that you should be evicted.
Your Honor,
hang on.
I'm sorry.
My response to that is the rent that you paid going to be paid back to you?
You're asking me, sir, not the tenant.
I'm asking you.
Yes, sir. Okay. Well, I did get a copy of what purported to be the lease. It started on October 15th, a year ago. And that was the lease that the defendant referred to, thinking he had a lease for at least through October of this year. At the last hearing, he said he hasn't paid rent since November. So I don't know what he's paid. I don't have a copy of his accounting, but there's no counterclaim requesting any payments. He certainly could bring that if he thinks he's owed some money back for the time that he did pay when it wasn't certified.
So you're asking me, hang on a second. You're asking me to, in effect, give a statutory remedy with some equitable claim that, well, we didn't get it certified, so he's in there. So now we get to terminate his tenancy after taking his money when you shouldn't have been taking his money. Really?
Well, I don't know what money was taken, sir. Again, I've come into this sort of in the 11th.
Any money that he paid, if that property was not certified to be rent, was money that was taken. And your client should know that.
I do not know what was paid, sir. The defendant said he hadn't paid since November. So if he moved in October 15th, he may or may not have paid a half a month's rent. I don't know. He may or may not have paid a deposit. I don't know. Let me look at the lease here. I don't see where it says he paid a deposit, but he might have. Again, there's no counterclaim. If he wanted to bring forth a claim for the monies, I'd be happy to run my client.
I'm not going to give you a judgment on this until he gets his money back.
He'd have to notify me of what he's thinking he gets back.
No, your client took his money on an uncertified property. How does this become his problem?
well, if you request, okay, sir, having listened for a while here, you want to adjourn it out a week? I'll figure out how much money was received from the defendant.
August 4th, 2023. 10 a.m. Thank you. Court calls the case.
Did you say
I'm
August
sorry.
4th?
Yes, August 4th, 10 a.m.
All right, thank you.
Francie Moore saying. Dwendra Maida versus Ephraim Jackson.
Yes, Ephraim is here.
Gary App's unmuted, sir. Hello.
Hello.
Yep. Good morning, Gary App, sir.
All right. Okay, where are we on this case?
Well, when we last spoke, sir, you said I needed to refund whatever monies the defendant had paid when he first moved in. I sent over a certified letter to both the court and to him. His letter includes the check. It was around $1,500. The letter sent to the court showed a copy of my check. I checked with the UPS or the Postal Service this morning. The court received my letter on the August 1st. It included the copy of the check, the copy of the letter showing that the property was not certified, and a copy of the accounting from my client showing the amount of money I was told to refund. So the court signed for it on the 1st. The Postal Service says that one of those brown notices was left with Mr. Jackson's at his PO box, but as of this morning, he hasn't picked it up yet. But I've tendered to him the 1505 or 1510, whatever it was. I've tendered the entire amount back to him as the court directed. And again, this is a termination of tenancy based on the fact the property is not certified, so there was no request for any supplemental complaint.
I would like to say, like, if it is not like a cause to rent out, why is another person being rented? Another person is here, and another person was already here before I started. And what I like to say is, I feel like I'm really being picked on because just in, I think, June or May, he asked me to pay rent. I tried to pay him before, like last the time he came to court. I tried to pay him. He didn't text back. He didn't call. He didn't anything. So what I told him, I said, all right, I'll just wait till we go to court to show that I tried to pay you. So what I'm thinking is, I think he just got a lawyer and came up with something else smart that would make sense, because he knew that he was wrong, because I tried to pay him and he didn't contact me, didn't call back, anything. I tried to. And I don't get why I'm being targeted and it's someone else living here also. They was living here before I came here. So I don't get I really don't get it. I really don't get it at all, why I'm the only one being targeted. I tried to pay him. He didn't call back. He didn't text or anything. And he literally just texted me, I think probably May and June, and asked me and contacted me about the rent. So,
okay, Mr. Jackson, stop for a moment.
Yes, sir.
What do you mean that there's somebody moving in?
No, it was someone already here. His name is Joshua. Before I got here, it's somebody that's already here that's moved in. And it's two people that live here. It's roommates. Just for Joshua, and it's me. Joshua was already here when I got here. So I don't get, how is it not rentable and someone else just moved upstairs? Like, these are condos that people buy and they rent out. So I don't get how is that even possible, even logical, when someone the owner of a condo here just rented out to two people upstairs. And they told me to contact management.
Stop. Counsel, is that correct?
Your Honor, I understand that there are two people living in this unit, separate leases, and apparently the other person has agreed to move out. He's just there until the place vacates. Nothing to do with Mr. Jackson's tenancy. It was a separate lease, and we're simply asking that he be asked to leave.
All right, Mr. Jackson, how long will it take you to, I got the letter saying that it's not certified, so you can't stay there. There's a check for you that I've got to make sure you get and that it clears. How long will it take you to vacate, sir?
another thing is it was first month rent and deposit, and I paid November, so it should be like $1,800. Just be like $1,815.
You paid, no.
First month's rent and deposit was $605, and rent was $605. And
according to the landlord, he paid $300 towards the that next month's rent. So that was, I attached the ledger given to me by my client, sir.
All right, so I have $605 paid security deposit, and then $300 payment, and that's October, and then November's rent of $605, which comes to the $1,510.
Yeah, but I gave him I gave him for deposit $605 for their first month deposit and rent.
Well, I have October, you paid a total of $905, which was a payment of $300 and then $600 security deposit. Right?
No, I paid $600 deposit and $600 for the rent, and then I paid November.
Well, I only have $300 paid that first month for rent.
Okay, I really just want this to be over. I'm tired of this landlord.
All right. So when can you? The check is there. When can you vacate?
I don't have a check though. Where do I pick the check up at? Like something came here. So
I think it's a PO box that he sent it to.
I don't have a PO box.
The address on the pleading, sir, was for Mr. Jackson, was the apartment number 1 at the Packard Road address. That's where I sent the check to.
Okay, that's where he sent it. But did you get that check, sir?
No, they left me an orange ticket that said I had to sign for something, and I never got it.
Okay, then you got to go to the post office.
Okay, will it still be there from that day, or will it be shipped back?
Oh, it should be. It was just a few days ago because the court got theirs. My timestamp is the 2nd, so I'm sure it's still at the post office.
Okay. I would like to ask, when is the other Joshua moving out? Like, when is he moving out? Because if this is no one can live here, I think it's fair that we both have to leave.
Counsel, when is the other tenant moving? When is the other tenant moving out?
I wasn't given a date. I was simply told that when Mr. Jackson was out, the other tenant would move out at essentially the same time, but we didn't know when Mr. Jackson was actually going to be out. So I don't have a date, sir. I'm sorry.
All right. Okay. Here's what we're going to do. I'm adjourning this out 2 weeks. You got to figure out your move out date, Mr. Jackson. Maybe you can ask the guy upstairs or whatever. And you need to pick up the check, get it to the bank or wherever you do that so that it can get cash. Okay?
All right.
So the 18th. So this will be adjourned to August 18th, 2023, 9 a.m. Thank you.
Your Honor, what's the purpose? Is the purpose of the adjournment to make sure the check clears? I guess I didn't follow the reason for the adjournment.
Well, the reason for the adjournment is to try to get a move out time because the whole building won't be empty, and also to make sure he gets the check and that it clears.
Okay. I just want to make sure, because if it's a matter of the check, that's fine, but I don't have a timeline for the other tenant, but I can get one.
Let me grab your file. Yeah. 6841-23, she signed her advice of rights, criminal trespass in the first, criminal trespass in the second. We must have appointed Mr. Crystal.
I think this is the
Oh.
first appearance.
Oh, I'm sorry. Ms. Fisher, sorry, I was jumping ahead of myself there. What I had done earlier, this is Judge Hannafy, what I had done earlier is find probable cause for both criminal trespass in the first degree, maximum punishment, 364 days in jail, $5,000 fine, and criminal trespass in the second degree, maximum punishment, 90 days in jail, and a $1,000 fine. Do you have any idea what a good mailing address would be for you if you got released?
Yes, it's P.O. Box.
Do you have family down there in Cathlamet?
Yeah, I have family all over the state of Washington and Oregon right now.
Okay, but would you be going back to Cathlamet if you got released?
Yes, I would be.
Okay.
I have to go back and forth, I guess.
Okay, so what's your? Okay, can you let me talk?
Hold on,
Ms. Fisher, can you let the judge talk? That would make the day go a little quicker if I could finish a sentence. Do you actually have any income?
Any what?
Income, like a job, like a paycheck?
No, I have a disability, Social Security right now.
Okay, all right. What we're gonna do is we're gonna appoint Clallam Public Defenders to represent you. Now, Mr. Murphy, I think I count 1, 2, 3, 4, 5, 6 warrants. Is that what you count?
Let me unmute.
In Longview, Washington.
No, hang on a second, Ms. Fisher. We're just looking for, yeah, they would be. They'd be Cowlitz District Court, Longview District Court. You bet.
Yeah.
Municipal Court.
Your Honor, I just saw one active one out of Cowlitz districts. I'm assuming the other ones you're mentioning are older.
They could all be this kind of bunched together, but they show up as separate on this thing.
Well, I called Great Law. And
Okay,
Great
so
Law.
Ms. Fisher, we're not going to be able to finish our court day if you keep wanting to have conversations. You just hold your horse.
So to answer the court's question, she did have a number of warrants out of Cowlitz district that issued today, but I think that that's on the, it seems to say it's on the pay or appear calendar. Let me see if those are infractions.
I'll bet you're right. I guess what I'm really getting to is she has an address in Cathlamet.
No, those are criminal. It looks like a number of charges for illegal possession of shopping cart.
Right.
You defecate in public. So yeah, so there's a warrant for the occurrence date of September 2020. So I think she missed court today in Cowlitz. I think all those warrants just issued today.
Okay, so Mr. Murphy, what is we've appointed Mr. Kressel. What's your inclination, Mr. Murphy, on bail amount, if any, conditions of release?
Well, so the number of warrants that she has is concerning, with the caveat, albeit that one of them is because, or only several of them are because she was in custody in the Forks jail.
Yeah.
But I don't see much in the ties to Clallam County. It seems she has more ties to Cowlitz District. I think it's likely if she's just released on a promise to appear that she's not going to show up.
I did.
So I would ask for some bail. I'd ask for $250 cash or $2,500 bond. I think that amount would be sufficient. And I'm comparing that to the warrant amounts that were issued, and it looks like there was one for $500, and then it looks like $4,000, and then one at $1,500. So I think 250 is a little bit lower than what's been issued, but I think that would be sufficient for our purposes.
What about time served?
Mr. Kressel, I'm leaning towards 250. What do you think?
Your Honor, unfortunately, I didn't have a chance to take a look at probable cause. I did print up the DCH. The odd thing was all I saw was one warrant. The other ones were in O status, which I've never seen before, so I'm not sure.
Mr. Kressel, when did you check? When did you check?
Yesterday.
Yeah,
Ms. Fisher, please stop. Ms. Fisher, I'm going to put you in jail for contempt if you don't stop talking. That's my last time. That's my last time I'm gonna say that. You're gonna get yourself 10 days in jail for talking if you don't quit talking. Quit talking. Yes, Mr. Kressel.
Okay. So Mr. Murphy was going to add some information because I checked the warrant status yesterday. And it was all listed. There was one active one for a 2023 cause number for illegal possession of a shopping cart, which is usually related to someone having, not always, but usually related to someone not having stable housing. But there's a whole bunch of warrants in O status, which was kind of odd, and that was as of yesterday.
Right. So, Mr. Kressel, yeah, I was on the same page as you with that warrant that issued on the 21st, but there's the other ones issued today. So that's why you didn't see it today.
I see.
Okay.
What we're gonna do is we're gonna set bail at $250 cash because the probable cause report reads in such a way, this was actually not that far from a burglary in terms of intrusiveness. So there's a little bit of threat to community security here, enough to merit $250 bail. Ms. Fisher, I don't think you won't be able to post $250, will you?
What about time served?
No, we're not. That wasn't my question. Did you hear me say anything about what about time served? I said, can you post $250 cash or not? That's the question. That would be a yes or a no.
I may have $250 on.
Okay. So hang on. We're going to put your court case back on for next Monday, which is August 7th next week?
August 7th.
We're going to put her back on for August 7th at 9:30. If you can post bail, you either have to be back here in Forks in person or appear by Zoom, which you can do by telephone or any kind of smart device like a tablet. So if we're putting you back on for Monday. So if you post, whether you post or not post, you got to be back here Monday at 9:30.
Okay, so what if I can't?
Hey, Miss Fisher, if you're unable to post bail, I will be down to see you sometimes towards the end of the week. But,
so you're going to hold me the whole week?
The next available court date is August 7th. That's the soonest we can set it.
Okay, will I be able to access my bank card?
Hang on.
That's between you and the jail.
Do you have a telephone number, Ms. Fisher?
Yes, but I don't have it on me.
Okay.
It's in my property.
That's okay. Make sure and get it to us before you leave town. We'll see you next Monday. Whether you post bail or not, I don't know, but we'll see you next Monday.
And Mr. Murphy, just to let you know, I was informed by the court administrator, O status means the warrant was ordered but not yet issued. That's why we don't see it very often.
Oh, okay.
Huh, I've been doing this almost 10 years now. I never heard of that.
I was confused by it too.
Never heard of that.
All right, this is a citation. It was issued on June 30th of this year on Patterson Road there, Wayland Township, Allen County, state of Michigan. It's a speeding citation on an actual 50 and a 35. However, it was only written as 1 to 5 over. Ms. Brenner-Rumpf, you're here on this citation for 1 to 5 over speeding to do one of 3 things. First is you could admit responsibility to the citation. 2, admit responsibility, but you'd like to provide explanation to the court as to how or why this happened. Or 3, you wish to contest this citation, in other words, fight the ticket at what we call informal hearing. What were you looking to do?
I believe I'm looking to do the 3rd, I believe.
All right. Then I'm going to go ahead and swear you both in. If you could raise your right hand, same as the deputy. Swear or affirm any testimony you'd give here today would be the truth, the whole truth, and nothing but the truth.
I do.
I do.
It makes a lot more sense for me to start with the officer. He has the burden to establish to me why he issued you a citation in the first place. But after that, you'd have an opportunity to either ask questions or testify on your own behalf. All right?
Thank you, Your Honor.
And with that, Deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation?
Sure. I was conducting moving radar southbound on Patterson. road. The suspect was northbound on Patterson Road in the 35 zone. It was the only vehicle in the operating zone of the radar. I detected 50 and a 35, and my radar was calibrated to an independently calibrated speedometer. I also had audio visual match on the suspect vehicle. And then when I made contact with the suspect, near the defendant, Brooke Romp, she had stated that she was going 40 or 50 in the 35 zone. And then I issued the citation.
All right, and ma'am, what is it you wish to tell me?
All right. On 6/30 of 2023, I received citation number SD 20177 stating I was in violation of MCL 257.628 of the Michigan Motor Vehicle Code. 1 to 5 miles per hour over the posted 35 mile per hour speed limit. The citation indicated I was in violation of the statute while on Patterson Road near 126th Avenue. Section 5 of the above listed statute states a speed limit established under this section shall be determined by an engineering and safety study by the 85th percentile speed of free-flowing traffic under ideal conditions of a section of highway rounded to the nearest multiple of 5 miles per hour. A speed limit established under this act shall not be posted at less than the 50th percentile speed of free-flowing traffic under optimal conditions on the fastest portion of the highway.
Ma'am, I am familiar with the law. You can move forward.
Okay, my apologies. However, this section of roadway in question is not, it has not been, the safety study has not happened. On August 1st.
How did you determine that, ma'am?
I'll continue. On August 1st, 2023 at 15:08 hours, contact was made with John at the Allegan County Road Commission, who advised his title was Traffic and Safety Advisor. He advised this section of roadway in question has not had an engineering and safety study conducted on it, and the speed limit was set in 1993 under a traffic control order. He advised the road was zoned as all right-of-way and not as residential or in any other manner in which would require the speed limit to default to. Under the statute that we are going over, MCL 257.628, Section 2, subsection A states the proposed change of speed limit without the necessity of a speed study consistent with the methods prescribed for establishing speed limits under 627. MCL 257.627, Section 2, subsection H indicates for a 35 mile per hour zone to be established without a speed study, there must be no less than 45 vehicular access points, but no more than 49 vehicular access points within the half mile. The section of roadway in question does not meet or qualify the number of access points for the section of roadway to be 35 miles per hour, as it does not have 45 vehicular access points within the half mile section in question.
How many does it have?
This morning when I drove through, I counted, and it has, in that half mile section, it has 24. That was my count. I'm not the expert on the safety study, but when I counted, it has 24,
Okay.
including.
I'm going to make a
126
long story short here. What you're asking for is formal hearing because you're challenging statute. At informal hearing, you would be challenging speed. You need to, and what I'm going to do is they'll reset this for formal hearing. That involves the prosecutor's office in front of the district court judges. That's who you'd have to make this argument in front of. So I'm not saying you're wrong. I'm just saying you're beyond what we do for informal hearing with this particular vein of challenge. Does that make sense to you?
Yes, sir.
All right. So you will get reset for formal hearing. You'll get new notice out. We just need to make sure, I mean, I'm sure we have good address for you here. Edwin Drive in Wayland.
Yes, that's correct, sir.
All right.
Your Honor.
So,
may I ask another
yes.
question? Okay. If you find Officer Morse in favor, if you find in favor of him, I would just like to ask him if he would be willing to amend the citation to a non-moving violation while keeping the costs and fines the same. I'm willing to pay that. I just would not like the points on my license.
Let me ask you a different question. There is one speeder that you get no points for. It is 1 to 5 over speeder like you have, but instead of not on expressway, it is on unlimited access. In other words, if the speeder you were looking at was 1 to 5 over limited access, you would pay the same fine, but you would get 0 points for it instead of this one, which is 2 points.
Okay.
Is that acceptable? Is that what you mean by a no points?
I would just like to, if he could amend it to a non-moving violation.
Well, I'm not going to ask him to do that. I would ask him to move it to a no point speeder. But if you want a non-moving violation, you'll have to go to formal hearing and see if the prosecutor would accept that.
Okay, so I just want to just make sure that I understand you correctly. So if we ask him to amend it to the limited access, then it would be, then I would pay the same fines. I would just have no points on my license.
Correct.
Okay. I'm willing to. Sorry, go ahead, Deputy Morris.
I'm fine with that. If we want to amend it to a 1 to 5 limited access and do the no points, I'm fine with that. If
I think that's 627C. All right, so just so you understand this, Ms. Brenner-Rump, I'm going to explain this to you because it sounds like you want to know this rather than it just magically happening. It's a little bit of a legal fallacy because now we're going to say you're going 72 miles an hour, but in a 70-mile-an-hour zone, that's what's called limited access, meaning you have to ramp on and off, like 131 or I-196. That's what gets you 0 points and the $100 fine still. So what I'm going to do is now say we're amending to that citation that's saying you're going 72 and a 70 on limited access. We do this quite frequently, but I don't do it at my discretion because I'm judicial branch. But I would always do it at executive branch's discretion, which is the officer. I think the officer's reading in between the lines that this may be more trouble than it's worth to go down this road, and you might be correct, and they have a problem with the whole speed limit on that stretch. That he's willing to do it, you're willing to do it. We would end this now. You would get no points, but you would still be paying the $100 fines and costs.
I'm fine with that.
All right, then that's how we will proceed. You want to give it a few hours though before you call to pay because they need to see that I changed it rather than you paying on the one that you have right now. All right.
So like this afternoon?
Even later this morning is fine because I'm before at about 11 they'd be ready.
Okay. All right.
All right. Thank you.
Thank you.
Okay, that's correct. Mr. Larson, you want to enter a guilty plea to the bond violation? I couldn't hear you.
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Okay, and so the bond violation, sir, is a contempt of court order. The maximum penalty is 93 days in jail and or up to $7,500 in fines. The violation alleges that you, however, violated the terms of your bond by tampering with the GPS tether. You have the right to have a contested hearing on that, sir. You understand that?
Yes, Your Honor.
You have the right to have your attorney represent you at that hearing. You have the right to have the prosecution put forth evidence to establish their burden of whether or not you did tamper with the GPS strap alert. You want to waive your right to have that hearing today?
Yes, Your Honor.
Anybody threatening you to get you to waive your right to a hearing on that? Have there been any promises made to you in exchange for a waiver? Okay. As to the violation that you tampered with your GPS tether, how do you plead, sir? Okay, factual basis.
Thank you, Your Honor. Mr. Larson, do you remember when you were put on bond in this court that you were ordered to have a GPS tether attached to your leg?
Yes, Your Honor. Or yes.
And so on July 24th, at some time that day, did you come to realize that you did not have a tether on anymore?
Yes.
Do you know what happened to the tether?
I was out riding 4-wheelers. I think it got stuck on something on the 4-wheeler cut through the strap on the tether. I wasn't aware that it was even on at the time, but until after.
Right, but when you did realize that you did not have this tether on anymore, did you contact JSG or the court or your attorney?
No, I didn't. I shouldn't. I was up in the UP because my father was dying and I'm his medical power of attorney, and I kind of freaked out and I'm taking full responsibility for it. I should have called. I didn't. I was arrested a few days later up there. I clearly was nowhere around the victim, and I sincerely apologize for my part that I played in it. I should have called and I didn't, and it was very stupid.
Okay. I'm not sure I understood what happened to the tether. You said it fell off?
I think the something on the side of the foot peg on the 4-wheeler, there's a sharp piece that was hanging off of it, and I think it cut through it.
A sharp piece came off and it just cut through on its own?
No, I was out riding and it cut through it most of the way through the tether. And
so you were out riding?
Yes.
Is that what you said? Riding what?
Yes. 4-wheelers.
You were riding a Harley?
ATV?
I can't hear because of the echo. You were riding what?
ATVs, 4-wheelers.
Oh, ATVs, and something from the ATV cut through it?
Yes, ma'am.
Oh, and you were unaware?
I was unaware, yes.
Did you ever see the tether after it fell off?
No, I didn't.
All right, so do you know you don't know how the tether fell off, truly?
No, but that's the only thing I could come up with because I tried to go back and look for it afterwards, but.
Okay, well then it sounds like that could have been a malfunction of the tether, so we'll continue to your hearing, and then we'll require the prosecutor to establish how the tether was dismantled from your leg.
Your Honor, I know that it said that it's a tamper alert that was given. I don't think that there's any dispute that he was ordered to have a tether and he knows that he did not have one.
But he didn't tamper with it, is what the factual basis tells me. It was something that happened outside of his knowledge and or control.
So potentially he could be found not guilty of tampering if we continue this on, and I can prove that.
What he's saying is true, then he didn't tamper with the tether.
Your Honor, then yes, I will be able to proceed because there is evidence that shows that he did not tamper with the tether.
Okay, well then we'll continue to the hearing on the 18th.
Your Honor, is there any, right now he's being remanded, is there any way to reinstate the tether and the and a bond?
We'll reinstate the bond, which was originally a 10,000 cash surety. I remanded him on the tether violation. He'll get a new tether before he could be released, okay? You should probably stay away from ATVs in the meantime, okay?
Yes, ma'am. Thank you, ma'am.
Additional matters for the record?
Nothing from the people, Your Honor.
Nothing for defense. Thank you, Your Honor.
Thank you. You're all set.
I'm Marshall on behalf of the people.
Good morning, Your Honor. Jacob Sartz, Fourth Assistant Public Defender here on behalf of Mr. Waltz. I request permission for Mr. Waltz to remain seated, Your Honor, due to his pretty significant, very serious medical issues.
All right, that's granted. Sir, you are Benjamin David Waltz?
Yes, sir.
All right. This is the time set for a preliminary examination today. Mr. Marshall, how we proceed?
Your Honor, the defendant in this matter is going to plead guilty to an added count 2 brandishing. And I have the MCL and penalty when you're ready.
Brandishing. MCL?
It is 750.234E.
And that's a 90-day?
Correct, and or $100.
Is that a correct statement, Mr. Stark? There's an added count 2 of brandishing of a weapon under 750.42341E. It's a 90-day and or $100.
Correct, Your Honor.
All right. May I inquire of your client of his advice of rights that you've tendered to the court?
Yes, Your Honor. Thank you.
Mr. Waltz, you've signed an advice of rights indicating that you're aware of your trial rights in this matter. There's 12 on this sheet, and Mr. Sartz has gone over them with you, and you've signed them to that effect. Is that correct?
Yes, sir.
All right. I'm just going to go over 3 main ones, and then we'll continue with the plea. You understand that this is a 90-day misdemeanor and or $100, which are the ultimate penalties the court could sentence you to pursuant to brandishing of the weapon. It's an added count 2. You have the right to trial by jury. Do you understand that? You have the right to be presumed innocent, and you have the right to have Mr. Sartz represent you in court and contest any charges or cross-examine any witnesses brought to trial against you. Okay?
Yes.
Oh, right. And you have the right to silence you have the right to silence, and you cannot have that silence used against you in trial. Do you understand that?
Yes, sir.
All right. Raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to July 21st of 2023 at the offense location of Ballard Street in the city of Lansing, Ingham County. Were you at the Ballard Street address in the city of Lansing, Ingham County on that date, July 21st, 2023?
Yes, sir.
Okay. And at that time, in count 2, did you have a weapon?
I had an airsoft pistol, yes.
All right. And tell me about that.
It's a spring-loaded airsoft pistol. Takes plastic, BBs, whatever. I was sitting on my front porch, shooting at a cardboard box in our front lawn. And
at some point in time, were you waving that pistol around?
no,
Sure.
Yeah, Your Honor.
Right.
Mr. Sartz.
Yeah. Right, we gotta do the factual
Yeah,
basis
to-
of quotation
yes,
in order to
yes.
I'm aware of that, Bob, thank you.
All right. So you'll do the factual basis as to count 1, which is, so did at some point in time, did you point the airsoft pistol at somebody?
No, but I did hold it up in view for some. Your Honor, may I have a brief moment?
Sure, Mr. Sartz.
Yes. My apologies, Your Honor.
No worries. Did you want to continue on with the plea or?
Yes, Your Honor.
All right. Mr. Waltz, at some point in time, did you point the airsoft gun at Miss Wood?
I made a comment as to having a gun and showed it to her.
And you showed her the gun?
Yes.
Okay. And I think what comment did you make?
It was, what kind of moron would be talking shit to somebody who's holding a gun?
Who's holding a gun? Okay.
Yes.
I find that as count 1 felonious assault, an adequate factual basis. So I can take that in place of the brandishing of a weapon to count 2. Any questions concerning that, Mr. Marshall?
No, Your Honor.
Mr. Sartz.
Thank you, Your Honor. And just briefly, Mr. Waltz, you can understand why your neighbor would be concerned about
you displaying something and then you informing your neighbor that it appears to be a gun. Absolutely. And you can understand why she might be in fear that it might be a real gun, or that you might be able to potentially use it and shoot her or something. Correct? Absolutely. All right. Thank you.
Thank you. And your admission today is it was an airsoft gun that you pointed.
Yes, sir.
All right. I find that factual basis to be knowing, voluntarily, and accurately made. I would take it as to count 2, brandishing of a weapon, the 90-day misdemeanor. So I'm going to refer to probation at this point. And what they'll do is they'll prepare a report for me, and then at sentencing, on the date of sentencing, we'll go over and see what options we have available to us. Okay. I'll have a sentencing date. So the probation's on the 5th floor. Make sure you stop by them on the way down and set up a meeting to answer any questions they have for the report they're going to prepare. Okay.
Okay.
Sentencing date of
October 6th at 8:30.
October 6th at 8:30. And you'll get a notice to that effect on the October 6th at 8:30. That's the date of sentencing on this matter. All right, sir?
Yes, sir.
Anything else for the record in docket 23-02246, Mr. Marshall?
No, Your Honor.
Mr. Sartz?
Thank you, Your Honor. May I just be heard about the no contact order?
Absolutely.
Thank you. Your Honor, the backstory here is that this was basically a dispute between a couple of neighbors. It escalated. Mr. Waltz has pled guilty this morning to a brandishing charge, which is a 90-day misdemeanor with a $100 fine. Respectfully, Your Honor, Mr. Waltz has a urgent situation that relates to the no contact order. He requests permission at this point to return back to his home. He just lost his temporary housing early this morning, Your Honor. He is currently homeless. He has a series of very serious medical issues, including really bad injuries to his ankle. He needs at this point to be able to get back home and convalesce. His mother also is elderly, so he provides care for his mother. Now, important things to know here, Your Honor, this case has been reduced now to a brandishing, which is only a 90-day misdemeanor, $100 fine potentially. From what the police report reads, the complaining witness here was in the process of moving out anyway. To the best of our knowledge, that process is nearly complete, or the neighbor has largely moved her possessions out. There is enough distance there where Mr. Waltz can stay safely in his home without directly being right next to, or they're neighbors, but there's enough privacy and there's enough distance between the two houses that Mr. Waltz could live in the house without directly interacting with the complaining witness outside of perhaps something incidental. There's been no allegations of any violations, no contact order. Mr. Waltz, Your Honor, has already served 12 days in jail on this already. So before he was able to get out on bond, served about 12 days, correct?
That's technically an unrelated charge. It was for child support.
Okay, but still, you're in custody for 12 days.
Yes.
So, Your Honor, under the circumstances, due to his particular medical issues and the nature of these circumstances, I would request an amendment to the no contact order, perhaps a reduction in the range. And certainly if the complaining witness has any disagreements with it or any concerns, we can address it at sentencing. But there's been no issues so far. And to the best of our knowledge, the complaining witness is moving out, Your Honor.
All right. Thank you. Mr. Marshall, any comment on the modification of the no contact order?
Your Honor, I did have contact with the victim. She did tell me she was moving out of the home. I didn't get an exact date. I would leave this to the discretion of the court, given the plea to a misdemeanor.
Thank you. I'm going to grant the request for modification of the court order. I'm going to continue with the no contact order to Esther Wooden. This appears to be some neighborhood dispute on some level, or the like behind. So continue no contact with Miss Wooden. What's going to happen is if you have any contact with Miss Wooden, she's going to end up reporting it to the police, and then they're going to come and they're going to indicate you violated the no contact order. What I'm doing is modifying it so you can go home. Okay. So I've taken away the 2,000 feet. All right. So you can go home. You can start whatever convalescence is necessary and make sure, but you're to continue to have no contact with Miss Wooden. That may not be an issue because she'd be moved out, but regardless, and no contact is direct or indirect.
So you can't tell somebody to contact her or come to contact with her, or have a neighbor contact her, direct or indirect. But with that understanding, and you've pled to a misdemeanor today, I will modify that I'm just going to take out the 2,000 feet. Just continued no contact with Esperwood. Okay.
Understood.
All right. Anything else for the record in 23-02246, Mr. Marshall?
No, Your Honor.
Mr. Sarks.
Nothing further, Your Honor.
All right. Thank you. You're all set. We will see you, sir, on October 6th. Okay.
Thank you, sir.
23-02140. That's people of the state of Michigan versus Charles Trainer. Will the parties please introduce themselves for the record?
Marshall, on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Mr. Trainer. He is standing to my right.
And sir, you are Charles Trainer?
Yes, sir.
All right. This is the time set for preliminary examination. It's my understanding that we are going to be running the preliminary examination today. Are there any pretrial matters to preliminary matters to come to the court's attention before we get started today, Mr. Marshall?
I don't believe so, Your Honor.
Mr. Abbott?
One for the defense.
All right. There's a motion for sequestration order, obviously, so any potential witnesses shouldn't be in the courtroom to hear another witness testify. I'll leave it to counsel to bring that to my attention if anybody's in here that should not be in here, okay?
It's just one officer involved, Your Honor.
All right.
So
Your Honor, Ms. Culpepper is a witness, and I don't anticipate right now calling her, but she's a potential.
Right. So, ma'am, as a potential witness, I'm going to sequester you. So I'm going to have you be out of the courtroom. You shouldn't see what another witness has to testify to. It's both a protection for the court and yourself. All right. So I'm going to have you sequestered out of the courtroom. And Mr. Marshall, you may call your first witness. All right, officer, you can come right up here.
in Your Honor, the people call Officer Forbes.
Okay. Officer Forbes, you can come up here and I'll have you have to state your, I don't know if you can state your first name and your last name for the record.
Yes, it's Robert Forbes,
Okay.
ROBERTFORBIS.
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, have a seat. The microphone is for recording purposes. I'd have you project to the back and let me know if the fan's bothering you. We can turn that off. All right. Mr. Marshall, you may proceed.
Officer Forbes, where are you employed?
Lansing Police.
In what capacity?
I'm currently assigned to uniform patrol.
And what were your previous duties? Did you have any other previous duties?
Yes. From 2018 to 2021, that 3 years I was with the violent crime impact team.
And what's that?
It's commonly referred to as VCI. It's a blend of plainclothes surveillance and marked patrol units with the overarching goal of reducing violent crime in Greater Lansing area.
And were you employed in your current capacity on May 8th of 2023?
Yes, sir.
The 7th.
Yes.
And while you were employed in that capacity, were in marked patrol vehicle, were you conducting regular patrol near the St. Therese School on that day?
Yes.
And is that in the city of Lansing?
Yes.
County of Ingham?
Yes.
And what did you observe that day while in that area near the school?
I remember this day very, very well. It was a very nice Michigan summer day. It was sunny and very nice. And I was just driving, moving patrol, regular just patrol. This particular area has had several complaints recently of weapons related incidents, quality of life issues. And so I was just cruising through the area essentially. And I saw that there was, at my first glance was that there was a family playing at the park.
And did you stop and observe that, or what did you do at that point?
So to just try to describe it, Judge, the school has at least two entrances. One entrance is off of Randolph. The other entrance is off of Turner. And I came from Randolph and was driving essentially almost in a U around the area to the Turner Street entrance exit. And in that became, in my view, the playground and in the general area. And that's how this came into my view as I was driving through right in front of me.
And what did you see that that caught your attention?
The first thing that caught my attention, really, this started off as not suspicious. It looked, I saw a man and a woman and a couple of young kids on the playground, and it looked like a beautiful day to be in a Lansing Park. And everything changed when Mr. Trainer saw my patrol vehicle getting closer, and I saw him, and his demeanor changed from playing with the kids and the female to looking very anxious. And I saw that he made a retention touch to the right side of his waistband.
What is a retention touch?
So a retention touch is what it is, an indicator that someone is armed. And we learned all about this at a training that was hosted by the ATF when I was in the VCI team.
So you have past training experience in observing and learning what a retention touch is?
Yes.
And you observed the defendant do that on this day?
Yes, I did. And furthermore, once that happened, combined with his demeanor change from playing to appearing nervous and anxious, and combined with a retention touch, it allowed me to now, as I was moving forward, get closer to him. And I saw that there was a very distinct bulge protruding through his black t-shirt, consistent with the handle of a firearm based on my training experience.
And what did you do at that point?
At that point, I remained in my patrol vehicle, and it made it, my sense of suspicion was continuing to rise, that he was carrying an illegal firearm, because as I got closer, he walked from near the playground equipment to a nearby I don't remember if it was a picnic table, Judge, or a bench. I think it was a picnic table, but he sat down at the picnic table and put his arm on the item that was protruding that I suspected was a firearm. In other words, trying to further conceal what I suspected was a firearm in the behavior change.
And did you make contact with him at that point, or?
Yes, eventually I made contact with him. I did not exit my patrol vehicle. I had my windows down, and I just pulled up relatively close to him, and told him flat out, hey, do you have a CPL? Because at that point I was convinced that he was armed, and his response was that she did, and indicating to the female that was with him at the park. Meaning to me, if she does, he's indicating that she does and not himself.
Not
pinpointing to me, he is armed illegally.
And what, at that point, did you specifically ask him, or what did you do at that point?
Yes, at that point I got out of my vehicle and directed the conversation to look, listen, number one, let's be safe, don't reach. He was 100% cooperative, did everything I asked him to do, provided ID, surrendered the firearm, exactly as I ordered, was completely compliant. I remember the firearm being a Glock 9mm in a holster that was in his right side waistband.
And that, when you pulled up, that was completely concealed. He had removed that.
Yes, it was. I remember him wearing a black t-shirt that was untucked and black jeans, and the holster was the firearm was inside a holster, Judge, and the holster had I remember having a clip on it, and the clip was essentially clipped to the waistband of his jeans to hold the holster and the firearm inside of his jeans.
Thank you. And do you see the individual that that had removed that firearm from himself in the courtroom today?
Yes. He didn't remove it. I removed it, but he was compliant completely. With
Understood.
Yes.
Understood. Do you see the individual that you removed the firearm from?
Yes.
Can you identify something that he is wearing?
Yes, see, it's my left, wearing a black polo style shirt.
Your Honor, I would ask that the record reflect that the officer identified the defendant.
Any objection to the witness identifying the defendant for purposes of prelim?
No.
For purposes of prelim, the witness has identified the defendant.
And just to clarify, you at that point, you had already asked him, he stated he did not have a CPL.
Yes, and that was further validated when I got out and engaged him in the follow-up conversation, and was clear to me in the beginning, and then verified with the follow-up conversation on foot that he did not have a CPL, and that he was holding the firearm for his girlfriend who was nearby, who was on scene and did have a CPL.
I have no further questions at this time.
Thank you, counsel. Cross-examination, Mr. Abbott.
Thank you. Good morning.
Bye, sir.
So you stated that one of the first signs that started to draw your attention from your observation to suspicion was his anxious attitude.
I don't remember anything about his attitude. I remember seeing his behavior change to be anxious upon seeing me.
Okay, and you were in a fully marked police car?
Yes.
Wearing a police uniform?
Yes.
Is that sometimes all it takes to make people change their behavior? Just to see a police officer?
I would agree. It could be situational. There certainly could have been other issues that he was concerned about seeing me, of course.
Okay. All right. So, and you testified that the firearm was on the right side of his body.
Yes.
And so when you approached him, was he was facing you, looking at you?
I'm sorry.
When you were driving towards him at first, was he looking at you, like right at you?
I remember making eye contact with him pulling up, and he was essentially looking right at me.
And how far away would you say you guys are apart? How far apart?
I would approximate the first time that I saw him, and understand that I was moving in my patrol vehicle, driving slowly through the parking lot. I first saw them probably, I would say maybe 100 feet away. And I pulled up directly next to him and engaged in conversation from less than 20 feet.
Okay. And as you approached him, did he turn his right side away from you?
He did yes, he did at one point.
And was that when he walked over to the picnic table and sat down?
I don't I don't remember that. I remember him seeing me being nervous, turning, and just his behavior completely changed. And turning was part of my observations of him being anxious.
And so anxious behavior, turning, and a retention touch, could you, so he's just putting his hand down there, is that what you're saying?
Yes, and then he also, I remember his pants were sagging down, and I remember him
Can I stop you
adjusting
right
his
there?
pants.
Before you go any further, sagging down pants, isn't that a pretty common sight? A lot of people wear their pants sagging down.
Yes, I would agree. The difference, the important piece here is it is in combination with all the other factors of the behavior change.
So when he made one retention touch?
No, I remember him making several.
And is this as he's walking towards the picnic table?
Yes.
And at this time, you hadn't actually seen a gun?
No, that's true.
And all you saw was an outline, a bulge in the t-shirt?
Well, yes, I absolutely saw a bulge protruding through his t-shirt. That is true.
And you were, based on your training experience, thinking that was probably a gun?
I was convinced it was a firearm, and that's why I followed up.
And his girlfriend had a CPL?
That is true.
And he said that he admitted to you that she had just given it to him?
Yes, that was his initial statement, is we were on foot together initially, essentially first contact.
So you're on foot together, he got up from the picnic table?
I'm sorry, what
When you,
point, sir?
well, so he's sitting at the picnic table and you got out of the car
Yes,
and you walked towards him?
yes,
Did he stand up?
yes,
Okay. And then you had your conversation with him?
yes.
Then during that conversation, he admitted that he had a firearm?
Yes.
I have no further questions. Thank you.
Thank you. Mr. Marshall, any redirect?
No, Your Honor.
May this witness be excused from the people,
Yes, Your Honor.
from the defense?
Yes, Your Honor.
Right, thank you. You're excused.
Thank you, Judge.
Any further witnesses of Mr. Marshall?
No, Your Honor.
Do the people rest at this time?
Yes.
Mr. Abbott, any proofs today?
No, not today, Your Honor.
All right. Motion for bind over, Mr. Marshall.
Your Honor, the people feel that we have met our burden of proof for bind over in this matter. Officer Forbes testified that to the ID and proper venue in this matter, that on this date, while on patrol, he observed what he described as several retention touches while observing the defendant walking, a bulge that he believed to be a firearm, along with the fact that the defendant's demeanor completely changed and started acting nervous. At that point, he approached the defendant, not even out of his vehicle, and just had a conversation. He asked the defendant if he had a CPL, to which he denied. The defendant admitted to having a gun, and that gun was removed from the inside of his waistband. I believe he testified to the right side. The fact that he does not have a CPL and that was completely concealed would meet the elements of this crime. And that he also testified that it was a Black Glock 9mm pistol.
Response to motion for bind over, Mr. Abbott.
Thank you, Your Honor. It seems like a Terry stop analysis. Whether or not the officer was able to articulate a reasonable suspicion. Well, based on the fact that these people didn't know each other, and He seemed, after just moments of observation, decided that he had just become anxious and just become nervous. Seems a little incredible, Your Honor, since he may have been nervous and anxious all morning. In addition, Your Honor, he admitted that he couldn't actually tell what was in the waistband, only that it, was on his right waistband and it was a bulge. There's nothing specifically suspicious about having a bulge under your t-shirt. So I'd ask the court to consider the reasonableness of the suspicion that was articulated by the officer in its analysis. Thank you.
Thank you. Probable cause is any response, Mr. Marshall?
No, Your Honor.
Probable cause is the standard for preliminary examination. Probable cause being the second lowest standard in criminal law. Reasonable suspicion, which is the Terry standard, is the lowest suspicion, but we do have on or about May 7th, 2023, the venue of the city of Lansing, location at 102 West Randolph Park, have been met by probable cause evidence and testimony of Officer Rob Forbes from the Lansing Police Department. He made identification of the defendant, Mr. Trainer, for purposes. And so this does come down to what initially just was a patrol car incident on Randolph, driving by St. Therese in the city of Lansing. And then as he gets approached, he sees some behavior which would indicate that Mr. Trainer is not acting the way somebody. Well, regardless, Mr. Trainer does a retention touch and then moves, and Officer Forbes is moving towards him. I think he described the feet, the complete feet, started 100 feet and then got less than 20 feet. At some time, that investigation or that suspicion changes as he sees a bulge in the right side, which the officer, based on the retention touches that he did observe, took to mean that there may be a gun present, which changes the reasonable suspicion. And so he makes inquiry of it by approaching and indicating the question as to whether he had a CPL or not. And Mr. Trainer immediately indicates that his girlfriend has a trainer. His girlfriend has a CPL. Part of the rules of having a CPL, as the court's aware of, is that the person holding the gun is supposed to make it aware to law enforcement immediately. That being aside, Mr. Trainer indicates that he does not have a CPL. His girlfriend has a CPL. He obviously is carrying the firearm, which is provided to him with 100% cooperation, as the officer testified. The Glock 9mm. It's in a inside waistband holster carrying mechanism. So although it was his girlfriend who had the CPL, he has a carrying mechanism for the Glock 9mm on his person in his waistband. And therefore, I believe that the Terry stop and Terry reasonable suspicion is met, and then the defendant indicates that he has a weapon, he does not have a CPL, and it's concealed on his person. I believe that the prosecutor has proven by probable cause evidence of the offense elements of carrying a concealed weapon, in that Mr. Trainer did carry a dangerous weapon, to wit a Glock 9mm or a pistol, on or about his person, contrary to the law of the state of Michigan. And I will grant the motion to bind over. So I grant the motion to bind over as charged. So, Mr. Trainer, your time in district court is now done. You'll be on to circuit court, which is the trial court on the felony matter. The court has found probable cause evidence to bind over. You should receive any new date from your attorney, Mr. Abbott, concerning this file. Anything else for the record, Mr. Marshall, on 23-02-140?
No, Your Honor.
Mr. Abbott.
Not from the defense, thank you.
All right, Mr. Trainer, please keep in contact with your attorney, Mr. Abbott. He'll provide you with any additional date concerning this file. Your time in district court is all set. Okay, sir? All right, thank you.
So this is a small claims case in front of the fabulous Judge Webster out in Kansas. The Beckmans are suing their veterinarian for failing to inform them that their dog had tested positive for a parasitic infection. It took about 2 weeks for her to let them know. They took the dog elsewhere, got the dog treated, the dog is healed, everything is fine. They don't have actual damages. It's more emotional. What could have happened is what their premise is. So it's a little interesting. Hope you enjoy.
All right, Mr. and Mrs. Beckman, can you hear me?
Yes.
Okay. All right, we will be on the record now in 2023 SC 16. Bill Beckman and Joyce Beckman, plaintiffs appearing in person and pro se, defendants in the counter petition, versus Michaela Sundgren, DVM, El Dorado Animal Clinic, appearing in person and pro se. She is the plaintiff in the counter petition. This is 2023 SC 16. Would all three of you please raise your right hand? You solemnly swear the testimony you're going to give herein shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, all right, thank you. You've all taken an oath and sworn to tell the truth throughout these proceedings. We will start with Mr. Beckman's petition and Ms. Beckman's. This is a small claims petition, and you indicated in your paperwork that you're seeking $4,000 in judgment plus interest and costs. You say that the veterinarian, here's what it says literally, veterinarian incompetence by failing to notify us in a timely manner that our dog tested positive for Giardia, thereby endangering her health and exposing us to this infectious disease. So who's primarily going to testify here?
Or both, but I should go first.
Okay, go ahead. Remember, you are under oath.
Yes.
Please proceed.
I should probably start from the beginning, from the first time I went to this veterinary clinic, because it's detrimental to the case. I believe so. I originally went there, and it was the first time, you know, and I thought it was kind of odd at first because I never got to see the vet. Usually when you go see a veterinarian, you know, for a the first time visit, you see a veterinarian. I was told by the tech, oh, no, you don't see the vet the first time. Okay. So then we were, you know, we had a lot of questions and answers, and we were given I said, well, what about the parasite? Let's test for parasites, you know, worms and stuff like that. They said, oh, well, the tech told me we don't have to do that. We don't have to do that because I think that the name of the drug is Bravacto or something like that. It kills everything. It kills everything. So we don't have to do that. Well, that didn't register with me too good. I kept thinking about that in my mind because I have a little medical background too. And I said, you know, that don't make no sense. But I asked her a couple more times during the conversations because we had another thing, and just said, okay. So after it was all done, you know, and we did everything, we went, and I found out later, I thought everything was okay, but I felt a little uncomfortable. And then whenever I got home, I looked and checked on some things, and there was three things. I can't think of all of the things off the top, but they were not detrimental to my dog's health, but they had something to do with the chip. They had my name spelled wrong, you know, and a bunch of stuff. So I said, right there, my gut told me, okay, this veterinary clinic, I don't want to go back to, because if they're going to mess with that, they're going to screw up on my dog and something's going to happen. So let's see. I followed up. I wrote a nice letter
saying to the veterinarian why I would not come back. So I went, I believe it was the next day or the day after, and I had a letter all ready to go. It was sealed in an envelope. So I went into the vet clinic to give it to the vet. Remember, I don't even know what this vet looks like. I never seen her. So I went to the front desk and said, I have a letter for the vet. And one of the gals there said, oh, the next thing you know, the office manager comes back. Her name's Andrea. And I tell her I have a letter for the vet. She goes, anyway, we went to the back room. And I told her, you know, some of the screw ups and mess ups or whatever you want to call them. And we went over them. And, you know, she did apologize. She apologized more than once. She said, we dropped the ball on this, but we're human. I said, yeah. She says, well, okay. So we went over the thing that went wrong with the computer. I don't know. There was a chip. There was a name. There was a couple other things. But like I said, none of it was detrimental to the pet's health. And she told me, Andrea said, she just, you know, I thought we got along pretty good. She said, please give us a second chance. She said, I wasn't there that day. I wasn't there that day. And these girls, they're going to have a talking to because I trained them. She says, I trained them. And I guess they're not getting the training. And I asked her again, I said, doesn't the veterinarian see the pet, right? The first visit? And they go, no. Oh, no. Excuse me. She says, yes. They see the veterinarian, usually always the first visit, but I wasn't there that day. So that covered that visit. And, you know, she just, again, I believe she said, when we went out to the back, I gave her some dog food. I did, you know, and, you know, I thought everything was good. She said, I hope you give us a second chance, you know. So I went home, I slept on it, I thought about it. I said, okay. So then we had an appointment for another follow-up, you know, for, you know, whatever the follow-up was, I guess, for another checkup, because she's a puppy.
And one of the shots.
And one of the shots. And yeah, I think it was anyway, you can, okay. I gotta get my thoughts together. It's all in my head. I don't have to take notes. So when I went back for that follow-up visit, I brought my wife. She came with me. But before I did, nobody told me to take a stool sample. I did that on my own. So I took a stool sample with me because I said, when I went to the front desk, because I want her tested for parasites. Something doesn't sound right. And my dog, I don't know. She's not eating right, but she's a puppy. So I don't really know, you know, she's not eating right. She's not really drinking that good, but she's still a puppy, new to me. But I had seen her eating, you know, it's kind of, anyway, to make me feel more comfortable. So I didn't hear anything back, you know, after that. You know, the rest of the visit seemed to go okay. You know, the vet was okay, you know, I mean, she addressed my concerns, you know. Of course, I didn't know, you know, what's normal for my puppy. Yeah, I still don't, you know, I mean, I'm learning more now. I mean, certain things a vet will tell you, some things won't. I mean, veterinarians know to tell you usually, or most common people will tell you that, oh, never give a dog chocolate. But have you ever heard of a veterinarian never tell you to give a dog a grape? But one grape can kill a dog. Okay, that's neither here nor there, but that's a fact. So I didn't hear nothing back after that visit. And I thought it was kind of odd. How long does this take? How long does this take? How long does this take? So I think it was it the 24th of, what was the date?
They got the results back on the 24th.
No, forget the results. I submitted the results that day. I mean, not the results, but I gave that specimen, but I never heard nothing back. So that morning, I think it was July 6th, I called and made a phone call early in the morning. And I got a nice gal on the phone and I told her, have you had the results of that test? She says, you know, I believe you do. I'm not sure, but I'll go in the back I'll write a note right now and I'll go back. I'll get back with you within just like 2 or 3 minutes. Well, 2 or 3 minutes turned into 10. I never heard nothing back. And I wanted to take my dog, you know, out in the country. I take care of some land out there. It's an hour one-way drive. So I figured, okay, I'll take my dog out, you know, and I took her out in the woods. I thought something was off. She's really a spunky little thing. She's a pup. She has a lot of energy. She's a hunting dog. And I said to myself, this isn't right. You know, she's not hardly drinking. And I became, you know, really, really concerned then. I said, I don't know. It's just, so I get in my car, I take her back, and I asked my wife, I called the wife. I said, did they call you yet? Did they tell you? No, I haven't heard anything. I believe she called. She can verify. I don't know. I'm just telling you what I know. And I called again. I'm on my way home. I call on my phone. I ask, I said, the results of that test, this is Mr. Beckman, you know, or something like that. I said, I'd like to know the results of that stool test. And I guess I got a different gal. I don't know these gals' names. She told me, and she says, oh, she says, that's being handled by another gal, and she's on the phone right now, she says, but she's just about ready to hang up. I'll have her call you right back within 2 minutes, max. I said, okay, that's fine. She hung up. I never heard boo. I'm about halfway home. I called again, and I said, I want to speak to the office manager. Well, Andrea picked up, the office manager, and right off the bat, she tells me, she says, "Oh, your dog has, I believe it was Giardia." You know, and I go, "Oh man," because for puppies, that's bad. Maybe a dog can survive, but she's a puppy. That's not good. Puppies. So right away, like, you know, it hit me right in the gut. And I go, wow, that explains all this stuff. And then she goes on to say, okay, I don't think you're a fit for this clinic. She was trying to read me this, blah, blah, blah. And I'm going, what? You're telling me the day I'm trying to get answers for my dog for Giardia, or not Giardia, for what, if the parasite test came back positive or not. You're telling me the test came back positive, and now you're telling me you're just gonna throw me away, find another vet. We don't think you're suited for us. It's like, okay, I guess I know more than the vet. I'm smarter, because remember, the vet never ordered that test. I did. So she did say, okay, the veterinarian, or we will cover a little medication until you find another vet. Blah, 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 blah. Well, I didn't want nothing to do with this vet anyway. So the letter, you can see the letter, that's fine. I don't have a problem with that. But later on in the evening, when we talk to the vet, it's like, oh, so you're gonna take me to small clinic. So I'm not gonna give you that medication. That tells me that's spite. That's spite. I used to work with surgeons for a living, surgeons. And if they ever did that, I don't believe they would ever do it. I would never know. But I think if a surgeon would do that, or say, okay, I'm going to sue you, but I'm not going to give your child that medication today because you're going to take me to court. You're going to have to find another doctor. I don't think that would go over too good with the board. I really don't. But that's me. I mean, I'm not a doctor.
So we do have a limited time.
Okay. Yes,
so
ma'am.
Tell me, please, what happened between that call and now that brings you to court? Anything else?
I quick went down because Andrea told me that she had all the paperwork and everything. So I mean, it upset me. I mean, I had to quick get my dog. I had a sick dog. I have a sick dog right with me. Mm-hmm. So I quick went in there. I said, where are the paperwork? Where's the stuff? Quick. I don't know, one of the gals quick, they got it. And I said, I'm out of here. I'll see you in court. And I left. And I had to hustle around to quick find me another vet. Luckily, I found a really good vet. It was a godsend. And he right away put her on some good medication, and he checked her all over physically and everything, So,
And is she fine now? Did she survive okay?
yes, ma'am, she seems to be doing really well. Thank
I'd
you.
like to add a couple of things if I may.
Okay.
First of all,
You need to sit in this chair.
Now,
I don't see her,
Joyce
I don't see her now.
Oh,
You're Joyce Beckman, right?
Yes.
Okay, you're part of the plaintiff.
What I want to flesh out is that I also emailed the office around that time. They had the results on June 24th. We didn't find out until July 6th. Now, I have had Giardia before myself in the 90s, and I was very, very sick. Now, Dr. Sundgren may tell you it's not the same thing in puppies as it is in adults. Regardless, I was sick enough to be hospitalized and was extremely ill. I took the same medication that they give for puppies and dogs for Giardia. It's very rough on the system. In the meantime, she had Giardia, and I had an aggressive place with her, and she bit me accidentally. And it was a pretty bad bite, so I went in for treatment. And because I'd had Giardia before, and because the puppy did have Giardia, I was putting the exact same drug. All of this could have been prevented if she had told us when the result came in. It came in the 24th, and we didn't find out about it till the 6th. I asked for $4,000 simply because I don't know a dollar figure to put on this. My husband is a disabled veteran, a service-connected disabled veteran. He has this dog certified by his psychiatric provider as an emotional support animal. I can't put a price tag on an emotional support animal for my husband. So I don't know what to ask for. Yeah, and I was on the same medicine for the same thing, and it was very, very harsh on me too. Yeah, because I told her I got bit. I fleshed out this whole story. So that's pretty much what I have to add to it, and that's our case.
Okay, I wanted to wait till after he testified before I gave you this information because it kind of changed the way I looked at the case. So, Giardia, Giardia, it's a parasitic infection, but it just causes diarrhea in dogs. And it's caused by an intestinal parasite, and it's found in contaminated soil, food, or water. And many dogs don't show signs of infection at all. Younger dogs, dogs with weakened immune system, may experience symptoms, but the symptoms are diarrhea or watery stool, abdominal discomfort. It's not a deadly disease like parvo, where it is very hard to treat and super expensive to treat. This is, here, take a pill, watch, don't let them get in contaminated stuff. The same way you would treat if the dog had roundworms. So it kind of made me look at it a little bit different because, yeah, the vet should have told him sooner. It probably wasn't the best thing, but his reaction was a little bit over the top. Granted, I probably would have done the same thing because I would have anxiety. I would be freaking out thinking the dog had cancer when actually it was just a lump of fat in her chest. Yeah, that was me. But him, I kind of understand. Another thing is if they would have actually presented some form of expense that was resulting from the treatment of the dog at the other veterinary clinic, like, hey, I had to go do this and it cost me this much more money because of the treatment, but it seems like the treatment was the treatment and the dog had it before he went to them. So they didn't really have any monetary damages that they could ask for. It was emotional distress. And yeah, the vet didn't do the right thing, but she didn't cause actual damages.
So how did you come up with 4,000? Just because that's the small claims limit?
That's the limit, and Your Honor, I didn't know what to ask for, so that's what
I should jump in. I should say something.
Yes, please do.
Your Honor, most people, including all the vets that I've been to in Kansas so far, which isn't very few, and I haven't met one single person that even knows my dog breed. They don't even have it on their roster. She's got pedigree. She dates back way, way back. Even George Washington, I think he had one of these dogs for a hunting dog. I know Theodore Roosevelt, Teddy, the big hunter, he hunted with his sons. So a lot of people don't know about these dogs, but it's big in the South. That's probably why they don't know about it in Kansas. I had to go to Texas to get my dog. My dog's got world-class champion backgrounds. She's just not any dog. It's hard to replace a dog like that. I mean, I don't know how you put a price tag on a dog. You don't put a price tag on your kid. I don't know how you put a price tag on this particular puppy.
Yeah, and she survived, but it wasn't thanks to Dr. Sundgren. Not thanks to her.
Okay, thank you, folks. I understand where you're coming from now. Dr. Sundgren, if you want to respond to, first of all, there's a case, and then support your case against them with your testimony, please.
Well, I am sorry that their dog was sick. I was never aware that their dog was sick in any of our interactions. I think that protocol was followed pretty standard with this case. As you can see, they were not very happy with us as a vet clinic, and we were processing their records to mail those to them so that they could seek care elsewhere. I did get their results that it antigen tested positive with Giardia, which is not correlated with clinical signs always. And it is not even recommended to treat an antigen test positive if they don't have any ova or clinical signs. And where I did not know that there was clinical signs, I didn't feel there was a reason to treat. I have their records right here where we did ask at both of their appointments, how's your dog's energy level? Normal. Is your dog eating? Yes, normal. Any coughing, vomiting, diarrhea, which would be some symptoms, blood in the stool, all of those were normal. So I don't think that there would have been any reason to treat the animal, not knowing that there were any clinical signs. And we did prepare their records in a timely manner. Records can take 5 to 7 business days to put together, especially with a letter that we had to send releasing them as a client, because we've never had to do that before. We've never encountered that situation where we had to let a client take their records and leave, because we've never had someone who was so aggressive with us before. So it was new territory for us, but we did complete that in a fairly timely manner.
So when you saw the dog, did it show any signs? I think you've answered this, but did it show any signs of Giardia when you saw it?
No.
And the day that they complained about the signs of Giardia, was that the day they also told you that they were going elsewhere and going to sue you?
It's 2 o'clock.
Okay. Now, what do you want to say about your claim against them?
I just filed a counterclaim to cover some of the costs associated with my staff time that was put into drafting their records, time away from clients, which is during this proceeding, and my staff that's going to be there at this time until I get back.
All right. Thank you both parties. First of all, I haven't seen any justification for the $4,000. I understand that sentimentally the dog is, as you said, priceless, like a child, but I can't make the doctor give you $4,000 without knowing why those are your damages, other than sentimental. So I'm not going to grant the Beckman's petition. And frankly, I'm not going to grant the Dr. Sundgren's petition either. I understand you may have put in more costs than are in the normal course of business. And I do know business records can be very expensive. But have you given them just a simple bill for the cost of production of the documents?
No.
Okay. Well, I think that would be the better approach, to just give them a bill for the costs of production. But as far as lost staff wages and time here to testify, I'm not granting that, so I'm denying both claims at this time. But you can appeal my decision. You have up to 14 days each side to appeal that decision. So you may go at this time.
Thank you, Your Honor.
You're welcome. We're in recess on Beckman versus Sundgren.
Your Honor, do either of us have to pay, do I need to go and pay court costs for this? I mean, what do I need to do?
You're each responsible for your own court costs.
Okay.
Okay, you may.
All righty, thank you.
You're welcome, and we will take up. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, I didn't hear the ladies.
Oh, I do.
And Miss.
I do, sorry.
Okay, thank you.
I think I hit something
Right.
over here.
You may lower your hands. All right, Miss Schuster, you are suing the Bains for, what is that? I can't make out that word, theft of deposit?
Yes.
Trespassing, entering your home twice without written notice, police reports, 3, fraud and extortion. Said he raised rent November 21st and I did not comply, and you're seeking $4,000. So tell me what this is all about. I don't understand it in detail. I kind of get a general picture, but what's going on?
In October, the first week, he came over to fix my bathroom.
Excuse me just a minute. So were you renting property from the Bains?
I was.
And where was this property located?
211 North Orchard here in El Dorado.
211 North Orchard. That's not your address anymore?
No.
Is that your address on the charging document?
No, it's my PO Box 708 here in El Dorado.
Okay. All right, go ahead. So you're renting this property.
And the first weekend, he came over to fix the bathroom. And then a few days later, he called me, wanted to talk to me and said that he was semi-retiring and wanted to sell the property. So he said I had until the end of February. So I said, okay, not a problem. I'll get right on it. And so I was in the process of trying to locate a place to rent and whatnot. And then a week before Thanksgiving, my daughter and I were going to see my mom for Thanksgiving because my daughter was working for the sheriff's department. So she had to work Thanksgiving. So we were going the week before. And 2 days before we were leaving, he calls me and tells me he wanted me out by February 1st because he had big plans for the house. So that kind of took away a month away from me. So I'm sitting here, frantically trying to find a place. So in the meantime, on Thursday, I was cleaning out my house, getting everything into the storage units. I left my camera in there. So I got a picture of him coming into my house Thursday night. He was sitting there looking at my cleaning supplies that was on the floor because I was going to clean Friday because I was to meet him on Sunday. And then there's a second picture of him coming out of my bedroom, well, on that Thursday. So the next morning when I saw this on my camera, I called the police to write a police report because according to what I have learned with the tenant's legal guide and whatnot, they're supposed to give a 24-hour notice. Well, he did not. Well, then Friday, after I got done cleaning everything and everything is out of the house, apparently both him and his wife came into the house with flashlights looking around. So a neighbor of mine, or a former neighbor, I should say now, called, thought maybe I was over there. And I said, no, I'm not. So she had called the police and said, somebody is over there. My friend just moved, was moving out and there's a problem. So the police came and found the two of them in the house. Again, no written notice, no nothing. And from what I understand, the police officer was like, is the lights not working? Well, they never checked it and they turned them on. Of course, I didn't have them shut off until Monday. So come Sunday, when we were meeting him, I had an acquaintance of mine that put the blinds up because I can't be upside down because I got hardware in my neck. And about 10 minutes after he left, when Bob came in, I had Martha that was with me. He just started yelling at me. Well, where is this gas stove? I'm like, there was never a gas stove here. He's like, well, it was right here. You brought in a freezer for me from Charlie's. So, I mean, obviously there was not a gas stove there, whatsoever. Then he's like, do you think this house is clean enough? I mean, it was clean. I said, yeah. Well, he just happened to come across a cobweb, I guess. It came off the ceiling onto the light switch, and he got upset about that. And I'm just like, a cobweb, Then he goes in and he tells me about the scratches on my bedroom door. And I said, yeah, Bob. I said, remember the previous tenants' dogs did that? Because my dogs were little. They couldn't make the 3 or 4 inch scratches on these doors. And I said, my bedroom door to the bathroom is closed, so there'd been no reason for them to scratch it. Then he proceeded to go into the living room and tells me, do you think you're going to get your deposit back? And I said, well, yes, the house is clean. Well, you're not. So I just sat there and I said, Bob, I said, it's been a blessing being in this home. I hope that whoever buys this house, it's a blessing to them. I set the keys on the counter and I said, you have a good day. I said, here's some paperwork for the housing authority that you need to sign. So that way they know that I moved out. Okay, so we left. And then come Monday, I get a text from him telling me that, and I'm going to quote this to you. So if you give me just one quick second here, that, come on, phone. Okay, where'd you go? I'm in the wrong place. Hang on, here it comes. He goes, Monday morning, he goes, Virginia, you didn't give me a chance to tell you the main reason for not getting your deposit back. Back in November 2021, I raised the rent, and for 2 years, you never paid a penny toward that increase. I guess it's my fault for never pushing it. So with the $500, you're getting off very well. You can verify all the rent increase correspondence in the November 2021 text between you and I. As you can tell, I gave you all the paperwork. Housing authorities clearly states that whatever they say is to be paid is what's going to get paid. And as you can tell, both in 2021 and 2022, it all remained the same at $575. And so I'm not to be paying a dime more than that. And so that's where the fraud and extortion comes in. I didn't know what else to call it, so that's what I did. And so I had to find these legal books to make sure that what I was doing and what I was going to be presenting here today was factual. I didn't want to come in here and doing, wrong things. And so I feel like, he knew, and I told him numerous times, if he wanted the rent raised, he had to contact the housing authority because I could not do anything about it. If they say to pay a dime, that's all I was supposed to pay. If they said pay $5, that's all I was supposed to pay. And as you can tell, like I said in the correspondence, I paid exactly what they said to pay.
Okay. All right. Who's going to speak primarily for the Baines?
Yes, I'll be speaking.
Okay, go ahead, please.
Okay, I'll just address these as they're listed here. As far as theft of deposit, in our term of lease agreement, it says that the rental property should be returned in the same condition as it was initially rented. And it was in very clean shape when she first took possession.
And when was that? I'm sorry, Mr. Bain, when did she take possession?
Oh, boy.
No, if you know, if not, go on.
I don't know.
Okay.
Looks like November 1st, 2020.
Okay, go ahead, please. I'm sorry. I hope I didn't break your train of thought.
That's all right. Unfortunately, the property required significant cleaning and repair upon renter's departure. The specific areas I'm addressing are the walls, kitchen, dining room, utility room, all need scrubbing, deep clean. I mean, her idea of cleaning is a lot different than mine. And appliances, the stove was filthy. It was coated with grease from top to bottom. Refrigerator needed a deep cleaning. The carpets had never been cleaned since she's been there. Had to remove all the carpet because they were urine infested. And I'm going to note that she had 6 to 7 dogs and cats in that house at one time. I allowed one when she first rented the house. And the lease specifies renter must ask permission. And we come upon all these animals in the house. And we told her, okay, you can have 2. And well, that never happened. 4 was probably the least she ever had in there. And there were litter boxes scattered around the house, completely full, and all over the carpet and floors everywhere. Overhead fans and vents were filthy. There was a excuse me, window air conditioner installed by the renter without my knowledge or my consent. And when she removed it on departure, I had to rework the window, and there was moisture that was dripping down into the wall, and I had to repair the sheetrock beneath it. And we go to the outside of the house. It was a complete mess. Yard, bushes, flower beds were all overgrown. And it just took hours to put that back in the shape. And I'm just saying the estimated cleaning and maintenance was 20 hours. Carpet was 1,700 with the repairs. Okay, number 2 with the trespassing. I pride myself, I never enter a tenant's house without permission. And because it's their house, I have no business being in there unless I'm allowed to. And the last couple of days she was in possession of the house. I knew she was gone. I knew it was vacant, and I was worried about, and I thought the power was off, and I was worried about freezing pipes and everything. And that's why we went in there, my wife and I, with flashlights. We didn't know the power was on until the police came and we checked some other lights and they worked.
Now, when was this?
That was a couple days, let's see,
The 28%.
28th of January.
What month?
January.
Of this year?
No.
22?
It was this
No,
year.
this year.
Yes.
23?
And and I just wanted to see condition of my house. I knew she wasn't living there at the time, and I would not have gone in if she was there, of course. Fraud and extortion. I first gave her a notice of rent increase 7/9/2019, not 2021. She acknowledged the increase but never paid it. And to be honest, I didn't know that the housing authority had to be contacted for all this until the last days. But after a couple of months, she told me that she was looking for another place to rent. So I didn't even pursue an increase in rent. I just thought I was being good about that. After that, I didn't pursue, or I believed that I thought she was moving out. And her multiple attempts to secure another rental all failed for some reason or another. When COVID hit, of course, there's no properties out there to be found. So she quit pursuing a rental. And I just thought it'd be a big hardship on her to try to enforce that. And then November 2022, advised renter is planning to sell the house and gave her 3 months. And I don't understand why I'm being sued for a rent increase that I never received or even attempted to to collect. And I'm not sure why she's doing this, but I'm there within a day of fixing anything that she had a problem with the whole time. And just didn't know there was a problem, but we just have different ideas on cleanliness of the house too.
I do have
Hold on, Ms.
a,
Schuster, hang on, Ms. Schuster, did you have 6 or 7 dogs at a time in the house?
no, I came in with my service dog, Annabelle and Tico. And then I had 2 cats, and then Shelby, my daughter, she had 2 cats. And the time, right, yeah, we had the 4 cats and the 2 dogs. And I think the time he was talking about, I was actually babysitting 2 of my friend's cats because they were going out on a cruise, wasn't it? I think it was a cruise they were going on. And they asked me, they actually went on 2 that month, and asked me if I could watch their cats. And that's when they came in and saw all these animals. But
Okay.
I had 2 cats. Shelby had 2 cats. Go ahead. I'm sorry.
Is that Shelby that keeps kind of coaching you there?
Oh, yeah, she's over here. I'm just making sure I was telling the right story.
Let's not have that. Oh, okay.
Can I speak?
Well, who? Ms.
Linda,
Bain?
Linda
Sure,
Bain.
Sure, go ahead.
Okay, so when we found all the animals in the house, and she had been told that she could have the dog. And the litter boxes were so full and overflowing with cats. We gave her there, and I'm sure that, Judge, I'm sure you're familiar with this. It's the 1430 form that says you either fix this within 14 days or you have 30 days to get out. We presented that to her. She came to my office. I presented that to her. And I said, okay, you can have 1 dog, 1 cat. Well, which one do you want me to kill? Said, no, you can have 1 dog, 1 cat. That's what we're doing. Your lease said 1 dog, you can have 1 dog, 1 cat. We gave her the 14 days to remedy that. And she said that one of her cats, James, was dying. So I said, you choose 1 dog, 1 cat. That didn't happen. She might have gotten rid of 1 of each.
Yeah.
But there were always multiple animals in there, not just 1 dog and 1 cat. But again, we didn't, because that said, we presented it to her, and at the time, she had 30 days if she did not comply. Well, yes, that's our fault. We didn't pursue it and make her not comply. And then that's when all of the COVID hit and all the things. So we had talked about the animals, and she really hadn't ever said that those animals weren't hers, and they all stayed except for probably 4 of them. That 4 of them stayed, but but when she was rented it, 1 dog is what we were told she had.
She was never down to 1 dog.
So how many times did you see our house full of the animals and the litter box overflowing and those things?
The time that there was a tree, one of our trees had fallen. It was just a small tree, had fallen over into the neighbor's yard. And so she was out of town, and we had to get a chainsaw and get it off the house, but it's an electric chainsaw, so we had to plug it in. So that was the time when we saw all the animals, the multiple overflowing litter boxes in that mess. And that's why we presented that deal to her, that she had to get rid of all but 2 of the animals.
And I started a monthly inspection, and I've only done that a few times, and she never got rid of all the dogs. And when I go in to change filters, there's always, the last probably 6 months that she was there was probably 3 or 4 dogs in there at that time. And I just shrug, and she says that she's rescue. She's a rescue person. So who knows how many dogs and cats have gone through that place without our.
Oh, we're talking about Toby.
Changing gears on you here. So when you went into the apartment with the flashlights, had she removed everything, all of her possessions?
Yes, everything but the cleaning supplies.
Right.
And had she turned in her keys?
No, we met the following weekend or that weekend to go over the place, and then she gave up her keys then.
Had she told you she was moving
Oh, of course, yes.
before you went in?
Yes. Yes, yes, it was all scheduled that she was moving out. And I could see that everything was going away. And I found that she was completely gone because I went by there some evenings and her car has never been there. So I knew that she wasn't staying there.
So because it was colder, that's when we were concerned that because
The pipes,
the pipes,
freezing pipes and everything.
and we took the flashlights in because of thinking that the
Well, we turned some switches on, but
yeah,
nothing came on.
that one was burned, that light bulb must have been burned out.
Yeah.
So we didn't try anymore.
And so I guess from a neighbor's standpoint, it looked like someone was
breaking
in the house.
Yeah. And the neighbor said that she knew that nobody lived there. It was in the police report that she had told the police no one lives there and I see lights inside the house. So even the neighbor knew that she didn't live there.
All right. Ms. Schuster, I'll give you just a minute to kind of wrap up.
I have a video here of the house that I did for this purpose to show you what was done. Because I actually had 4 people, well, being 3 plus myself, that cleaned that house. And I mean, we spent 8 hours on that house cleaning it. I don't know if you're interested in seeing it or not.
Is it a video that shows the house when you left it?
Yep.
Okay.
You want to see
it? We've got a few more minutes.
It's 7 minutes long.
Well, let's go ahead and get it started. And you took it for the sole purpose of documenting the condition. Oh, that's not gonna work. I thought you'd give it to the clerk. Yeah, I can't see that.
Yeah.
To the clerk?
I'm sorry, give it to the clerk?
You didn't give it to the clerk? Clerk, do you have that? No, that's not what I mean.
Oh.
No.
Bellen, did she send you a copy?
I don't have the video.
Yeah, I can't tell from you holding it up to the screen.
Do you want, you can take it, do you want to see it? I mean, I did every inch of that house. I had to hunt it down yesterday to make sure I still had it. But I have it to where I took every inch of the house. But like I said, there was 4 of us there that cleaned that house from top to bottom.
Did you clean the carpet?
Yes. Well, no, actually all I did is we vacuumed over it twice because you said you're going to sell it. So I knew you're going to replace the carpet because when we moved in, there was this big purple stain, which Dorsha from the housing authority had told you about. So I didn't figure, why should I spend money shampooing the carpet if you're going to replace it because of that stain that had been there before we even moved in. So no, I did not have it shampooed. I vacuumed over it twice.
Okay. How big is this? How many bedrooms?
2.
2 bedroom? Okay.
Yes.
850 square feet.
Okay. All right. Now it's my turn. Everyone else needs to listen to my decision. This case comes to me with 3 claims. There's not a counter claim or counter petition. Okay, I'm going to start in reverse. Claim number 3 is fraud and extortion. Says he raised the rent November and I did not comply. I don't find any grounds of fraud or extortion. He didn't get any money out of you. You didn't pay any money. Once he found out the housing laws, it sounds like he backed off and let that go. 2, trespassing. I find that you'd already vacated the home that your neighbors knew you'd vacated, that you knew you'd vacated, Ms. Schuster. So I don't find any grounds that he trespassed. Now, there's criminal trespass, and if you want to take that up and see if the police disagree with me, they can do that. But it looks like you've probably already done that, and it didn't materialize into a criminal trespass either. So then there comes theft of deposit, and that's, I don't know that it's actually a theft case. It's just a typical contract disagreement that landlords and tenants often get into on these kind of cases. So as I understand it, $500 was put down for deposit, and that Ms. Schuster did keep up to 6 animals in this house at a time. That I find it credible that there were times when the cat box was running over with cat feces. I find it easy to believe that these rescue dogs could have very easily and did urinate on the carpet. So with the value of the carpet having to be replaced, I think it far exceeds the $500 deposit. So I am in this case denying the claim, finding in favor of the defendants. But Ms. Schuster, you can appeal my decision. You have up to 14 days to file my decision. Okay. So if there's nothing further, we will be in recess at this time and you all can go. Thank you.
Thank you.
Thank you, Your Honor.
Okay, so this one's a little slow to get started, but please stick with it. I promise you won't be disappointed. This defendant's charged with assault with a dangerous weapon, felonious assault, interfering with electronic communications, domestic violence, police officer assault resisting or obstructing, and assault or assault and battery. 5 different charges is being held on a $25,000 bond. This is a probable cause conference to determine if the defendant should be bound over to circuit court. On the stand is the victim / possible girlfriend / friend / something of the defendant.
You may inquire.
Do you recall July 10th, 2023?
Yes.
Where were you?
My apartment.
And what is the street address? Do you know what city or township that is in?
Yes, that's Ann Arbor, Michigan, Washington County.
And who were you with that day?
Yeah, 5 people. Mr. Percy.
And do you see Mr. Percy in the courtroom?
Yes, I do.
Can you please point him out and tell me something he is wearing?
Jumpsuit.
Thank you. Let the record reflect that the witness has identified the defendant as James Percy.
Record shall so reflect without objection.
And what is your relationship with the defendant?
We've dated on and off for 9 years.
And what happened on July 10th, 2023?
Well, we had come in from a psychiatrist appointment and got half of a gallon of Jim Beam. Objection, Your Honor, foundation.
Sustained.
And that was all that was remaining in the bottle.
Well, no, I've sustained the objection. Ask your next question. Court will disregard what was said.
Okay. And did you get into an altercation with the defendant?
Yes, I did.
Was this a physical altercation?
Yes, he pushed me.
And when you say he pushed you, can you demonstrate how he pushed you?
He pushed me. I was getting into the bed and he pushed me off the bed and I fell back and I hit my head with my shoulder. I didn't hit my head.
And for the record, that was 2 hands to push you?
Yes.
And did you give the defendant permission to touch you?
No.
And what happened after that?
After that, I grabbed my phone and I tried to call 911. The battery was low. He asked me if I was calling the police. I said yes. He rushed around the side of the bed, grabbed the phone away from me. I then got up, got his phone, had it hit him, tried to use his phone to call 911. Before I could get a call off.
I'm going to stop you. I'm going to stop you right there for a second. When he took your phone the first time, were you able to call 911?
No, I wasn't able to hit send before he got it out of my hand.
And did you give the defendant permission to touch your phone?
No,
And then you said you went into the kitchen. What happened?
I had grabbed his phone, tried to use his phone to call 911. He had a special lock on his phone. I couldn't crack it. By the time I was trying to get a 911 call off the kitchen, and got that phone away from me.
Okay, so you weren't able to call 911 that time. And then what happened?
Then he reached into the butcher block, pulled out a knife, held it over my head, said, bitch, if you say one more word, I'm going to decapitate you.
And how far away was he standing when he said this?
From here to here.
I'm sorry, Your Honor.
Can you do that again?
From where I'm sitting to right here.
Okay. Record should reflect that's about 2.5 feet.
And did the defendant say anything else to you when he held the knife?
Say one more word, I'm going to decapitate you. And then we did a little bit of a stare down. After that, I went behind the block that he had grabbed the knife from, and I grabbed 2 knives. And I held them out and said, well, okay, if you're gonna do some slicing, I will too.
And how did you feel when he threatened you with the knife?
It was very fearful that I didn't want to let him see me sweat, so I did what I felt was necessary to make him feel that I'm as crazy as he is.
May I have a moment, Your Honor?
You may.
And when he got the knife, did he point that at you?
He held it over my head.
So did he come towards you with the knife?
Yeah.
Overruled.
No further questions, Your Honor.
Thank you. Cross-examination. You may.
So, Ms. King, it was your testimony earlier that you and Mr. Percy have been dating off and on for the past 9 years. Is that correct?
Correct.
Would I also be correct in saying that for approximately 6 months before that day in July of this year, that Mr. Percy had been residing with you?
No, not. We would stay sometimes. We did not reside with me. He didn't pay me any money.
Isn't it correct that in actuality, he paid you $400 a month to stay there? And is your testimony?
What is irrelevant to the,
Oh, Your Honor, I was just following up on what she said. But I can.
I'll sustain the objection, move on.
So during the, it was your testimony that Mr. Percy came over after 5 o'clock that day, is that right? Isn't it correct that he had actually been at your home before that, before going to the psychiatrist? And he had actually spent the night from the night before, isn't that correct?
That's correct.
And the two of you had actually been together since even the day before that, is that right?
Objection, Your Honor, relevance.
Overruled, go ahead.
I believe he was around the day before that.
And over the course of these days, you and he had engaged in drinking alcoholic beverages, is that correct?
No, objection, Your Honor, relevance.
Well, since she was bringing up alcohol, you objected, now you want to bring up alcohol?
I would, Your Honor.
You would?
Yes, I would.
Okay, well, the door's open. I'll overrule the objection. Good luck with that.
And over the course of these 3 days, the two of you have been drinking alcohol, is that correct?
No, that is not correct. Alcohol wasn't brought into the picture until July 10th.
So would I be correct in stating that over the course of these 3 days that illegal substances were used by both of you, is that right?
No, that's not correct.
And would I be correct in stating that you, on July 10th, had smoked crack cocaine with Mr. Percy?
Objection, Your Honor, relevance.
What is the relevance in this?
Your Honor, Mr. Percy is indicating that Miss King's testimony and initial call were motivated by a situation with the substance use and a drug dealer. And so it's going to credibility.
I'll allow a little bit of an objection to overrule. Go ahead.
That day, one hit of crack cocaine that I did.
And over the course of that day, there was even a period of time where your drug dealer was actually in your home, correct?
Sorry, I needed to pause real quick and jump in. Look at the look on Judge Simpson's face and how his head jerked up. Like instantly my head went to that little clip that Mike plays with the hamster, dun dun dun. That escalated quickly. Wow. But I also don't like the whole shaming of the victim in a domestic violence case. That really bothers me. So yeah, she took a hit off a crack pipe. That doesn't mean that he didn't beat her ass and throw her off the bed. Like, give her a break.
No. Objection, relevance.
What is the relevance of whether a dealer was there? Presuming she has one.
Again, Mr. Percy is indicating that this situation and the phone call by Miss King are not true and were actually motivated by the situation between Miss King and her drug dealer.
Are you saying the drug dealer pushed her off the bed?
Your Honor, he is denying that, but he is saying that there were other circumstances that resulted in these false accusations.
I'm not following. He's saying there are other circumstances that resulted in her
False.
making these claims against him.
That is correct.
Okay, I'll let you go. I'll overrule it. Let's hear it.
Thank you, Your Honor. So I think I'm going to repeat a question that I asked you just because I want to make sure that I didn't skip it, okay? Isn't it correct that your drug dealer had been over there with you and Mr. Percy at one point during that day? Isn't it correct that a gentleman named Mo had been there with the two of you that day? And during the course of this day, Your Honor, may I have one moment, please?
Yes.
And would I be correct in stating that Mo was there the day before? Right? And that he was there the day before, July 8th. In fact, he spent a considerable amount of time at your home.
Sustained.
Now, before Mr. Percy went to his psychiatrist appointment, would I be correct in stating that you and he had gone to Family Dollar?
Your Honor, relevance.
What is the relevance of this? I mean, they did something during the day, apparently.
Your Honor, I anticipate that Ms. King will be denying these things, but again, these are the things that Mr. Percy is stating.
I understand. I'll sustain the objection.
Isn't it correct that Mo took you and Mr. Percy to Dollar Tree that day?
Sustained.
And in fact, over the course of that day, the two of you were shoplifting for money for drugs.
Sustained. All right, I'll wait for you to get it out next time.
Okay. Now, when Mr. Percy returned home, by that time, Mo had left, isn't that correct?
He was never there.
However, at that time, you had also decided that Mr. Percy, you didn't no longer wish Mr. Percy to reside with you, is that correct?
I never wanted Mr. Percy to reside with me. I allowed him to stay the night several times, but I never allowed him to move in with me. I never collected any money for rent. He ate me about our house and home.
And it was
5 meals a day.
Go ahead.
Thank you. And at that time is when you decided to call law enforcement, correct?
I decided to call law enforcement. I couldn't get out of bed. I couldn't get a phone call because my battery was low. I called.
So it's your testimony that you could not get that you were, because your battery was low, you were unable to get a phone call.
Objection, Your Honor, should let the witness fully answer the question. I think we could have heard the answer to the question. Her testimony earlier was that she tried to call, her battery was low, and he came around the bed and grabbed the phone. So if we could have the witness answer the full question.
Marie was doing just fine. Overruled. Overruled. You're welcome. Go ahead, Ms. Gaines.
Thank you, Your Honor. So is your testimony that your battery was low and you were unable to make the call on the phone?
Before we grabbed it, yes.
Yep.
Are you also indicating that you would not have been able to make the call because of your battery?
I had just enough to probably get the phone call off, like 3 or 4%. And then when I did get the phone call off was after I was able to get a little bit of charge on the battery after he had pulled the knife on me, told me he was going to decapitate me. I take that very seriously when someone says they're going to kill me. And they've said it before, and they've said things like, I've thought about it, and I will kill you, and I will kill you before the police can even get you.
Would I be correct in stating that that is information that you did not disclose to law enforcement on July 10th of this year? That there have been prior threats?
All I told them there have been prior.
Would I be, so I want to go back to something you just said. So you indicated that there was a point where you were able to get your charger, get your phone, and plug them in. Is that correct?
Correct.
And you had it, and you were able to have the charger on for a period of time where you were able to get more than 3 or 4%. Is that your testimony? I want to make sure I understand.
Not much more, a short period of time. I had told him to go to bed after he put down the knife and put down my phone so that I could put it on the charger. But he wouldn't go to bed. He kept coming out and taunting me and saying, I can take you. I can take you. And I kept telling him to go to bed, just leave me alone. And he kept coming up on me, and he'd come up with an aggressive manner. So finally, I grabbed the phone off the charger and I called 911. And I asked the assistant to hold on to the phone until they got there. I put a robe on because I was naked, and I went out front to wait for the police because I live in a security building, and he kept saying before they ever get inside, you're going to be dead.
Ms. King, is it your testimony that you were naked during this whole incident that you described in terms of being on the bed?
Objection, Your Honor, relevance.
She opened the door to it, overruled. Go ahead.
Yes, I was naked when I was getting ready to go to bed. They pushed me off the bed and being chased into the kitchen. I was naked, he was naked.
He was naked?
Yeah.
Did he come? So are you trying to let us know that after coming from the psychiatrist, at some point he took off his clothes?
Yes. He was falling over drunk.
And it's your testimony still that at this time you had not had anything more than that one hit of crack cocaine earlier that day?
Yes.
No alcohol from.
I did have one glass of alcohol. I made it with coffee and the Jim Beam that he brought in, and cream and sugar, and I milked that through the night.
Let's stop and summarize real quick while Judge Simpson examines that very beautiful pen. So she's naked on the couch, relaxed from her one hit off the crack pipe, or amped up, drinking her Jim Beam and coffee with cream and sugar, when he comes out of the bedroom a dozen times and starts being an asshat, and then grabs a knife from the kitchen and threatens to decapitate her. WTF?
Okay. Okay. So approximately what time is it? Approximately what time was it when you indicated that you were pushed off the bed?
Approximately 10 o'clock.
Right. And your statement is that from approximately 5:30 until 10 o'clock, you were nursing the one drink?
I didn't start on the one drink until 7 or 8. Because he kept losing the bottle and getting argument about that I stole his liquor.
Okay. So, and during this whole time, you both are naked?
From about 8 o'clock on.
Now you stated, I'm gonna move forward in time to back to where we were when you were talking about the putting the charger and the phone on the charger again. So you stated, so it's your testimony that during that time, Mr. Percy was going in and out of the bedroom? Approximately how many times would you say he went in and out of the bedroom? And during this time, let me rephrase that, I said it backwards. And as he was going back and forth, these 5 to 10 times, approximately how long would you say that lasted?
Question.
Approximately how long was he going in and out of the bedroom? 5 to 10 times. Like 2 minutes, 5 minutes, 20 minutes?
Like how many minutes was he out of the room?
How many minutes was the back and forth going? From the bedroom to where you were, from the bedroom to where you were?
I don't recall exactly.
Would I be correct in stating that it was more than 3 minutes?
I would think so.
Would I be correct in saying that it was more than 10 minutes?
I don't think so, because he was on the phone trying to get drugs, calling his drug dealer, Teddy.
So at some point, he stopped going back and forth and he was using the telephone?
Yeah, he was using the telephone. He'd go in and sit down on the bed and he'd drink some, and then he'd use the bottle behind the blanket or whatnot. And then the next thing I know, he'd be coming out to ask me what I did with his bottle, because I was trying to watch a movie in the living room.
And that, the watching of the movie and the charging of the phone, all of that was occurring at the same time?
No, the charging of the phone and all that didn't start until I tried to go to bed at about 10 o'clock.
So I just want to make sure I understand the order of what you were saying. There was the incident that you described. Then
Which incident?
I'm sorry. There was the incident that you described as occurring in the kitchen where you had knives and he had a knife. Is that correct?
He had a knife first, yes.
And after that is when you started watching a movie. Is that right?
No, I had been watching the movie before that. And I think I sat down and started over again because I wasn't comfortable going in and laying down. Wasn't a good time to go to sleep when you got somebody who just threatened your life.
So it's your testimony that at that time you sat down and started the movie again?
I believe I started it again, and I put the phone on the charger in the living room, and I kept the knives handy because he kept coming in and out of the bedroom.
Okay. So there was some time where you were watching the movie, is that right? After the kitchen.
Yeah.
And then there was some time where he was going back and forth. Is that right? And is it your testimony that you continued to have the knives on you?
I had them on the table by me, yes.
And it was only after perhaps the 5th or perhaps the 10th time of Mr. Percy coming out of the bedroom that you decided to call law enforcement. Is that correct?
It was probably after the 5th or 6th time. Telling him to just go to bed. I was going to sit up. Mr. Percy is very jealous and, he's demanding, like, come to bed now. Don't talk on the phone, put it on speaker.
Was that happening at that time?
At the time that I took the phone call that caused him to push me off the bed, he was telling me to put it on speaker. I hung up the phone, and he made me mad, and that's when he pushed me off the bed.
Would I be correct that at that time you were actually talking to a different one of your drug dealers?
Sustained.
Can I have one here, Mr. Percy, one more question?
Yes, you may.
I believe those are all the questions we have for you. Thank you.
Any redirect?
No further questions, Your Honor. and
Thank
no
you.
further witness.
All right, you may step down. You said you have no further witnesses?
Yes, Your Honor.
All right, you may step down. Thank you, ma'am. Any witnesses for the defense?
No, thank you.
Oh, I'm sorry. No, thank you.
No, it's okay. You didn't have to say that. You've been up for a while. All right, do I have a motion?
Your Honor, the people would ask the court to bind over on counts 1 and 2, both 3, 4, and 5 following. The people believe they met the probable cause for assault with a dangerous weapon and interfering with electronic communications. The victim testified that she got into an argument with the defendant where he pushed her onto the floor, took away her phone when she was attempting to contact the police. The defendant pointed a knife at her and in a threatening manner that made her feel fearful and stated that he would decapitate her. Thank you.
Response?
Yes, that the court find that the burden of proof had not been met, not find ultimate.
Court, after hearing all of the testimony, court believes that the people have indeed sustained their burden of showing that the offense of assault with a dangerous weapon or felonious assault has occurred, as well as the interfering with an electronic communication device. Therefore, the court will bind the defendant over on counts 1 and 2 with 3, 4, and 5 following. Gaines as to the circuit court arraignment.
Yeah, we acknowledge receipt of the information, waive its reading on the record, and at this time, Mr. Percy wishes to stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 5 counts. Pre-trial in this matter will be set for
October 4th at 1:30 p.m. with Judge Conlon.
October 4th, 2023, 1:30 before Judge Conlon. Bond in this case will continue. Thank you.
Thank you.
Thank you.
The defendant waive a formal reading of the indictment and arraignment. Can we proceed in a summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about March 4th, 2022, in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle while intoxicated with child passenger. Do you understand what you're charged with?
Yes.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be confined in state jail for 2 years. And that would be suspended. You would be placed on regular probation for 5 years. I'll use the Arabic numbering system.
What did it look like?
It looked like a
Chicken
Roman
scratch.
numeral. And then
Was it left out?
$500. 500 lawyer's name. Right.
He always-
They write like doctors. and then fine $500. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this state jail felony, man? Guilty or not guilty? Guilty. Are you pleading guilty of voluntarily, that is on your own free will,
Yeah.
and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. Is that so?
Yes, sir.
All right. State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report way.
Please, Your Honor, yes.
I'm going to follow this agreement. If nothing further, I'm going to find Ms. Pope, you are pleading guilty today voluntarily. You're mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony, and you were hereby sentenced to confinement in the state jail for 2 years. That confinement shall be suspended, and you were placed on regular probation for 5 years. You must pay a fine of $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. And as I recall, I sent somebody for 10 days in the county jail this morning.
Yes, sir. The difference between this and that is not much as far as the blood alcohol content. Ms. Pope was at 0.269. There's only one child in this car versus the other had 4 children in one. The timing of this particular event was 8 o'clock in the morning when she was dropping her child off at school.
What was the blood alcohol?
0.26.
Oh, mama. At 8 o'clock in the morning, you're 3 times the legal limit?
I had been out the night before.
You think?
Yeah. Well, I wasn't supposed to have my kid. He
So-
said his dad.
So let's speculate on what it must have been 2 or 3 hours before this. 0.4? Good Lord. I mean, the condition of probation, which is what I do, and DWIs with child passengers and DWI felonies, you must serve 10 days in the county jail. We can do weekends if that's, which is, you would check in on or before 6 o'clock PM on Friday, be released at 6 o'clock Sunday. You get credit for 2 days. You would have to do 5 consecutive weekends, or you can just do 10 days straight.
You can't do that. No, don't worry.
With the jobs, you would be able to.
Okay, so you're gonna do the installment fashion. Okay, then the 10 days on that. Sit on that, in that timetable, and sign that, and that will begin this Friday at 6, on or before 6 o'clock. Do you understand?
Yes, sir.
Okay.
Also appearing on Ms. Roush's behalf. Ms. Truesdell is appearing on behalf of the prosecutor's office. We also have court staff and clerk staff. We're going to conduct the bond violation hearing via Zoom, absent objection. Mr. Kane, let me start with you. You had a chance to speak with Ms. Roush in a breakout room. How are we going to be proceeding this afternoon?
Your Honor, Ms. Roush is aware that she's got the right to have a contested hearing whereby the prosecutor or the court would be obligated to have evidence presented showing that she in fact violated her bond, and the evidentiary standard would be basically by preponderance in that case. She understands that she has the right to my assistance for that hearing. She's willing to waive those rights. She's going to admit that she violated the conditions of her bond as set forth in the affidavit and petition dated, or that you signed back on July 27th. She did in fact drink alcohol on July 24th, and she did fail to contact Ms. Jacobs prior to being released from residential treatment. As to the second half, she wants me to explain what happened there. As to the other, there's an explanation that's that I have a game plan for.
Okay. And Ms. Roush, we'll certainly talk about the circumstances behind both of those in a moment. But first thing I want to cover is you do understand, as Mr. Kane indicated, that you do have a right to have a contested hearing. He would represent you at that contested hearing, but you want to waive those rights and just admit to the violations. Is that correct?
Yes, Your Honor, I do.
Okay. Is it accurate then that when you got done with residential treatment, that you did not immediately contact community corrections to set up an appointment so that a GPS device could be placed on you?
I feel like I promptly did, but I didn't do it before being released because my daughter got COVID and we were medically discharged unexpectedly, but I did contact Saturday and Monday, and we made the appointment for Tuesday. So
okay, and it
I'm
may be
unsure.
Sure, that's fine. Let me phrase it this way: is it accurate that you did not contact community corrections prior to being released from treatment, as was ordered by this court?
Yes, Your Honor.
Okay, and then is it accurate that on the July date that Mr. Kane mentioned that you did consume alcohol?
Yes.
Okay, and you knew that you were not allowed to consume alcohol as part of your bond. Is that correct?
Yes, Your Honor.
Okay, I'll consider that an admission of the violations. Mr. Kane, let's talk about going forward. You mentioned you had a plan relative to that.
I did, Your Honor. And you heard Ms. Roush's explanation for the contact with pretrial services. I'm going to guess that that's not the court's biggest concern, particularly because she's got it well documented. She did not, in fact, notify Ms. Jacobs prior to being released because it was happening rapidly as a result of her daughter's COVID, and there was really little opportunity. She did on Saturday and then again on Monday, and ended up tethered on Tuesday. So I would call it, well, I don't want to use technical and non-technical. It is an actual violation of your order, but it's unintentional on her part based upon the speed of the services she was receiving out of her control and the timing of it. However, the bigger concern I'm going to guess that you're worried about is the drinking on the 24th. And that's a concern because you ordered her not to drink, and yet she did. Other than that, she's been testing successfully. So that my suggestion, Your Honor, is a CAM. She's got housing lined up that's still being held, a family unit at the Goodwill Inn that she'd like to take advantage of. She has young children that she should be there for. She actually was doing fairly well on this bond up until this relapse. And this relapse occurred because of the obvious. Shelby's an alcoholic. So extra tools in her toolbox to help her deal with her alcoholism, I think are mandated. Mere testing alone was insufficient. She had been on the hook for a Vivitrol shot and missed the appointment. And she understands now that this is the result of it. If she misses her Vivitrol shot appointments, she's going to end up in jail. So she's going to get a Vivitrol shot again as soon as she's released, assuming you release her, put on a CAM, and she'll submit to any additional testing on top of the CAM that you think is necessary in order to bootstrap that in.
Okay, Ms. Truesdell, let me go to you. Any comment for the prosecutor's office?
Thank you, Your Honor. With respect to going forward in bond, people request that Ms. Roush remain remanded until the time of the trial. This court gave her the very generous opportunity to get out of jail and go to rehab. Apparently she went to rehab for some little bit of time, but then once she was able to get out of rehab, she I don't know how you could argue that she's testing successfully. I have Sergeant Ryan Colley here, who was going to testify as to the circumstances under which Ms. Roush was found heavily intoxicated with a minor child. She's a danger to herself. She's a danger to others. This whole incident came about when Ms. Roush became so intoxicated that her partner, Mr. Brown, who is not unknown to this court, caused a stir at the Goodwill Inn. I don't know if she still has the ability to be housed there or not. I don't think she should be housed with Mr. Brown. Apparently, the two of them together caused law enforcement to be called. And as a result of this, I mean, Ms. Roush didn't just drink. Ms. Roush was so intoxicated, she had to be transported unconscious by ambulance to Munson Medical Center. There was an 18-month-old child who was left with a stranger at the Goodwill Inn because Mr. Brown was picked up on warrants. I mean, she is clearly a danger to herself, and I would argue to those around her. We have a trial scheduled for this matter at the end of the month. A plea has been offered. It has not been accepted, and I think she should remain remanded until the time of trial.
Okay, thank you. Mr. Kane, anything else for you?
My understanding is some of the condition that Officer Colley found her in is as a result of an unknown diabetic condition that was revealed upon this drinking incident. My comment, which wasn't testimony, was really more argument. I don't think Ms. Roush has testified. It's really more argument is that between the time of this incident and turning herself in, or being turned in on the warrant, rather, she did test successfully. So there's been a bracketed area of testing. I'm not going to argue that Ms. Truesdale's right. The condition that she was found in was deplorable, and the circumstances are not good either. But there had been attempts at successful testing, and so Ms. Roush is exercising efforts. Extra help given to her can't be a bad thing. From a housekeeping perspective, actually, we can address that after the court's made its decision about housekeeping with the trial and a final conference.
Well, I understand the desire to have her out. I understand that there was a period of time where she was successful with that. But quite frankly, given the circumstances, I'm worried about her safety and the safety of those around her. And I know that that obviously she wants to be out and wants to be doing those things, but I think without services in place, I'm just concerned for her safety and the public safety as well. So I'm not going to grant a bond at this time. Mr. Kane, what was it that you wanted to address relative to scheduling?
So you may recall we had a final conference. Ms. Roush failed to appear, and I indicated that I thought that it was my fault, not hers, because when we'd communicated, I don't think I'd given her the date. We've not had our final conference. So Ms. Truesdale's correct. We do have an offer in this. Ms. Roush and I haven't had an opportunity to discuss that offer, nor have we had an opportunity to discuss the downside risk if she fails to take the offer, meaning she elects instead to go to trial. So trial in the matter is still set for the
28th.
Thank you. Later this month. I'd like a final conference in front of that if I could. I'd like to adjourn that also if I could, if need be. I don't know when your next final conference date is, Your Honor.
Well, so the dates that I have, because I do remember that we did reset the final conference. So I show an amended notice of final conference in the file for August 21st at 9 a.m. And then I show the trial dates as the 28th and 29th.
Okay. I have those on calendar as well. I misspoke about the final conference. Not doing terribly well calendaring in this case, so I'll redouble those efforts. But that should be sufficient for her and I to decide what to do with Ms. Truesdale's offer and to adequately discuss the risks attendant in taking it or not.
Okay, so then we'll just plan on seeing everybody on the 21st for the final conference, and obviously we'll decide based on what Ms. Roush wants to do, whether she elects to go to trial or wants to accept the plea offer, and just go from that time. Okay, thank you all very much. We're all set.
Thank you.
Ms. Miller's had the opportunity to go over advice of rights and has no questions on this. She's here on a violation. She is going to enter a plea of guilty. Wish to address the court prior to sentencing, Your Honor.
All right. Ms. Miller, did you go over this 2-page program advice of rights form?
Yes, ma'am.
Did you understand it?
Yes.
And did you sign and date the second page of it?
Yes, Your Honor.
All right. Nope.
No.
It's not signed and dated,
I'm sorry. that's
but
my fault.
if you, Mr. Zicki, if you can get her to go over that real quick. And you understand you'd be waiving the right to the hearing if I accept that plea. There will be no hearing of any kind. All right, I'm going to accept the plea as knowing and voluntarily given.
Your Honor, what I'm gonna say to the court is not an excuse for her conduct, but just want the court to know that something that apparently is beyond her control. On the day of the incident, or the day prior to being tested, her daughter was rushed into the hospital for surgery. That was just another straw on the camel's back. She reports in the last 2 months, she's been trying to evict her boyfriend or ex-boyfriend from her house. Because of his negative conduct. She's facing a foreclosure. Everything's just been overwhelming on her. She doesn't want to be, or she's asking the court if the court would reconsider about removing her from the sobriety court. She realizes she does need help. She was in rehab last fall and seemed to be doing very well until the end of May, when all these problems started multiplying and she had the trouble of coping with it. Yeah, her 93 days in jail. I'm asking the court to reconsider that. Maybe some sort of rehab program would help her out better. That's all we can say, Your Honor. It's not like a deliberate violation where, some people come into this court and they don't have any reason. They just decided they want to drink.
Yeah.
She's got situations she can't cope with, and she needs some sort of guidance and help, and begging the court for it, Your Honor.
Here's the problem with Miss Miller, and this is very difficult. This is a tough hearing for everybody in the room right now, or at least her and I and Miss Havner. Miss Miller has this case back from 2021. She was originally on standard probation and she kept drinking on standard probation. She'd never been in trouble before. So that was indicative to everybody involved in the case that she probably needed an elevated level of treatment. So she was brought into treatment court. When she was brought into treatment court, she continued, we had her in an IOP, which was a level of care that the therapist thought was appropriate. And she started escalating. She was not just using alcohol, she started using crack. So then we did everything we could right away, and everything I am saying is true, and you know it. We did everything we could right away to get her better treatment. She got a bed in Naomi's Nest, and went to Naomi's Nest for inpatient residential treatment. She was in for how long, Ms. Havner?
45 days.
Yeah, it was a long, it wasn't like she was in for 7 days for detox. She stayed in 45 days. She came out, she was gonna hit the ground running. When did she get out, Ms. Havner?
It was sometime in January that she went immediately into IOP.
Yeah, and then we got her immediately into IOP. So she's now done 45 days inpatient, second bout of IOP. She's learning all of these coping skills. That's what they go there for, right? You're learning all of these different ways that you can react to stressful situations or triggering situations besides use. We got her into peer recovery. She was in IOP. She continued to use. She finished IOP the second time and then went to standard, right? She was just seeing her therapist every week, going to group every week, right, Kelsey? Correct me when I'm wrong. And then she started using crack again.
Cocaine, yes.
Well, okay. And then she had a violation for that in May. She didn't show up for testing in June. She missed IOP in July. She had 2 positive cocaine tests in May after completing a second round of IOP.
Yes, this was within a month of completing, and then at that time we put her back into IOP again.
She's now in her 3rd round of IOP. So she's currently in treatment 3 days a week, plus she sees her own therapist, right?
Once a week, correct.
Once a week. Do you go to that group once a week too?
Yeah.
Yeah, okay. You see Sarah still?
Yes.
So she's got a peer recovery coach. You go to her meeting? Yes. And you go to AA a couple times a week. So, other than jail, there's nothing else I can do for Miss Miller. Miss Miller doesn't, we just heard this lady speak at Families Against Narcotics, at an event, this opioid awareness month. Beaumont put something on. What was her name? Tiffany Jenkins. And she's in recovery, and she talked about being in recovery, and she said she did 2 inpatient stints. The first one she did it because the government told her she had to avoid jail. And she went through the motions, she did what she had to do, and she got out. The second time she did it, she had completely hit rock bottom, and she knew she needed to change. And that's when she quit using. And Miss Miller, I don't know where rock bottom is, but she's not in this program. It's clear to me she's not using any of the resources we've thrown at her because she just continues to have use violations. She has all of these tools, all of these people she could call. She knows she could come sit in the court if she wanted to. She could call Kelsey. She could call her peer recovery coach. She could call her therapist. She could call one of the 15 girls in our peer group, in the women's group that I know she has relationships with. And she could have done all of these things. She could have went to a meeting. She could have used all of these tools, and instead she decided to use, and then she came to court drunk, knowing full well she's she's still drunk from the night before.
You know, that could be another cry for help. I know that a lecture that you heard, the lady went 2 times to IOP. This may be her rock bottom, and be ashamed to give up hope and to throw her in jail, just throwing her to the wolves. Also, Your Honor, if I could just mention, if the court is going to incarcerate her, if she can have a startup page. She's got 2 minor children at home, and the child's father is finally doing something. He never supported him, but he's filing for custody. So she does have to make arrangements for those 2 minor children.
Yeah, the problem is with keeping her in any capacity is we don't have time. Like, she's got to have, we have phases in the program. She's in phase 2.
Right.
So she just had a violation. So now it'd be 90 days without a violation before she could go to phase 3. And then she's supposed to do how long in phase 3, Ms. Havner?
Minimum of 3 months.
A minimum of 3 months. And so that altogether is 6 months that we need. And how long do we have her?
Until January 5th, so about 5 months.
We don't have time for her to graduate. We don't have time for her to finish the program.
And if they're successful during that time, they'll be well worth it.
And that 90 days is also guaranteed that there is no further violations or use violations. So it's not even a guarantee to advance within 90 days.
I know I'm not actively involved in the sobriety court, but my understanding is incarceration for long terms really does not help in addiction.
It doesn't, but neither does keep helping and helping and helping someone who doesn't want help. Like, at some point, it's like I'm just screaming off a mountaintop. She's not listening. She's not taking advantage of any of the resources. I just don't see the point in it. And it's heartbreaking, and it's so sad. And Miss Miller's been with us for a long time, and it's like we start to see her make progress, and then she reverts right back. And she's reverted right back to the point where I don't know if I can keep her. And I don't think she's expecting this. I think she thought she could use, and it was going to be like all the other times. But now time's running out. And if she's not learned anything yet, I don't know that she's going to.
Yes, that's kind of where I'm at, Judge. They say incarceration is not going to help, but clearly recovery is not helping her either. She did reach out to her peer recovery coach that day, but she didn't even talk to her about wanting to use or about to use. So, she's not going to take the step further to tell people, hey, I'm at my rock bottom, this is what's going on. I don't see how much else we can help her if she's not utilizing her tools to the best of her ability.
Yeah, today's not an eye-opener for Miss Miller. Nothing would be. And the court still has time to keep her in the program. And, down the road, 2 weeks, 3 weeks, you can still throw her in jail for 90 days.
Ms. Havner, didn't she just do 5 days in county on her last violation?
She did 4 days, Judge.
In Wayne County Jail. Look at little Miss Miller. If 4 days in Wayne County Jail, and then how long she been in now?
5. So she did 4 days in Wayne County Jail in May, and the same day that she came out, she used.
She used.
I'm sorry, it was 2.5 days I was there. Okay, so 2.5 days later, and she got right out and used, so that didn't work. And then she's been in for 4 or 5 days now.
That sort of supports the argument that the jail doesn't help in addiction.
Yeah, what, right, but neither does therapy in Miss Miller's case or any of the other tools we're giving her, because she keeps using anyway.
She had a couple months there where she was sober and no violations.
I mean, when we're 18 months along and she's still not using her resources, I mean, that's very alarming.
Yeah, I mean, at this point, these should be approximate goals. Like these should be things that she's able to do. I don't know, Miss Miller, I can't see any.
I did put the minor children's father on the consent form, so I can call him following this hearing and arrange contact.
You'll love that.
For the children, so the children will be fine.
This,
The other two are adult children.
I'm sorry. This is an individual who barely supported the children, and now he's trying to seize on this opportunity.
It is what it is.
It is what you made it.
Yes.
It is, it's what you made it, Ms. Miller. This isn't, it is what it is.
No.
This is your reality because you created this reality.
I apologize for saying that.
I mean, this is, is it good for the kids, for the ma to be, doing crack and coke and drinking when she's looking at all this jail time? These are rhetorical questions. I mean, we all know the answer. All right, I'm gonna call this other matter. Miss Miller can just sit for a minute. We'll call this other matter real quick. That's according to the guidance center. Like they can't think of anything else other than 3 stints in IOP and a residential that would help Miss Miller, learn some coping mechanisms or deal with whatever trauma she has, and this is still her first response, even with everything that we've provided. I'm gonna give her some credit for the time she's been in the program. I'm sorry, Kelsey, I lost your paper. Ms. Miller, you can still do this on your own when you're ready. If you continue down this path, I'm confident I'll see you again. What?
I don't want to be like that anymore.
All right. I'm gonna give her 80 days. Credit.
Startup date?
11. No, start now. I'm sorry, Miss Miller. This one was, you knew better.
This year on US 131 there in Martin Township, Loudoun County, state of Michigan. It's a speeding citation on an actual 91 and a 70. However, the trooper only wrote this for 6 to 10 over on a freeway. You are here, Mr. Green, on this citation to do one of 3 things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened, or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Fight the ticket at an informal hearing, please.
All right. And even though I cannot see you, I'd ask you to raise your right hand the same way the trooper is going to raise his right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay, Trooper, I didn't catch your audio there. Want to make sure it's up. Okay, so Mr. Green, it makes a lot more sense for me to start with the trooper. He has the burden to establish to me why he issued you a citation in the first place. But then after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Yes, sir.
With that, troopers, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation.
Okay. On July 4th of 2023, I was on duty
working in a fully marked patrol car in uniform. My patrol car is equipped with a radar speed measurement device that's approved for use in the state of Michigan, and I am trained in the use of radar speed measurement devices. This particular device tested or passed all tests at the beginning and at the end of my shift. At approximately 2:22 p.m., I was conducting traffic enforcement on US 131 just south of 124th Avenue, Martin Township, Allegan County. I was sitting stationary facing north. Again, at approximately 2:22, I observed a southbound vehicle that appeared to be exceeding the 70-mile-an-hour posted speed limit. Traffic was medium to heavy on this holiday afternoon. I activated the radar and obtained a tracking history of 91, 88, and 87. The radar was tracking this as the fastest vehicle. There were other targets as this visibly faster vehicle was passing other cars in the left lane. The audio matched the fastest speed readout, and there were no obstructions between the radar antenna and the numerous targets in front. Once the target vehicle, which was a white Dodge, passed my location, I turned into traffic, turned on the vehicle, following behind it southbound on 131. Once I caught up to it, north of 116th Avenue, I had a brief pace of 91 miles an hour on this vehicle. I effected a traffic stop for the speeding violation, identified the driver as Kevin Eugene Green, and his admission was he thought he was doing 81 miles an hour. I subsequently cited him for 80 in a 70-mile-an-hour zone.
Okay, and Mr. Green, what is it you'd like to tell me?
Can you hear me?
Yes.
Okay, so first of all, he said that he was tracking multiple cars at one time. I'm kind of confused that if he was tracking multiple cars at one time and they go on all different speeds, what made him assume that I was the one speeding?
Well, sir, he testified that the radar would give the speed of the fastest moving vehicle and that he visually identified your vehicle as the fastest moving vehicle. So the speed was for one car, not all the others.
Okay, so that's what I'm saying. If I'm in the fast lane and another car is, if I'm in the right lane and another car is in the left lane and we're both side by side and it's another car coming right behind us, how can he determine which car is moving at which speed if we're right next to each other?
Okay, so I can say it one more time. The radar is going to give the speed of the fastest moving vehicle. Then he's going to match that with which vehicle he is visually seeing as moving the fastest. He identified that as the white Dodge that he then pulled over that you were driving. He also testified that besides radar, he actually paced you while he was behind you and also had you at 91.
Well, I'm kind of confused because if I was speeding, the first thing he asked me when he pulled me over was,
well, let me ask you this, sir. Instead of we're going the long way, let's go the short way. How fast do you think you were going?
To be honest, I know I wasn't going no 91. I can't tell you how fast I was going a month or so ago, but I can tell you that I wasn't speeding and going that fast that he said I was. And if I was, why would the first thing you asked me when you pulled me over, like, who car does this belong? Who car is this? I felt racially profiled, like you were pulling me over because of the car. You wasn't pulling me over because I was speeding. And if I was, you would have said something to me about speeding, not who car this is and who the car belonged to and why am I driving it? I was just kind of confused at that whole situation. It was multiple cars and I wasn't speeding. So I was just kind of confused. How did I get pulled over?
All
And if
right.
I'm getting pulled,
Sir, he also said that you testified that you thought you were going 81.
sir, I said anything I could to keep him calm and just everything normal. I wasn't going
All right.
81, 91 or anything like that. When was the last time the speedometer was even checked? Has the speedometer been checked anytime this year?
Well, you could ask him that, sir.
Well, I thought I was addressing the court. I didn't know I could speak to him directly. I'm sorry.
You could ask questions. So I'll refer the same question that you're asking to the trooper because it's a relevant question. Trooper, you testified that was your radar was tested before and after your shift. What do you mean by that?
There's internal and external checks that we have to do on the radar to ensure that the display readout is accurate, that the speed readout is accurate, audio is accurate.
But that's your radar tested against your own speedometer in your patrol car when it runs that test, correct?
Correct. And the
Your speedometer is separately calibrated?
Yeah, the speedometer is calibrated at VTS, Vehicle Traffic Services, just before the vehicle's issued out to the field. It's only calibrated once unless there's some, I believe it's transmission work done on the vehicle. I believe there's one other situation, which my vehicle has not had either of those. So it's only been calibrated the one time when it was issued, and it's a 2020 model year. But we're not required to have it calibrated every year.
Anything further you wish to say, Mr. Green?
So if I'm not mistaken, if I heard you right, the car hasn't been calibrated for 3 years.
It's not required to by my department policy.
Right. So us personally, we don't know exactly if the speedometer is right or what. I'm just going off you telling me verbally that you were chasing me or you were going 91 with me. How do you know if you were going 91 if your speedometer haven't been checked in 3 years?
Because I trust my speedometer.
So you just trust your car. You're just going off of what the car said. Correct. And not what's actually going on.
Well, okay. And my own experience of driving for 35 plus years, I know when I'm going faster than 70 miles an hour.
I mean, but how would you know that if you weren't 100% sure that your speedometer is correct? If my speedometer may be off, I mean, I've been in multiple cars where the speedometer is kind of giving me issues. But either way it goes, correct me if I'm wrong, if it's multiple cars side by side and your speed gun is pointed directly at the cars, how can your speed gun determine which car is going fastest?
This particular model of radar, it detects two things. It detects the strongest vehicle, and if I have the feature turned on, we'll just call it fastest, the radar will also give me a return of the fastest vehicle. So I'll get two returns, one of the strongest, which could be any of the other vehicles in that pack that was in my radar zone, including your vehicle. And then it also gave me the fastest readout, which me visually looking down the road, yes, I have to determine which vehicle the radar is assigning that fastest speed to. And so with my 23 years of experience as a state trooper, yes, I could tell it was the white Dodge that was going fastest within the radar cone zone that was doing that 91 miles an hour.
So when you said you could determine, does the gun give you like a description of the car, making a model of the car? This car is going 91 and the black car is going 92.
No, it doesn't. No, it doesn't.
So you just like visualize it through your vision.
My training and experience, yes.
Okay, so you assumed that I was the person going fast, right?
No, I knew the white Dodge was exceeding the posted speed limit by a significant amount.
Let me reiterate, Mr. Green, we're spinning our wheels. Here's what happened. The trooper is watching cars. He already testified that visually he sees your car and he is able to say that it's moving faster than the speed limit. So what he does is hit it with the radar. The radar, which is calibrated before and after his shift, is in working order that day because it's calibrated against his speedometer, which is separately calibrated. It gives a visual reading to him, a tracking 91, 88, 87. Then it audio tones out. The audio tone matched the numbers. And then when he pulls behind you, he can pace you at 91. So in other words, 4 different ways he has you as speeding. He has more than met his burden. What I need to decide here at an informal, I would find you responsible on this citation as written. What you need to understand is because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. You can contest this further to what's called formal hearing. To do that, you must ask for that in writing and you must ask for it within 7 days of today's date. Otherwise, that window of opportunity to contest this further closes. Do you understand your rights on appeal?
Yes, sir. Can I ask one more question?
Yes.
This goes to the state trooper. I'm just kind of confused that if you pull me over for speeding, why is the first thing you ask me, who car is this? Why am I in this car?
I ask that of everybody I pull over. Mainly it's so when I ask for the registration, I'll know ahead of time if the name on the registration is going to be different, and then I'll know why it's different.
But that don't make any sense because you're already gonna know who the car belongs to once you run the plate and once I give you the registration. So you ask me,
I don't run the plate typically until after I pull somebody over, contact them, and then go back to my car. So it's just so I'm not like surprised that, hey, why is there a difference between who the driver is and who the vehicle's registered to? That's a standard thing I do for everybody I pull over.
But why does it matter who car it is? Or who belongs to it? Is it a law against?
That's outside of the scope of this. Again, it's so I'm not surprised.
It
If I
is.
see a
It's
different
irrelevant,
name,
but I'm just
no, I felt like
letting
it was
him ask
relevant.
because I know what your answer is. I know that you're not asking him because of who he is. You're asking him because you would ask anybody that. But Mr. Green, we're all set here for purposes of hearing. Because I sit here and listen to officers do traffic stops all the time.
And this sounds like it's, sir, I just feel like this is one-sided. Like you gave me an opportunity to speak, but you're really not giving me an opportunity to speak or understand
sir, you're not asking any questions relevant to your speeding citation. I have to decide whether or not you were speeding that day.
Sir, if I got pulled over for speeding, why would an officer ask me who car is this? That sounds like I'm being profiled. That doesn't sound like you're pulling me over for speeding. Because if you pull me over for speeding, the first thing I'm gonna say to you, if I'm an officer, is, sir, do you know how fast you were going? Or why were you going this fast? Or is everything okay in the car? Or where are you headed to? I'm not gonna ask you who car is this and why you're driving the car. I'm gonna ask you why you were speeding.
I believe the trooper explained his answer, sir. I'm gonna go ahead and release you. I have to move on to my next ticket.
So how do I appeal this? Do I appeal it through you or do I just call the court?
I explained that, sir. You have to do it in writing within 7 days of today's date to the district court. Thank you.
I apologize. My name is Brandon Thornburg. I was called to report. I am running a little late, to my understanding as well. So I apologize for that.
Yes, sir. You failed to appear for your 940. You were defaulted.
Okay.
So you're all set.
Okay. All right. I apologize.
That's all right. Thank you.
There's no pups in the pup cam. What's the deal with that? Where's the, oh, here's pup. Hi. I hope everyone's having a fabulous evening this evening. I feel like something's wrong. I don't know why. Maybe it's because I have my camera out. I don't know. Maybe it's because I'm doing a live this late in the day. It's really odd. It's really weird. I should be in bed. I woke up late. Had a weird day. Very weird day. It's because I had a weird night. You see, Cha, I can't say your name. I was going to put it on a card. Chada Skadum. Yeah, that. I want to thank her for sending me down this rabbit hole. I don't really know if thanks are in order because it was a weird one. Totally freaked out. I can't remember her whole username. I remember the Cha and I remember the Dum. And I don't want to call her Dum Dum, so I call her Cha because Dum Dums remind me of the lollipops. Which, by the way, did you know those things come in like a cinnamon roll flavor now? Like, what? Like ruining my childhood. Those things were the best. Cinnamon rolls? Really? Like, that is not a lollipop flavor. Like, where's the good old-fashioned mystery flavor? Lollipop. Cinnamon roll lollipops? Really? Chadaskadum. Chadaskadum. Fuck, I can't do it. All right. I had to write notes on this one because it is like way too much to like try and remember. But the whole point of it, she sent me the link to this and she's like, hey, check this out. Name change in prison. And I was like, oh, cool, small town. I love small town justice. It's like my favorite stream to watch. So then I was trying to figure out her name. Of course, here. Thank you for typing that out for me. So I'm trying to figure out what her name was previously. And if it was always Tracy or if she had changed it before or whatever. I don't know why my brain goes to weird places. And then I found the dockets, which led me to the sentences, which led me to the original charges, and then to a Washington Supreme Court appeal by her partner in crime, like literally partner in crime from 2005. But before I tell you that story, because that's the rabbit hole, let's just watch the name change video because, you know, that was why we were here. Don't tell me that. It was a mystery flavor. It had a flavor. It had a name. It was very important because, you know, we always spent hours guessing what flavor ours was. It had to have a flavor. Okay. Which one's the stream? This one. Oh, look, putt putt.
I have life without parole.
Oh, sorry. Guess we need to start at the beginning. My bad. Totally not prepared today.
Just need to unmute. Can you unmute, please?
I hear something. Can you hear me, Mr. Corbett?
Yeah. Yes.
Oh,
It's miss. It's miss.
Yeah, I know. There you are. We usually have a pretty good connection from where you are, so that was a little weird, but we got you now. So, yeah, I know you want to change your name. I've read your petition. So, how do you say that middle name? You're trying to go to Tracy Calais Fox Pony. Does that sound right?
Yeah, Colay, Colay, my mom's name.
Oh, that's okay. Yeah, I wondered what that was about. Okay, so the couple questions for you. When are you getting released from prison?
Never.
Oh, you're in there for the run, are you?
I have life without parole. I'm a 3 striker though. I'm a low level 3 striker, so I will get released. It's gonna be a long time though, right now.
Right. Okay, yeah, that's what I meant. You don't have an anticipated release date, apparently.
No.
Okay, well, that might make my next 2 questions sound kind of stupid, but that's okay. Usually the concern is, are you going to have to register as an offender, you know, like a violent offender or sex offender?
No.
Kind of a thing. Right.
No, I don't have to register for nothing.
If I
ever get out, which I will get out, but I'm not a sex offender.
Which that actually made me think, why don't we have like a murder registry? Like we have a sex offender registry. Like it's super easy. They're in jail. Just keep a record of it. Put it on the internet. It's not even hard these days. Like a preschooler could do it.
Okay.
Be really
And so
helpful.
obviously, I'm assuming you don't have anybody tell you got warrants for you got warrants out there anywhere?
No,
Okay, all
I've
right.
been in
So
prison, I've been in prison
right.
18 years.
Oh, okay. All right. Well, we're going to go ahead and grant your order. And you're at Clallam Bay, aren't you?
Yeah.
Okay. Well, we're going to sign an order that says you're a Tracy Coley Fox Pony.
All right, thank you.
Well,
I believe the last name is Fox Pony. I'm actually going to go back like a couple seconds, and I want you all to listen and tell me if I'm wrong. I listened to it like a dozen times and I couldn't figure it out.
Coley Fox Pony.
All right, thank you.
Well, you're welcome.
When will I get that? Will I get it in the mail?
My clerk knows all the answers to those secret questions. What do you say, Ms. Freeman?
We can send them a copy, Your Honor, but it has to be recorded with the auditor's office.
Right.
And get a certified copy from the auditor's office.
Right. Yeah, what she's telling you, I don't know if it makes sense or not, but even though we can grant an order saying you got a new name, we can't record it for you. You have to do all the recording stuff. You know what I mean?
All right. All right.
All
Thank
right.
you.
We'll send you a copy. All right.
All right,
Thank you, Miss. Thank you, Miss Freeman.
Thank you.
All right. Bye-bye.
Yes, the judge was exceptional. And what like makes it even more is the fact that it's a small town and that's not the norm in this small town. I was thinking about it and I was like, if this took place in Florida, like this would be a whole different bag. What is it? Bag of worms? I don't even remember what the saying is. But anyways, okay. What I found interesting, but first, the getting released is debatable. We'll get to that in a second. Second, why would you change your name if you're a lifer? It costs money to change your name. You have to pay a filing fee and all of that. And you have to file it. And money is hard to get in jail. And isn't it better spent on commissary than a name change? So tell me if I'm missing something, because the only thing I could think of would be it would force the guards to call her the new name. But she's not changing her first name. She's just changing her last name. So, I mean, I assume they usually call them by their last name in prison because there's probably 500 Johns, or what's the other popular name? So that's really the only thing I could think of would be to make the guards call her Fox Pony. I don't know if that has some meaning or not, but I don't know. So I wasn't able to determine what her birth name was. Her name going into this was Tracy Conrad Corbett. And at the end, it is Tracy. No, I can't remember it. Connie Fox Pony. So I thought that was interesting. The prison face tattoos were interesting. Personally, I want to know how she's stuffing her bra and where she got a bra from. It fascinates me. Like, how does this work? Because she's in a male prison. So where does this come from? Anyways, so to the story. As they mentioned in the stream, she's housed at Clallam. There's an L. I always miss that first L. Clallam Bay Correction Center, which is a medium, close, and maximum custody level facility that has the capacity for 858 male inmates. There are no female units, and there's no mention on the website or anywhere else of any special units or anything like that. So that's where I kind of got a little fascinated with it. Like, that's bold. I mean, that's dangerous in some cases to, God, I can't think of the word. Become trans while in prison. God, sorry, MS brain at night. I can't think of words. So I I don't know, I was kind of like, wow. So then I started digging into it because I was like, so lifer, what are the charges? Is it really life? How long is she in there for? So I pulled up, what I could. And turns out back in October of 2004, Tracy Conrad Corbett, which is the new Mrs. Fox Pony. I wonder if it's almost like when you get married, whole new name, whole new persona. It's kind of cool. Anyways, had a buddy named Franklin Simpson. Franklin drove Tracy to the Flying Bee gas station in I need Shaw here to pronounce these names for me. Okanogan, Washington. Tracy entered the gas station, robbed it, shot the clerk twice using Franklin's gun, and then fled with Franklin in Frankie's truck. And I even found a news clip. This was all that was in the news, though, which surprised me. Like, usually when a convenience store gets robbed in 2005, that was big news, but apparently not. Yeah. So the clerk survived, and both he and a witness that was on scene reported the truck to law enforcement. Within minutes, the deputy located the truck. They were pulling into a driveway of what I'm assuming is one of their houses. Tracy fled on foot, and Frankie was arrested. So it didn't take long before they located Tracy. And see, that's where I don't know. I don't know if it was a he at the time or a she at the time. So I don't know the correct pronoun to use. They were arrested, and there was a multitude of charges. There was more than 20 on the background check app that I used. I mean, it was probably closer to 30, 35. So I have no idea what the actual charges were and what the convicted charges were, because the state of Washington migrated their systems sometime between 2005 and now, and all it says is adult criminal. So yeah, I'm pretty sure those tats are prison tats. But, you never know. That there were convictions prior to that, but again, all I could see was criminal, adult criminal. Couldn't tell you anything. So I can tell that the disposition on this case was guilty on 4 charges with 5 of them dismissed. And on February 2nd of 2005, there was a guilty plea entered with a plea agreement and a recommended sentence. And in the sentence description, it reads, prison, life without early release counts 1 and 2. 116 months counts 3, and 29 months count 4. So that's life without early release, 116 months. How many years is that? That's like over 10 years. At 11. Right. Oh God, I can't math. Oh, 9.6 years. Yeah, 20. Yeah. Then plus another 29 months, which is more than 2 years. So I don't know what that whole I'll be released thing was. There were appeals. The appeals were denied. So it was a plea agreement. You accepted the plea agreement. You only have limited grounds to appeal a plea on. So you're done. Sorry, sister. Like, it is what it is. But Frankie, on the other hand, Frankie was charged with attempted murder, attempted first-degree murder, robbery in the first degree, theft in the second degree other than a firearm, rendering criminal assistance in the first degree, driving while license suspended or revoked in the second degree, solicitation to commit theft in the third degree, possession of a stolen firearm, and unlawful possession of a firearm in the second degree. So the state later dismissed the theft in the second degree other than a firearm, because give a guy a break. He did not accept any plea deals and went to trial, which lasted 6 days. It was quite the trial. I really would like to see a transcript of that. So at trial, the state called it says Mr. Corbett in the appeal. So maybe she didn't transition until then. Transition. See, that was the word I was trying to find earlier. My brain is so jacked. Seriously. Sorry, I'm not trying to ignore your comments, but I can't look at 4 screens at once, just one, so we'll look at them in a minute. Right? But I think it was Clyde and Clyde back then. I don't know. So the state called Tracy to testify. He answered no frequently and responded twice that he did not remember. So the state moved to have the court declare him unavailable as a witness and to admit his prior deposition testimony. Sorry, I was trying to see where I was at. So the court allowed his lawyer to inquire, and they ultimately concluded that he was unavailable because of his refusal to testify and him being so uncooperative. So the jury ultimately found Mr. Simpson, which is Frankie, guilty of second-degree murder, robbery in the first degree, rendering criminal assistance in the first degree, driving while license suspended or revoked in the second degree, possession of a stolen firearm, and unlawful possession of a firearm in the second degree. The court dismissed Frankie's conviction for rendering criminal assistance in the first degree at sentencing because it would be unjust to have additional punishment or additional conviction for count 4 rendering criminal assistance because his liability as an accomplice was really no different than rendering criminal assistance, is what they said. So let's get this off of here. Pull this up here. This gets really interesting. It's a little law nerdy. Sorry, I showed you all the good stuff already. Why is this not showing up? Oh, I put it up on my screen. But it also is kind of the interesting part. So he filed an appeal. Frankie, we're talking about Frankie now. Tracy is done. Dunzo. Sorry, life plus 116 plus whatever. So Frankie, the accomplice, who I couldn't find a mugshot for, I'd really love to see a mugshot, files an appeal on various different grounds, which we'll talk about a couple of them. But then the state files a cross appeal, which is pretty rare. You don't hear about it very much, challenging the court dropping the rendering of criminal assistance in the first degree conviction. So, all right. So basically, this is the appeals court is reviewing the trials court decision on multiple grounds. And they're basically determining whether the trial court erred in concluding that Mr. Corbett was unavailable as a witness. And a couple other grounds. So, 6-day trial. So this is what we just talked about. The court, he frequently answered no and said he didn't remember. So they just read his prior deposition in lieu of his testimony, which, you know, you've seen that in cases before. Usually it's civil cases, not criminal, but so they called him to the courtroom before the jury entered, and he told the judge he did not have anything to say since he already told the state what he knew. I'm a little curious whether testifying was part of the plea deal or not, but I'm not sure. No, I'm not saying nothing. I mean, I ain't got nothing to say. I already said what I said. You guys bring me back here and hold me in the hole, you know? I just want to get back to Shelton. I don't know what Shelton is. I'm guessing it's another prison there. So the judge told him he would put him under oath, and he asked him to listen to the questions and consider answering. As they questioned him, he responded, yes, no, I'm not sure. I don't know. I don't remember. When they asked him about the robbery, he refused to admit he did it or that he was armed, even though he had already been convicted of it by this point in time. He had pled guilty to it. And they requested the court find him unavailable after he provided numerous no responses to things that were obviously true. They let his lawyer question him, and that didn't really do any good. So the court concluded he was unavailable because at this point he has answered that he went to the gas station and some people and some accused him of robbery there, that he was there alone, but he's not answering questions about having a firearm or committing robbery or doing any of those things that he testified to before in his deposition. So they found that his persisting in refusal to testify and testifying to lack of memory, the court allowed his deposition in. Oh. And if you all are interested, I can post this up if you want to read the citations and things. You know, I don't usually get as deep as John into that. So basically, the appeals court found that in order to argue that, you have to timely object to the, let's see. Oh, first, the witness's responses easily support the trial judge's conclusion that he was unavailable because he was an asshat and didn't answer the question. So they affirmed that decision. And then this was another thing he appealed on, that there was improper evidence to preserve on appeal, which was another non-issue that they affirmed. But then he argued that they were making corrections to the deposition because they misspelt names. You know, court reporters often don't have the spelling of names, and way back then, things weren't quite as digitized as they are now. And the transcript had some incorrect spellings and things like that. So as they were going through the deposition, it wasn't really supposed to be submitted as evidence, so nobody ever proofread it and fixed it. And they were doing that during court. And so he argued that, you know, changed it, which of course it didn't change the meaning of it. It just, yeah, I don't really know. So he also appealed on the grounds of ineffective counsel, which I'm not sure where that is. I think that's up at the top. But he's saying that his lawyer did nothing to assist him. He said little, if anything, to represent my interests. He didn't make an opening statement. He didn't call witnesses. He didn't offer exhibits. He didn't cross-examine the state's witnesses. And during closing arguments, his lawyer argued that he had been drinking and driving and that he lied to the deputy that pulled him over. So, you know, the appeals court found that his lawyer cross-examined most of the state witnesses, like all but 3 in a 6-day trial. His lawyer argued that he was scared and drunk when he lied to the deputy, and that's why he lied, which it was proven that he lied. And his lawyer also argued that his intoxication was inconsistent with the state's argument that he was the mastermind of the crime. That was the whole premise with all these charges, that he is the mastermind of the crime and he told Tracy what to do. And Tracy was the puppet doing what he wanted. So they denied his appeal for ineffective counsel. So then, to get to the interesting part, the cross appeal for the dismissal of the charge of rendering criminal assistance. So they dismissed that because they thought it was going to be like a double jeopardy charge. Like, okay, well, you're already charged for this part of it. If we do this, then you're kind of getting charged twice. And basically what this says is they both went to the gas station. Mr. Corbett went in. He robbed the store. He shot the clerk. He was using Mr. Simpson's gun. They both fled the scene in Mr. Simpson's truck. The store clerk called the police. The deputies located the truck within a few minutes. Mr. Corbett, Tracy, took off running. And Mr. Simpson tried to drive away, but he caught Frankie. He said he was the only person in the truck, denied Tracy was there. And they arrested him anyways. They said the dismissal here was only appropriate if Mr. Simpson's constitutional double jeopardy rights were violated. So rendering criminal assistance in the first degree and accomplice liability for attempted murder in the second degree and first degree robbery do not contain the same elements. So evidence that a defendant provided another with transportation or another means of avoiding discovery or apprehension is necessary for rendering criminal assistance, but not for accomplice liability. The evidence that a defendant aided or agreed to aid another in planning, committing a crime is necessary for accomplice liability, but not for rendering criminal assistance. So the trial court erred when it dismissed that conviction. So they denied all of his complaints. And as a bonus, for filing his appeal, he picked up an additional charge. So good job, Frankie. Good for you. Good job, buddy. I thought that was great. You're not quite as law nerdy as me. Maybe not as great as I thought it was pretty good. Because, wow. So I went looking around and there's way more. He has sued everybody. And it doesn't look like he's doing any of it pro se. It looks like he's got attorneys. So somebody's paying some legal bills somewhere. He is, Penny, you're not on the pup cam. Go get on the pup cam. Look at all those toys I gave you. Go play toys. Go play toys. Come here. She's like, do I have to, Mom? Oh, I know. It's like so hard. Say hi. I know. You're so tired. So I don't know how he is affording it in prison. That's what I'm curious about. And I tried to find more. There was a couple different lawsuits, but I can't find much information about the actual cases themselves. I would have to file a FOIA request and it would take, 10 years for the government to respond to that and actually, send something decent back to me and things like that. So I don't have a lot of answers, but I'm still fascinated by the name change in prison. I don't know. It just kind of blew my mind. And I feel like at some point they're going to have to do something because not all areas are as accommodating or as understanding because that's just the culture. And is it really fair that trans people have to be locked in a special unit, a segregated unit, and they have to be segregated from everybody else? Because that almost seems like we're bordering on being prejudicial and things like that. And as we're moving forward in the world, it seems like there's going to have to be, I don't know, some solution that provides, they have to make 4 prisons? I don't know. I don't know what the answer is, but I feel like there's going to have to be some change to that system as time goes on. Right. It's happening, and they're either in Gen Pop and just have to deal with it, which in some cases there's no problem, but in some cases, people are mean. I know how mean people are just on YouTube. I can't imagine in a prison. I just can't. It can't be pleasant at times for some people in some ways. So yeah, I don't know. But anyways, so it is actually surprisingly easy to get your name changed. I didn't realize how easy it was. So, right. And at some point, somebody is going to sue or something on constitutional rights grounds to say you know, it's not fair that I have to be segregated. But then again, you know, Florida just rolled everything back and in schools. So I don't know. You're probably right. You're probably right. And I don't have any solid knowledge to back that up on other than, you know, my research and extensive true crime shows. Probably not many, but I mean, I know a lot of people who, I wouldn't say a lot, I know people who have shared their experience with me. I've watched, you know, documentaries. I'm not talking like 60 Days In and shit. I'm talking like actual documentaries, but that doesn't mean I understand it. Yeah, I think it depends on where you're at. I really think it depends on where you're at and what the culture is, what the politics are. Yes, it is. Yes, it is. Oh, that sounds interesting. You like went in a prison to play Christian rock? That's cool. That's really awesome. That's really awesome. All right, so I didn't put as much together on that as I thought I would. There is a lot of information in that appeal, and like I said, there's multiple appeals. If you want to look it up, just Google Franklin Simpson and the Akana. What is it with me and names today? I can't do it. Akenosen. Oh my gosh. I'm a hot mess. I don't even know what to say. Where's it at? Where's it at? Where's it at? Ah! Okanogan. That's the county in Washington. So if you Google Franklin Simpson in that county, it comes right up in very top of your Google search results. What docs? I might have missed something. Who's the docs? I missed the docs. But anyways, so this all happened in tiny little small town, you know, Washington, with the adorable Judge Hennepin. I don't even have words tonight. I don't even know my name. Look, my name's not even on the screen. I don't know who I am. Why is my name not on the screen? Everything's broken. Why is everything broken? Okay, so that's all I got for you. Sorry. I've been busy. Trying to life. Life's been fun. But I will try and get some more. I'm working on a very big, you know, every once in a while I have the big video that takes me like a month to put out that 12 people watch. So I am working on one of those that I think you all will enjoy, and hopefully I'll have it out in the next week or two. But thanks. I try. You know, not quite as interesting as it could have been, but you know, I'm not quite with it today. I don't realize I'm not quite with it until I start talking, because I go the whole day without talking, and then I get on here and start talking, and I'm like, oh yeah, I should have stayed in bed. My brain's like mush. But hey. Oh. I never got that impression. It's hell. So speaking of prisons, have you guys like seen some of the shit that's going on with the Fulton County? Like somebody else died in that unit where the guy died not that long ago. It's the I think it's actually a psychiatric unit is what they call it. But it's basically the mental health unit. And you know how long people sit in Fulton County, right? Like forever and a day. It's infested with bugs, and like they showed pictures of it. And there was the story that we talked about a long time ago where the guy was literally like eaten alive by bed bugs. Yes, somebody else died in the same unit. And they said they're going to have a state investigation and all of this, and people are getting involved. But basically, it's so overcrowded and they're so backlogged in doing any of the indictments and everything else that yeah. So when I did that mental health video, I researched it, and it basically said if somebody with a normal conviction or charges sits in jail for a week waiting for their indictment and everything, someone with mental health issues is going to be in there 6 weeks. And you know, in Fulton County, normal people have been in there for 300 up to 600 days without indictment. I mean, just listen to one of Manning's bond streams, and the numbers she calls out are unreal. And they finally put something in place where after 90 days, if they're not indicted, they get bond. Not always a cheap bond, but unless it's, I think there's a couple things that don't qualify, but pretty much everything qualifies except murder and, you know, the high end stuff. But I don't believe when somebody's on a mental health hold that qualifies. So that unit is so overcrowded. They said people, you know, are sleeping on the floor and everything else. And it's tragic and unbelievable. Oh yeah, that's totally normal. That's like normal stuff. Their prosecutor's office is so backed up, and I have to wonder, is it because so many resources are going to this YSL trial? And how much else is going to the Trump stuff? Like, why can't we make this happen? Because I've watched a couple other cases where they're like in and out, indicted, like solved everything in weeks for some high-end people. So why can't this stuff get going? Why are files sitting on people's desks for 600 days? I don't get it. It blows my mind. I can't process that. That's like 2 years of your life. Like, they are never going to get that back. Thank you. I try. It's hard. Hey, if oh, that was what I was gonna do. I don't know how many of you guys appreciate, you know, true crime stories, but I posted it in the community section. I went and that's when my brain's fried. I spent the night hanging out with Beefy last night. Whew. That's what it is. His fault. So I just put a link in the chat if you're interested. It was a awesome stream. It was a ton of fun. It's Beefy and Alistair, and they have a true crime podcast. And they talked about The Woman Without a Face. And it is about a serial killer who was tracked through DNA across multiple countries in Europe. And it's absolutely fascinating. It really is. And I knew nothing about the case. Alistair knew nothing about the case. We went in like blind as we were going through the story. And my mind was blown when we found out, you know, when the case was solved. It was super interesting, super awesome. And it was a fun stream. we had a lot of fun. So check it out if you get a chance. Like I said, I put the link in the description, and it was really entertaining. And then at the end, for some reason, we had a let's talk about Meg session. So I don't know if anybody wants to know that, but hey, if you want to know my life story, we laid it all out there. The podcast, was that theirs or was that somebody else's? I watched the Netflix one. Yeah. So anyways, I will try and get back to it and get some videos done. I have been a little preoccupied doing my missing person true crime stuff. There's a Chinese national who met a man online who is a Marine. I'm here. I might as well just pull it up and show you. Supposedly a Marine, former no, not Marine. Sorry, I'm getting cases mixed up. Former Navy SEAL. And he lived in California out in the desert. Not in the desert, but one of the desert towns. And she wanted to go basically on vacation from China. She was going to come here, hang out, and she asked him to be her guide and take her camping and things like that in the desert. And there it is. And he agreed. So she flies over, she takes a train from LA down to San Bernardino or to Palm Springs and meets up with him, and they go to Joshua Tree, and then they come back and she's checking in with her family every 2 days. She's got a grown daughter and she's checking in with them. And then all of a sudden, end of July, she stops checking in. Like nothing. It was like July 20th. And then her phone is shut off and there's nothing. And then a couple days later, his phone pings in some remote desert town and then nothing. And the authorities have them classified as voluntarily missing because they decided to go camping in the woods, and they're out there by themselves. Like they decided to go out there. Yeah, they went camping, but nobody goes camping for 4 weeks in the 150-degree desert and then shuts their phone off. I mean, you got to play Candy Crush to fall asleep. So nobody's really looking for them. And her daughter doesn't really speak English and is posting all these things in Chinese, trying to get, attention, but they don't have anyone over here. And he doesn't appear to have family out there. So I have been researching this case and following it and watching it because it's not getting any attention. And it just blows my mind. Like these two people, like their phone stopped working almost at the same time. And they're out in the middle of nowhere in the desert. Why is nobody looking for them? Like, why is nobody doing anything? Like Carly Russell walked off the side of the road and the whole world stopped. Why can't we spend like an hour or two just checking out the side of the road to see if they went off in a ditch or something? It doesn't take that long. I don't know. It just bothers me. So it's because they don't have, people haven't picked up on the story. It hasn't hit the media. I think that's what motivates people. There has to be either the family has to put pressure on law enforcement or the media has to put pressure on law enforcement. And neither of those things have happened. So this story has just kind of sat. They reported her missing on like the 24th of July. It's been almost a month and nothing has been done. Nothing has happened. And she's still classified as voluntarily missing. Blows my mind. So anyways, that's where I've been getting lost lately. Quick vent. All right, you guys. Everybody have a great evening. And for those of you who were in Bryant's the other morning, I'm still trying to figure out how to auto create content for the other channel. I'm trying to put together a channel that has kind of just I don't know, affirmations or something that just play on the screen all day that has the chat room open. So if people want to go in there and hang out, they can. Like, have someone to talk to during the day, because a lot of people don't use Discord and a lot of people don't use Twitter or Facebook or whatever, that and have trouble connecting and have said that they don't have anyone to talk to during the day. So I feel like if I put that open, it's always there. And if you need to pop in and talk to someone or just want to watch positive things on your screen, it's there. I mean, it doesn't cost anything to do. So as soon as I can figure out how to make like hundreds of images at once, I will have that up. Oh, we're going in circles. It's bedtime. There we go. Flop. Dogs, I tell you, drive me crazy. All right, everyone. You have a put a few dad jokes in there. I have to get those from Mike's stream. Who is that? He's got the dad joker. Andrew. Okay, everyone have a wonderful, wonderful evening, and I will see you all soon. Take care.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you. All right. Are you Mr. Barnes, Javon Barnes? Wave your hand if that's you. Ooh, okay. All right. So this is position 10 now, Ms. Flack. It's 23 CP 219-400. 68 days without indictment, no bond as of 6/16. Unlawful for a person to be employed or associated with a criminal street gang to conduct or participate in criminal street gang activity. Unlawful for a person to commit the offense with the intent to obtain, earn membership, maintain, or increase status in a gang. Unlawful for a person to acquire and maintain through criminal gang activity or proceeds derived from such. Possession of a firearm or knife during the commission of a felony. And armed robbery.
No prior arrest history.
All right. Go ahead, Ms. Flack.
Thank you, Judge. Mr. Barnes is 18 years old, Judge. At the time of before his arrest, he was living with his mom in Douglasville. He is a lifelong resident of Georgia. His father is present, Mr. Jonathan Barnes. He's present on Zoom if the court would like to hear from him. His mom is also present watching remotely on YouTube. Judge, if he's released on bond, he will be living with his dad, which I think makes a big difference in this case. His father is retired law enforcement and currently is employed as in security industry, but was employed as law enforcement with Georgia's state of Georgia, as well as City of Morrow and Florida Department of Law. He is presumed innocent of these charges, Judge, and I can assure you that Mr. Barnes is not a gang member. But nonetheless, I understand this is not the appropriate juncture to debate the facts in this case, and we look forward to doing that at the appropriate time. He does understand the serious nature of these charges, Judge, and upon his arrest, he was actually pulled over. He wasn't aware that there was an active warrant, but when made aware during this traffic stop, he was peacefully arrested. And in fact, law enforcement, he asked to call his dad. His dad was allowed and permitted to come to the scene to retrieve the vehicle. And so that happened peacefully. And I think that's important, Judge, because if he's released on bond, I'm asking that he live with his dad. His dad and he are very close. He listens to his dad. He's very close with his mom as well. But there's sort of that added layer of accountability that his father is here to ensure that he will comply with any conditions that this court see fit. In addition, because of the serious nature of these charges, Judge, and because he's taken these charges very seriously, he was also evaluated by Gary Davis, who's the CEO and founder of the Next Level Boys Academy. I don't know if the court is familiar with that program, but they do extensive work in Fulton County with people charged with very, very serious charges like this, some even more serious. So since his evaluation at the jail, he has been accepted, and I do have the acceptance letter, which I'm happy to provide to the court. Mr. Davis is also available to log on to Zoom if the court has questions, but he would be required to participate in this program DA Fonnie Willis is very familiar with this program and has endorsed it. And so I would add that adds sort of an added layer of accountability to ensure that when he's out on bond, he will be living with his dad in McDonough and Henry County. So he has no need to be in Fulton County other than he will be working. He does have an opportunity to work for Penske, which is in South Fulton, if the court would allow that. But he can also be banished from Fulton County because he can attend Next Level Boys Academy, which is in Union City. But if the court doesn't want him in Fulton, he can attend that remotely. Obviously, it's more ideal for him to attend Saturdays. He would be attending that 2 or 3 times a week with Next Level, be given a mentor, doing community service, working on life skills, communication skills, and all of the things that I think are important for somebody as young as he is. If he's released on bond, Judge, he'd be living at 125 Ashton Brook Drive, McDonough, Georgia. Again, we'd ask for an ankle monitor. We are fine with an ankle monitor. There is nothing before the court to show that Mr. Barnes wouldn't comply with any order of this court. Obviously, there's no criminal history. Any other conditions, curfew that the court see fit, we are asking for. So I'm asking for a global bond of no more than $30,000, ankle monitor, and any and all conditions, as well as requiring him to participate in the Next Level Boys Academy.
All right. What says the state?
Good afternoon, Judge. This is ADO come for the state.
Good afternoon.
Your Honor, the state's position is that the defendant is a member of a violent gang. This armed robbery was a violent armed robbery. The victim, in fact, was pistol whipped and bled while she was being robbed, and the individuals were armed. The state's position is that the defendant is a member of a gang. He and his fellow gang members robbed the victim twice, the same victim. So the state's position is that for each gang count, we'll be asking for $50,000. Inherent is, if you're a member of a gang, inherent in being a member of a gang is that it's a violent gang. I believe he's a member of the Bloods. Inherent is their violence. Inherent is they commit crimes. Inherent is that they commit violent crimes. The state's position is, if Your Honor is going to grant a bond, we would ask for $50,000 each on the gang counts. I believe he has 4. That'd be $200,000. And then for the armed robbery as well, we'd be asking for $100,000. That would be $300,000. We'd also ask for no weapons, no replicas of weapons, no association with gang members or known gang members, no gang affiliation, no flying of colors, no social media, and obviously stay away with his co-defendants. I believe his co-defendant's name is Mr. Mbaki. Last name is spelled Mbacke. I don't know if he has been through yet, Your Honor, but we would ask that you have no contact with him as well, and obviously with the victims as well. That's the state's position, Judge.
Judge, if I could just add, we have no issue with no contact with anybody that the court see fit in this case. I would ask though for, I think that bond is excessive. If we're talking about a gang member, that the very office has consented, the DA's office that is, has consented today to a RICO, arguably the biggest racketeering gang case that office has ever seen for the President of the United States of America. And that consent bond was $200,000 for somebody with multiple open indictments. Mr. Barnes has no prior arrests. This is his first case. And so to ask this court to issue a bond to an 18-year-old kid with no record, no history, with all we have is one simple arrest warrant, not an indictment with multiple counts and multiple co-defendants. To ask this court for a $200,000 bond, I think is just inappropriate and is punitive at this point. So I'd ask for a bond of no more than $30,000.
Ms. Oakham, anything else? Did she freeze?
Your Honor, I would note that the RICO charge for the $200,000, he's not a violent gang member. I would just note that for the record, Judge.
I just read that.
I think that's arguable, Judge.
All right, let's see. So, and he's the gang that he's allegedly a member of is Atlanta Blood Gang. Is that correct, Ms. Oakham? Is that what you're suggesting?
It's the Atlanta Blood Gang. To be specific, the Inglewood Family 9 Deuce Blood Gang.
Okay. All right. So no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no social media presence, no wearing your colors, No further contact with any gang members, affiliates of gangs, people wanting to be gangs, thinking they're a gang, the Atlanta Blood Gang or the Inglewood Family Blood Gang or any other gangs. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. Also stay out of Fulton County except for court, meetings with your lawyers, and employment, but you have to give a schedule. If you're not working there, sir, don't try me. Don't say you don't get a job and then quit it and go back and forth, because the ankle monitoring company, they send a printout and they look over it. All right. So stay out of Fulton County. If anything else, and I think your dad's on here. You're 18. Has he completed his GED? Does he gotta go back and complete his GED?
Yes, Judge, he completed Woodland High School.
Okay, let's see. Dad, is there anything else? I know you're on here that you need from this court to give you a helping hand.
No, sir, Your Honor. Myself and the other half.
All right, so you just got to follow the rules of your dad's house, okay? If your dad tells you go outside and cut the grass, cut it, go back in, ask him if he likes it, and if he doesn't like it, you go back out and cut it again. All right, until he's satisfied. Anything he needs you to do. And if your dad comes out of pocket any money, you're to reimburse your dad either in sweat equity or dollar for dollar what he has to pay. Because this is not a dad problem, this is a you problem. All right.
And just so I'm clear, Judge, is he not permitted to attend next level since it is in Fulton County?
Yes, okay, and he can attend the program that is called Next Levels, right?
Next Level Boys Academy.
Next Level Boys. You can attend that, but you have to let them know when you're doing it, okay? All right, so all right, 40 on each gang count, 10 on the possession of a firearm or a knife during the commission of a felony, and 40 on armed robbery. So it's 40, 40, 40, 10, and 40. Best of luck to you, sir. The ankle monitor will be paid for by the county.
Your Honor, that concludes my matter. May I be excused, please?
Yes, ma'am. Good to see you
Thank you,
again.
Judge. Have a good day.
All right, thank you.
We can proceed to sentencing. So Mr. Matoizik, I assume by now it's about a month. You've had an opportunity to review the pre-sentence report. Is that right?
That's correct, Your Honor.
Any additions, corrections, or deletions?
Before I get to the guidelines, on the face sheet, it should indicate that I'm his lawyer. Also, the jail credit should be adjusted.
So let's start with that. That's on the CFJ 145, page 2. So we'll get your name in there. I'm sure that's someplace else in here, but Ms. Vanderveen will get those corrections. And what's our updated jail credit?
87 days.
87, do you concur that?
That's
all right, so make those changes to 87. What else do you have?
And the sentencing date obviously has to be today's date.
All right, we'll get that changed. Today is the 17th of August. Okay. And what else do you have? What other changes?
Well, I'm just going through here.
Oh, okay.
My client, on page 7, and the victim's impact statement.
Mm-hmm.
That second paragraph. And about the middle of that paragraph, she reported discussing this with Mr. Deakins, and he refused to take her into DeVos until CPS involvement was discussed. My client disputes that he ever said that about a refusal.
So we'll just add a sentence that Mr. Deakins disputes.
And in that same paragraph, Your Honor, the third sentence She advised that Kiera struggles with anorexia, and I think that should be Carissa instead of Kiera. Just to be accurate.
Well, it does say Carissa. She had set up Carissa.
She advised that Kiera struggles with anorexia. According to my client, that's not accurate.
What else?
On page 9, under comments,
Oh, I see. Go ahead.
almost all the way to the bottom, a couple sentences up. She advised that defendant did lose his job as a school custodian when this occurred. He disputes that. That is not true. He did not lose his job.
All right, what else?
And that follows under employment. The Elk Rapids Public Schools fired my client, disputes that he was not fired.
Well, let me ask Ms. Vanderveen, was that as a result of contacting school, or was that a result of information taken from the families? Okay, so we can just put that he disputes the same.
On that same page, under marriage, Brendan Deacons, the address should be 9466 instead of 9464.
All right. What else?
And then as far as the body report, nothing else, Your Honor, but I do have some challenges to the scoring.
All right, what do you want to start with?
PRVs, no dispute there, Your Honor. The OB8 is scored at 15. We believe that that should be scored as 0. I think it was scored at 15. I think why it was scored at 15 because the alleged victim was sent to a bedroom or something like that. I think that's why it was scored at 15. I don't know for sure.
Well, let's start with Ms. Vanderveen. She did this, so can you help us out? What was your thoughts as far as OB8 and 15 points?
Both victims were locked in the bedroom with him.
Okay.
Go ahead. Thank you, Your Honor. Looking at the case law, merely incidental movement. In the Thompson case, People v. Thompson, 488 Mich. 888. 2010 case where the sex occurred in the defendant's bedroom. OV8 was improperly scored in a case of criminal sexual conduct because of any movement of the complainant from a common area to the bedroom to effectuate the criminal sexual conduct. Crime was not merely incidental to the commission of the offenses and did not amount to asportation. So I believe that should be scored at 0.
All right, then Mr. Valet, what's your response on OV8?
I think there was both statements made and certainly in the reports that he had locked the child in there, that in fact, I believe the mother came to the house at one point and had him locked in. And I think that by itself, the fact that it was in the bedroom by itself, it wouldn't necessarily be where it is. But when he locks her in the room in an attempt to keep clearly from people, mother and from the other children away, I think that it is clearly done for the purposes of securing his ability to commit the crime and to ensure that he's not discovered.
So I concur with that scoring. I did hear from the victims, I did read in the reports of that being secreted, if you will, in this bedroom. Now, Mr. Matoizik has cited a case, Thompson, I believe, but I think what distinguishes that case from this is the fact the bedroom door here was locked. And if I recall from the reports, that door was not opened upon even request of the mother knocking and actually being at the home, in essence, hiding both the victim and Mr. Deacons from the mother, who I can't recall why she was coming to the home. OV8 does allow 15 points. I'm going to read from it now. If a victim was aspirated to another place of greater danger or to a situation of greater danger or was held captive beyond the time necessary to commit the offense. That last or, certainly if I recall from reading the reports, the offense may have even been concluded, if I recall correctly, but victim was held in that bedroom in order to make sure that was not what Mr. Deacons was doing was not discovered. I think that distinguishes some of the case law that's been cited from simply just going from a common area to another room, for instance. This was actually a place where the victim was kept or held, if you will, behind a locked door. So respectfully, I'm declining to change the scoring on OV8. What else do you have?
OV9, Your Honor, number of victims was scored at 10. That should be scored at 0. Apparently, I think it's scored at 10, at least what I can glean from the report. It's they aggregated the victims of separate crimes to make it 2, since there was 2 alleged victims in this case. But if you look specifically, People v. McGraw, 484 Mich 120, 2009 case. In that case, that it talks about the separate victims, but they're separate crimes. So I think that it should be scored 0.
All right, Ms. Vanderveen.
I score it because there are 2 victims.
Mr. Valet, what's your thoughts
Well,
about
Judge,
it?
I think that maybe perhaps counsel is correct. I think that is in this case, because there's two separate offenses that are scored, they have to score based upon the elements of the offense that they're scoring. So I think unlike the case where we have multiple parties that are, let's say a car is driven at them and there's felonious assault on multiple things, in this case, there's just one per charge. So I can't disagree with you.
And I also would concur with the same. So OV9, we scored it 0. What else do you have?
OV13. Well, no, OV11, Your Honor. OV11 was scored at 50 points. And I think that the issue in this case is that looking at OV11, and reading the preliminary examination transcript, it's just that it should be simply at 0 when you talk about criminal sexual penetrations, scoring all penetrations of the victim by the offender rising out of sentencing offense. Criminal sexual penetrations of the victim at sentencing offense, which did not occur during the offense, may be scored in OV12 and OV13 where appropriate. In this case, the court found that it was error to score OV11 where the record reflected that 2 penetrations that formed the basis of 2 convictions offenses occurred on different dates, and there's no evidence they arose out of each other. The court explained that arising out means a casual connection between the 2 events. And looking at this case, Your Honor, and the preliminary exam transcript, there's just nothing to show that there's additional penetrations. I think it should be scored at 0.
All right, I'll start. Ms. Vanderveen.
Judge, I think there was statements made by the victim that were both oral sex, there was penetration, and again, we're talking about on the CSE third, which the element of the offense is the penetration. There were certainly statements made by the victim in this matter, that happened, was forced to perform oral sex on her, on him, and that he then had sex with her. These could easily be attributable to the same events. They happen multiple times over multiple incidents. And so I think the court can use its discretion, assuming that that's where it is, that there were multiple penetrations of the victim. So I think 50 is correct. That's how I had it scored.
So I recall in reading the police reports for a factual basis, there were certainly descriptions of multiple penetrations occurring over a whole host of time. The actual instructions here on 11 does allow for scoring of all sexual penetration by the offender arising out of the sentencing offense. It can be counted in OV 11. I'm not seeing the objection there with OV 11. I think if I recall, even both victims reporting the same about how this went on over a period of time and even in different places. So respectfully, I'm going to deny the objection to OV 11 and leave the scoring at 50 points. And then Mr. Matoizik, you indicated that OV 13.
Well, can I go back to 11 for 1 second?
Sure.
Thank you. As far as scoring additional penetrations, again, I would just cite the People v. Johnson 298 Mishap 120 2012 case. OV 13 is scored at 25. The issue with OV 13, we look at the continuing pattern of criminal behavior, scoring all OV 13, all crimes within a 5-year period, including the sentencing offense, must be counted without regard to whether the offense resulted in a conviction. Again, I think what's troubling about OV 13 is that what 5-year period are we using? I couldn't get it from the report.
Don't you have a better argument on 13 when you read OV 11? And it says any conduct scored under OV 11 may not also be scored under 12. And any conduct that is scored under OV 11 may also be scored under OV 13 only if the conduct is an offense that is related to membership in an organized criminal group. So I didn't hear anything about that. Now, the only thing that gets sticky, it goes on to say, for sentencing offenses committed on or after April 1st of 2009. Now, someone would have to. I do have an information here.
2007 is the offense date start.
So maybe my offer of help from the OV isn't applicable. No, Mr. Webster, what do you think?
I understand what he's saying about the time period. I think it's any 5-year period. It's the 5-year period. But the point is, I think that can be scored in 11. You can't score the same conduct in 11 and 13. I think there's ample evidence that there were multiple penetrations that occurred over this period of time that are not the subject of the charge. And so in that sense, I think there's, for lack of a better term, there's plenty to go around. There's enough to score in 11 and there's enough to score in 13. This was a multi-year assaults. And so I think you only get one bite at the apple. I agree that both ways. We can't score the same offenses in both, but we certainly can take into account all the offenses that happen, and there's certainly enough for scoring of 25 points.
So in other words, your position, if I have it right, is that there were 2 or more penetrations that support scoring on 11, and then there were additional penetrations beyond the 2 and 11 that would support scoring in 13.
Well, correct. And I'm not, as I sit here, I don't have all of my file in front of me, and apologize, but I think we're looking here at the 25 points is 3 crimes against a person that occurred. That's where these points come in. There's charges that were dismissed in this case. There's all those matters. And in that case, we are talking about both defendants in that case. We have to take it in all crimes against the person. So I think that there's multiple reasons in which you can score in both 11 and 13.
All right, Mr. Matoizik, anything else on 13 then?
Well, the argument on 11 and 13, there's multiple penetrations. I think 11 should be 0, and I think 13 should be 0 as well.
All right, so again, my review of that report, and it's People's Exhibit number 1, which was offered as part of that plea taking process. I think clearly supports as far as number of criminal penetrations here. There were certainly plenty, if you will, but that's where the courts are going with OB 11 and 13 to support 2 or more sexual penetrations as it relates to 11. And then this OB 13, 25 points for a continuing pattern of 3 or more. I think Mr. Belay is correct. We have 2 different victims here, both of which reported this ongoing sexual assaults by Mr. Deakins. And it just, maybe this is a simple way to view it, but the sheer number that were reported here, I think support the scoring of 11 and 13, recognizing that OB 11 does reference when scoring of OB 13 is appropriate if 11 is scored. In this case, the court has already said that it can be scored. So certainly, Mr. Matoizik, you've preserved the issue, I guess, for appellate review, but respectfully, I'm to decline for the reasons I stated on the record here, the objection to OB 13. What else do you have?
OB 19.
10 points, okay.
I believe that should be scored at 0.
And why?
Well, OB 19, threat to security of penal institution or court or interference with the administration of justice or rendering of emergency services. I don't think that's anywhere that would qualify as scoring that at 10 points.
Ms. Vanderveen?
I'm just trying to find it in my report. I recall one of the girls indicating that he tried to convince me that it was a secret and not to tell him.
I think that specifically there was discussion that he bought her gifts, including a necklace, or if I recall right, it's a necklace with a birthstone, and indicated that this was something secret between them and that he wasn't to tell all of those things. That to me, I think you certainly could assume that was with the intent to interfere with the administration of justice. Certainly isn't a violation of personal protection order, which is where the other 10 points is. It simply comes down to that. Did he take steps? Did he take steps to thwart his discovery? And I think he did.
All right, and then Mr. Matoizik.
There's no evidence that my client threatened to do anything or take anything away from any of the victims. Certainly buying them gifts, that doesn't cover OV 19. It's just not there.
I think he also threatened to kill himself if he came out, Judge. I don't know what more of a threat a father could make to his child other than, if you do this, I'm going to kill myself. The impact on a child of that kind of statement is clearly only intended to do one thing.
Right here in the report, at the top of page 6, it says she went on to state that he told her that no one would believe her if she told, and that her family would hate her. I believe that was beyond. Yeah.
Mr. McClintock.
So Ms. Vanderveen, can you tell which report? I'm trying to find the same page.
It's page 6. It's the second line from the top.
Which document?
I'm sorry, the 284.
Oh, so I was looking for something of this nature in the exhibit that the court accepted for the factual basis.
This is on page 6 in the first paragraph of the PSI. CFG 24, where he talks about advised that he threatened to kill himself if he told his family would hate her. It's all right in the first few lines of page 6.
All right, then Mr. Tyzik, anything further on 19?
Nothing on 19. I don't have any further scoring challenges, although I point out to the court, even if the court did grant all of my challenges, it didn't change the guidelines at all. So,
all right, so let's finish up with 19. With the people and Ms. Vanderveen pointing out what the court was looking for here, it does appear that with those threats, both to the victim that no one would believe her, also threat to kill himself, i.e. this emotional terrorism, if you will, by the defendant to the victim, the scoring of OV-19 would appear to be appropriate. OV-19 says the defendant interfered with or attempted to interfere with the administration of justice or directly or indirectly violated personal protection order. So the first part of that, I think, clearly is supported with what has just been placed into the record about the defendant's actions as it relates to that particular victim. But going back to the OVs here, we then have
125.
125 minus 10.
135 minus 10.
Yeah. And then does that change the OV level?
No.
All right. And so then it doesn't change the minimum guideline range. All right, Mr. Matwyzik, then if that completes your additions, corrections, deletions, I'm going to first then go right back to Mr. Valet. Anything else from victims or the people?
No, we've had the victim statements. I know the court heard those and is taking into consideration and determining the appropriate sentence. Your Honor, we did, as I've already said during the motion, I think Mr. Deakins is receiving an excellent deal here, and I'm not upset about it in the sense that this was negotiated with the full support of the family, and talked to both of those victims for a substantial amount of time. And so I'm comfortable with the offer. With that said, clearly this is a good offer, but as the court, I'm sure, could glean from the statements made by the victims, these incidents have taken a heavy toll on both of those young ladies, and going through a trial is certainly not anything that is fun. Whether you think you're in the right or not, being subject to cross-examination on your story is difficult. I think it's made all the worse in a case like this, where the betrayal of trust, a daughter and her father, who that natural person that you look to protect that child, the person that they look at, that violation of trust, having to come in and have it denied in your face is very difficult for them. And so I think that they made a good choice. We talked about where we were on this trial, and so I'm still comfortable with the offer. And so consequently, I asked the court to follow the offer. While certainly Mr. Deakins could have done much worse at trial, I think it is appropriate under the circumstances, and I think that based upon my conversations with the victim, we'll begin them along the healing process.
All right. Mr. Matwyzik, I'm going to ask you for elocution on behalf of your client. Mr. Deakins, you can come up to the podium, sir.
yeah, no, this is a tough case to elocute because of our motion to withdraw the plea and our position that my client has professed his innocence in this case and as outlined in his affidavit. So I would say that the court already put it on the record. The pre-sentence investigation supports that he hasn't been in any trouble his whole life, been a hardworking member of the community, done many things in the community, lives in the community, his family in the community. And again, I think that look, the court already said that he has nothing in his history that would indicate that he's a bad person prior to these allegations. And again, I guess we'll have the reviewing court look at this, obviously, and go from there. But and I would ask the court, I'm gonna leave it to the court's discretion on sentencing.
All right, Mr. Deacons, anything that you want to say before the court proposes sentence?
I'm not guilty of this. I didn't do anything wrong.
All right, Mr. Deacons. When I hear something like that, after hearing the victim statements, it's absurd. It really is flat out absurd. When you see the emotion in those two girls that the court heard from, young ladies now, when you hear the detail with which they communicated that in a courtroom full of people, when you hear the consistency between what happened with them, one your stepdaughter, one your biological daughter, I have zero doubt what occurred here. And if I were in your shoes, and I can't give you legal advice, so I'm not going to attempt to. I don't know what a reviewing court does with this. First, you have to cross the threshold of whether an appellate court will even look at it, because it's only by leave. But you might want to think long and hard about that, sir, because I've done this a long time, both in Mr. Millay's shoes, on the bench a while, and I've heard from lots of victims over the years. And I'm telling you, sir, that if they are anything like they were giving their statements to the court, you do not want a jury to hear that. Because the only thing that I hear today is just this silly thing from you. I didn't do this. But you have two young ladies that said, yes, you did. And here's all the disturbing details about it.
Yesterday, you were told you had a drug test so that I could figure out an appropriate sanction, right? Because I don't want to put you in jail. You haven't started treatment yet. I don't expect a lot of changed behavior when you're not going to therapy, you're not going to meetings, you know, you're not there. I can't expect this big life change out of you before you've had any of these resources. So you went down to test. My understanding is you dropped the cup and you're to wait. There was an individual that came into the court and there was some sort of argument with him. I'm assuming this is your boyfriend. Is that right?
Yeah.
He doesn't seem like a very good boyfriend.
No, he.
And then you left the building and got into his vehicle despite not. We're waiting for you to test
stuff, and he kind of forced me to get in the car.
And then we had a bunch of people, well, at least two, come into the court that were out in the parking lot, very concerned about you because they saw this man punching you in your head in the court parking lot. We had citizens, normal humans, not my court officers, not people, just not people that work here, random citizens coming in saying that guy's out there beating her in that car. So I know you seem to think you have your life together, JC.
This has never happened, Your Honor.
JC, you do,
I don't
just
surround
listen
myself.
to me.
I don't like people like that. He's never did
Listen,
this.
he's a bad man.
No shit, but I didn't know that.
Listen to me.
I trusted him.
Well, now we know better. JC, you're in your 30s. You don't have your kids. You're stripping. You're living in a hotel. You got a boyfriend who's married and beats you and in wide in the open. I know you think your life is going well. Your life is in shambles. I have not had anybody come in to this program that is in such a dire circumstance as you are. I haven't, not one. It breaks my heart. It makes me sad. I think you're defiant, and that's fine. But
I've asked for help years ago.
well, now is your chance. And we're gonna throw so much at you, JC. You can change your life. I have people in this program where their drug of choice was fentanyl. They see their kid again. And not because mom lets them once in a while. They see their kid again because they've gone to court and had some rights reestablished. You can do that. You're a baby still. You really are. 31. I'm 46. almost 47. Like, you have over half your life left to fix all this, but this is a mess, a disaster, a complete and utter disaster. So I'm gonna modify your bond. I'm not putting you in jail. I don't think it's gonna do you any good. You're gonna go stay at Sandy's. You have a personal bond with a GPS tether. Sandy, she needs to come up to, we'll get her on the tether tomorrow. All right, we need to get her up here tomorrow. Can you make that happen?
Anytime in particular?
And ma'am, can you just stand up and say your name for the record? No, not you. Sandy. I know who you are, but so the record's clear.
Sandy Carnes from Stanford House.
All right, Sandy runs homes for women in recovery. They work. I have other participants that are there now.
I just don't like being around people.
Well, I get that. I don't like that. I wouldn't want to really live in a sorority house full of women in recovery either. I'm not going to lie. But it's better than living at a hotel with some dude who beats you. Yeah, it is.
Believe me, this happened one time yesterday.
How many times does it have to happen? JC, okay, so he's been verbally, JC,
I don't know what happened.
He's been verbally abusing you for how long?
Long time.
Yeah, so he's already, you're in a domestic violence situation.
He pays all my fines off for me, so.
Oh, that's great. Is it worth your face? Is it worth your life?
I didn't think he would ever feel like that.
All right, well, now we know he is.
Now he's not allowed there.
Yeah.
But I still pay my rent. I still cook, I clean, I take care of my cats, I see my kids on a regular basis. I talk to my family every day. I have no problems other than money.
No, you got
Right
a lot
now.
of problems. Jace, you gonna test Pete clean right now for me?
Yeah. I haven't done anything. I haven't had a single craving until you put me in this program. That's why I feel like it's pushing me backwards, because it's putting me onto all of this stuff.
Jace,
I
you
just
have
got away
55 criminal convictions,
I
plus a
don't know
bunch
how
of
I
other ones
have that many,
pending.
but I
So, and
a
these
lot of
kids.
them's traffic, I would
No,
assume.
no,
I don't know.
no. They're not, you don't have to assume, because I have your
I
record.
don't know, man. There's a
All right,
couple
well, I
drivers.
know, JC, because I
Couple
have
drivers.
it. I have it, JC, so we can look. Listen, you have all these cases pending. This idea that you've like somehow changed, like, you are delusional. Listen to me. You are living in a delusion. You live in a fantasy world where your life is okay. Your life is a mess. A mess. Listen to me, JC, you currently have 2 theft cases pending. These are your pending. 2 in what I'm talking. 2 in Westland. Oh, you do have a traffic one in Westland. You got a controlled substance case in Dearborn that's pending. You're on felony probation in Oakland.
Yes.
Okay, your life is a disaster. And the minute you start to recognize that and you try and take advantage of this, I am trying to save your life. Whether you like it or not.
Okay, I didn't think I was doing that bad.
You're doing terribly right now, JC. And it's some of it's you and some of it's not you. But you're going to try this. You're going to, because I'm forcing you to. Or you go to jail and you will do the whole time. And then Oakland County will put you in too.
Ma'am,
You've got
I need
an
a doctor.
opportunity to be
I
in one of
need
the
a
best
therapist.
treatment. We're getting you one. Because here's the great news. You can use Sandy's address. And when you use Sandy's address, now we don't have to wait about this
My
Wayne
own
County.
address. I want my own stuff. I want to do this alone with my
No,
own.
no, not an option.
I am independent. I don't like being told what to do when I know what to do.
No, you don't know
You
what
don't
to do.
understand.
JC,
I
we
know
let,
what to do.
JC,
Try, like
JC,
that.
listen to me. You have been in control of your life for 31 years.
I haven't.
You are averaging, if
I
you
have
started
not.
getting a criminal conviction at 18,
It was 10 years ago.
you are averaging, I can't even do the math. I mean,
10
you're
years
doing 5 or 6 convictions a year. I mean, you are out of control, and you are going to do this program, or you are going to sit in Wayne County Jail for 93 days, period. We're gonna work on something for the cat.
I don't need that. I can do it myself.
Okay, well, you can't take the cat to
Can't
Sam's
somebody
house.
just come stay with me? Can't they just
Who
come with
am
me?
I gonna pay?
I don't
to
know,
stay in a
but I need
hotel
fun.
with you?
Can't they just
Might should
supervise my
Carol?
life and see that I'm
No,
okay?
no, absolutely not. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of any change of address or phone number. You're not to purchase or consume alcohol or illegal drugs. Sandy, how many meetings are at your house on a weekly basis?
She will be attending at least 4, and then 2 days a week of women's groups. And then we're asking that she doesn't give anybody our address or location.
Can't do that.
Great. So I'm living somewhere where I've never been and I don't have any idea where I'm going and nobody will know where I'm at. I just got my family back in my life.
Do you want us to contact your family? Do you want to take time with Kara to let them know? You were at a house that is a safe location and we have to keep everyone
My
there
dad
safe.
can't come and see me. I can't see
It's
him.
not that your dad can't eventually come and see you, JC.
I
Let's
don't
get
like
you
either.
stable.
I don't like it.
Let's get you stable. I don't know. Maybe 6 months,
Seriously,
maybe a month.
Man, I got my hotel, my stuff, everything, please.
Well, Sandy's gonna help you get your stuff.
Please don't do this to me. I'm
just
trying to
save
get a
your
damn
life.
doctor that works with like PTSD and deeper stuff that's been happening in my brain. I
We're
don't
gonna
need
get
to be
you-
at someone's house.
She needs to go to DWIN or get signed up for treatment and get an intake. And I need you to call over to whoever Hydera, the guidance center. You tell her she is in extreme crisis and we need her intake ASAP tomorrow. She needs to be seen tomorrow or Friday for an intake. We're gonna get you over there. She needs to see a psychiatrist, she needs to see a therapist, but her intake has.
Torn away from where I'm at. Oh,
You are
you're
living
doing
at
more
a
damage
hotel.
to me by taking me away from my home.
Yes, I'm gonna save
It
your
is
life.
my home, it's not just.
It
a
is not your
hotel.
home,
I
it is a
cook there, I
hotel.
live there, ma'am. I've been living in hotels for 3 years because it's comfortable. I feel safe there.
Can't
I
operate a motor
established
vehicle
life
without a
there.
valid license. And she cannot.
I need help with housing.
We're gonna get you
Stuff
all
like
that,
but
all
I
that.
don't like, I don't wanna be
JC.
at a stranger's house being told, I can't do it on my own, I can do this by myself.
No, you can't. You can't.
I need your assistance, I don't.
I'm gonna give it to
take
you.
over.
But listen to me.
I can't be at someone's house for 6, like, man.
I don't know how long you're going for, JC. I don't know, but I know you're going now. I know that. And you're coming here tomorrow morning to get on your GPS tether. Period.
I'm not a flight risk.
Not provide.
Do whatever you want. I can't
okay.
leave my home.
Okay, cannot provide address. To any third parties. I am going to allow, Ms. Carnes, I'm going to allow her to provide the address to her attorney.
Absolutely. And then she can use the shelter address for everybody else. But she did hand the key over to the guy that hit her.
Oh, he was there?
Yeah, he was there. I didn't
He
know.
brought
he was
money
there
for the
when they
hotel,
got
I
there.
asked.
So she did give him the key, so there's no more hotel as far as I'm concerned at all. The GPS, if he tracks her going there without us, without the support team, then it's over for us. Because we're not, she can't go there, he's there, I didn't know.
He's not there, he's just there to take care of
And
the
he
kids.
reached out to us, and we're not doing anything.
If
I said,
we-
"Hey,
gonna be there.
The only issue I have is if she
He's
has
not
all of her
there.
personal possessions
I mean,
there.
we'll take
Yeah,
it,
he's
once you
not allowed
figure
on
out,
property.
GPS figures out, she said she has a storage unit, but it's in his name, we need that
I
on his
only
name.
gave him the
in her
key to
name.
take care of the
Then
cat.
she can put whatever she wants in her
He's not
storage
allowed
unit,
there.
but he's not gonna rob her of her stuff either,
He's
right,
not allowed
JC?
there.
Okay,
Well,
So
you
I'm
need to keep it-
concerned
keep
that
the key in
something's
that
gonna
safe.
happen.
okay, so we're gonna figure out some of this
If they find
tomorrow.
out that he's there, they're gonna kick me out and I'm not there. All my stuff's gonna go on the.
Then why'd you give him the key,
So we can
girl?
go feed the cat after work.
All right,
He's gotta
cannot
work.
provide address
I
of
don't have
Sanford
nobody
House
else.
to any third parties except her attorney. DWIN to called When she's here tomorrow, Sandy, we got it. She is in crisis.
Absolutely, she's lovely,
I
Judge.
don't want to be with someone else.
She's lovely. And then I can bring her in the morning and you guys can figure that out and we'll pick her up whenever you call and say she's ready to go. And then whatever she needs, we'll help her with.
Okay. And then we're gonna have, so tomorrow she'll come in, Kara. We're gonna do D-Win in the morning. You can call and make sure they get her in ASAP. And we're going to get the tether company here. And if you can contact Sandy directly, Sandy will get her here.
You're putting me on a tether. Why can't I go home?
You're going on a GPS tether because I'm tethering you to Sandy's house.
Can you put me on house arrest or something, please? I'm just scared about people. I had so much shit happen to me. I'm sorry.
The guy,
I'm
the one,
scared to be around
listen,
anybody.
JC Owens.
He's
The
not
one-
allowed there, man.
Okay. The one person you're not afraid of, who you literally just told me is not going to hurt you and is not a danger, is the guy that beat the living crap out of you yesterday.
Yes.
And you have bruises all over
I
your
told him to
face.
bring me money.
You showed Kara
That's the
pictures.
only
It is
reason.
absolutely shocking what
He only
happened.
showed up to drop off money for the room.
That's my order. That's my ruling.
He's not allowed on the property, you know.
He was
I gave
there
him the
when you-
key.
He was there when you were there, Sandy?
I just called it. He just showed up to give me the money for the room and I gave him the key to take care of the cat because I didn't know if he'd be home or not.
All right.
But he's not allowed there, so anything could happen to my cat, everything.
We're gonna get the cat situation figured out
I
quick.
just wanna go home.
You're going
I'll
home.
go to a different hotel. I don't care. Just please don't make me stay with other people.
No, you're going home. You're going home with Sandy.
Man, this is gonna ruin me. It's gonna
Only
help
if
me.
you,
It's
if you
not gonna help me.
refuse to
I
take
just
advantage.
need a doctor.
You are not manipulating me.
I'm not.
I'm
need a
not, I am
doctor.
getting you a
I need
doctor.
somebody to go in my mind, not take me away from everything that I'm safe.
We're getting you to a doctor by the end of the week. We are making all kinds of phone calls and calling in all kinds of favors to all kinds of agencies to get you in ASAP.
Then put
So
me on
for-
house arrest
I did.
at the hotel that I'm at.
Okay.
Please, I can't lose everything again.
You're going with Sandy right now, and I'll see you in the morning, or you are going to the Wayne County Jail.
I just don't want to lose my life again.
JC, right now, I want you to turn around and pick which door you're walking
I'm
out.
going with her, but can I go home tomorrow?
No, I'll see you in the morning.
I don't want to lose everything, man.
I know, we're gonna get your stuff, don't worry, we're gonna figure out a plan.
Not fair.
Call downstairs and just make sure they know. She's only gonna leave with Sandy.
Can you hear me?
Yes. All right, Mr. Nykamp. I'm assuming you're here for cutting edge excavating?
Yep.
All right. So this is a citation that was issued on April 24th of this year on I-196 there at Casco Township, Eluding County, state of Michigan. This is for an overweight citation. You're here, sir, on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, contest this ticket at what we call informal hearing. What were you looking to do?
Contest it.
All right, then I'm going to go ahead and ask anyone who might be testifying here, go ahead and raise their right hand. Swear or affirm anything you testify to here today would be the truth, the whole truth, and nothing but the truth.
I do.
All right. Mr. Nykamp, what do you do for cutting edge excavating?
Owner and operations manager, vice president.
All right, so it makes a lot more sense for me to start with the officer. Motor carrier officer here has the burden to establish to me why they issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. And with that, Officer Washer, you want to pick up the narrative somewhere it makes sense and explain the issuing of this citation?
Yes, sir. So I was sitting at the mile marker 22. I observed the commercial motor vehicle go by me with 2 lift axles up. I followed them all the way to the Casco rest area, which is at mile marker 27 with both lift axles still up. I initiated a traffic stop, and that is when the driver lowered the 2 lift axles. I asked him why he had those up. He said they were up the whole time, which is not true. And then we proceeded to weigh out the vehicle with the lift axles up as I observed it on the road. And he was over on his gross weight. So his actual gross weight was 100,400 pounds. His legal gross weight was at 89,000 pounds at the time. So he was over 11,400 pounds. I did advise him if he did have those lift axles down, he would have been at 110,500 pounds.
So the lift axle is an optional axle that's added onto a truck that helps carry the load. I'm not sure exactly what the purpose is that they're issuing a fine for, but from what I looked at, it helps fuel efficiency. It probably has something to do with not tearing up the road as much. But they can put that axle up and down so that extra wheel goes up and down depending on what the driver wants to do.
I believe. So he would have been good. But even when we were trying to do the area where we're doing the weight, checking his weight and everything, he was having trouble with the lift axles, like staying down and coming up. And so, yeah, that's pretty much it.
All right. And what is it you'd like to tell me, Mr. Nightcamp?
So this trailer, I agree with what he said in regards to having trouble with the lift axles. This trailer apparently had a bad valve in it. The valve was repaired the next day. I think we have that work order here somewhere that it was repaired. So the switch, even though the axles in the down position were not down, apparently, as the officer indicated, he's seen them up during his transport. So, but the switch was down, and on these trailers, if there's a mechanical failure and the axle comes up during transport, a driver would have no way of knowing it. And that's what I was told is happening here. The axles were in operating order in the morning. And when he was loaded during his pre-trip, he indicated everything worked. And then some point down the road, he had a mechanical failure. And I do believe that at some point during the stop, the axles were down and the officer made him lift them in order to weigh him with him up, because that's how he's seen him going down the road. And at that time, the driver, Ryan, showed the officer that the switch, here's the switch, it's down. They're not going down, and they messed with it and got him to go up, actually, so that he could weigh him with him up because of the mechanic. He couldn't control them, is my point. When they tried to scale them, they were down.
Essentially what you're doing here is providing a reason why you're overweight. You're not really contesting that you're overweight.
We weren't overweight. We would be at our weight or under our legal weight if the axles were down.
But they weren't.
They were, according to, they were when he left the facility.
Okay, but what you have a ticket for is when this officer observed the truck with those up, that you would have been carrying too much weight on those last 2 axles. You have an overweight ticket. So you're providing an explanation for how this happened, but you're not really saying it didn't happen. What I need to do is find whether or not you're responsible on this citation as it's written.
Well, I guess what I'm asking is, when we experience an equipment failure going down the road, if a tire blew, we'd be overweight, because then I can't legally scale the load, and I have no control over that. if the axle comes up, a driver, an owner, the guy that loaded them, the scale that we went across, none of that matters anymore if there's a mechanical failure. And when the axle was down, the officer made him lift him back up to weigh him.
Yeah, but we can't write a ticket to a piece of equipment. Essentially, you're driving around on the road with, you know what I mean? The damage is already happening.
From what I
You just don't want the
understand-
responsibility, right?
But from what I understand, talking to officers and lieutenants, they can write the ticket to PADNOS, to the people that own the equipment that have the mechanical failure, but they chose to write us a ticket after forcing us to lift our axle. They chose to write us an overweight ticket. In my driver's defense, he made sure his equipment worked when he left. Everything was in working order, and he made sure when he went across the scale that he was underweight.
We have a repair ticket for the leveling valve.
And when he goes down the road and there's an equipment failure with the trailer that we were contracted to pull, I'm having a hard time holding my driver responsible for doing his job when he was verified that it worked and verified that he was underweight.
All right, but the ticket's written to the company.
I understand that. And I would love it if it was written to PADNOS, which I was told, and maybe somebody can tell me if I'm wrong. They can write these tickets to the trailer, the owner of the trailer, instead of the carrier, if there's an equipment failure on behalf of.
Sure, but the carrier's not supposed to be driving around unless the whole setup is in compliance. It's not. And that's what the officer observed, and that's why the officer wrote a citation. What I have to decide here is whether or not you're overweight on those three axles, while you're driving down I-196. I still haven't heard anything of why that wouldn't be the case. So for purposes of informal hearing, I would find you responsible on this. Now, you do have a right, because you had a contested hearing, to say, I don't agree with what that finding is. I want to take this to formal hearing in front of the district court judges with the prosecutor's office. You have every right to do that. And then you could perhaps negotiate with the prosecutor, but you must ask for that within 7 days of today's date, and you must ask for that in writing. You understand your rights on appeal?
Yeah.
All right. So we're all set for what we needed to do here today. I'm going to go ahead and release party.
Okay, you tell me who you think should be responsible and should get this ticket. And I believe this is between $500 and $1,000 ticket. It's a pretty significant ticket from what I've seen. So should the driver be responsible because he was actually the one in control of the vehicle? Should the owner be responsible because it's technically a maintenance issue, you know, checking all of the things and maybe he needed to do that more frequently? The manufacturer because it's a defect in the truck, or no one? This is just a way for them to line their pockets. Let me know in the comments. I thought this one was kind of interesting. You guys might enjoy it. Sparks an interesting discussion. Have a great day. Hello, my favorite people. We are starting our day in Jefferson County, Texas, with the wonderful Judge John Stevens. The man before him is facing charges of failure to pay for services, which was home repair services following hurricane damage that amounted to more than $50,000. The penalty for which is up to 10 years in prison. Oh, and there's a backstory.
All right, you were charged with theft of service, convicted of this third-degree felony. You face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you have an attorney?
Someone bring this in last time. Haven't quite acquired them. Still have a little.
Who is it?
Macon, James R. Macon.
Oh,
Yeah. Well, he's going to be the one we'll be paying to.
Okay, so what is this? Was home repair work?
Yes, sir.
Yes, sir. This was repair done, but
I'm not going to talk to you.
repair was done, but the payment wasn't made. That's what
Nothing was made. Not a dime.
I'll show $59,699.84 restitution of the law. So
But
know how much was, if anything was paid. It's your kid.
Sonny, that's yours?
Yes.
What, I want to know if anything was paid.
Judge, I believe.
Are you kidding me? The guy, $60,000. Take us home. Take us home. You own that home?
No, sir, I don't anymore. It, before the work was all completely done, the house burned down.
Did you have insurance on it?
We did have it, when we called to, because that's what this was all for, was supposed to be for insurance. And we were having a lot of issue with the insurance.
But
and-
no, that's,
Yeah.
I'm sure the contract didn't say conditioned upon
No,
insurance.
no, sir.
The guy wouldn't have done any work if that was it. Did you get insurance money?
No, sir.
Why not?
That's where we ran into a lot of problems. with-
No, that's not the answer. Why not? Did they suspect it was arson or something?
No, the insurance claim was from the hurricane prior to the fire. The fire was after. When we went to make the insurance claim, that's when we found out that we were having a bunch of issues.
There's a PC judge that confirms that the entirety of the work was done and then no payment was made.
Yes, sir.
Yeah, but what's the property now? It's a burnt down cinder? It's just burned?
No, there's a house there.
Who owns the home now?
I guess my mortgage company, because they foreclosed on it.
Yeah, it's owned by the bank.
Yeah. We had a lot of issues.
Yeah, well, 10 years in prison is a big
Yes, sir.
fat issue.
No, I know, that's what we're.
That needs to be. When are you going to hire Mr. Macon?
I'm hoping by the end of either this week or the end of next week, I should have the remaining balance.
Do you work somewhere?
Yes, sir.
Where?
Texas Plumbing.
What do you do for them?
I'm a plumber.
How much do you make an hour?
27. Just, I was a low last 3 weeks.
Sir?
It was just, I didn't work a whole lot of hours the last 3 weeks.
Because of what?
Just, well, the holiday was one, and then it got slow due to the holiday.
No, it doesn't. Not in this town right now with I had a plumber 3 days ago. Everybody in the neighborhood has had to hire plumbers.
I know.
They're working like they never worked before.
That's like this week I've been busy.
Okay, how long have you been a plumber?
About 15 years.
At 27 an hour?
No, sir. 27 an hour, probably maybe less than a year.
Okay, less than a year, and you've never $27, which is about $70,000 a year. At 2,000 hours, but I think plumbers work probably longer than a regular work week of 40 hours.
I typically don't, because I have a lot of kids.
Nonetheless, that's the way it's always
Yes,
figured
sir.
out. You
Yes,
figure a regular work week is 2,000, a regular work month is 2,000.
Yes, sir.
I'm sorry, a year is 2,000 a year. 8 hours times 5, 40 hours times 50.
Yes, sir.
2,000. And that's the way, that's just a universal, that's been universally used. And people like me and others around here work far more than 2,000 hours, but
Yes, sir.
2,000 hours is normal. So this is going on a whole year and not one dime was paid to that man? Is that right?
No, sir. I mean, yes, sir. That's correct. But
Okay.
I
All
thought
right.
he had my house under a lien, and we were gonna
All
try.
right. If I were you, you need to do whatever it takes to get Mr. Macon
I
in
will.
on the game as soon as possible.
Yes, sir.
So I want to, you're going to be back in 2 weeks to explain to me what the status is on hiring a lawyer.
Yes,
okay?
sir.
And if you hire one, make sure you bring in showing,
Like a piece of paper showing that he's. Yes,
yeah,
sir.
you get receipts. Get a resetting. Gregory Renfro.
And now for your backstory. This defendant and his wife have 8 children aged 1 through 12. The family was living in this home that was built by the defendant's grandfather by hand, and he was very proud of it. His mother called it a family heirloom in a newspaper interview. 4 of the children were home at the time of the fire. Husband and wife were sitting on the couch when the wife said, "I smell smoke." Husband walked outside, saw smoke coming from the top of the house, told the wife, "Get the kids out," immediately started disconnecting utility lines to the house, opened the garage, and it was completely black. He said within a couple minutes, you couldn't even see the house. There was so much smoke. Reportedly, the fire started in the washroom, which I am pretty certain is the laundry room based on the amount of damage that was shown in there. The family lost almost everything, but his mother went on social media almost immediately asking for donations for clothing for the kids, as well as beds and shoes and the other necessities. There was a GoFundMe put up asking for $5,000, and it looks like they received $1,500 of that, and that was 11 months ago. The article that I was looking at noted that work was in progress from damage from Hurricane Laura, which caused several trees to fall on the roof of the house. They had finished the roof, they had finished the outside, and they were coming inside to do some paint and some final work. The insurance company was supposed to pay for that work. Apparently, there's some kind of issue that the insurance company now is not paying. Likely as a result of the fire. I'm totally speculating here, but it's probably an insurance company being an insurance company and saying, "Hey, well, the work's not there anymore, so we're not paying for it." So he's going to have to sue the insurance company to get back all of that. However, he's now in a criminal case for not paying this bill, which who has $50,000 laying around, not most of us, to pay a bill that the insurance company should have paid. However, we don't know if there's questions regarding how the fire started or not. What I'm telling you is coming from a newspaper article. So, I will keep up on this one and let you know.
Bring the deputy over and we'll go ahead and get started. All right, so this is a citation. It was issued on August 5th of this year on 102nd Avenue there, Trowbridge Township, Allen County, state of Michigan. This is a speeding citation on an actual 74 and a 55. However, the deputy chose to only write it as a 1 to 5 over. So, Mr. Thrash, you're here on this 1 to 5 over speeding ticket to do one of 3 things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation to the court as to how or why this happened. Or 3, you wish to contest this citation. In other words, to fight the ticket at what we call informal hearing. What were you looking to do?
I would like to fight the ticket.
All right, but even though I cannot see you, I would ask that you would please raise your right hand the same way the deputy is going to raise his right hand, so I can swear you both in. You swear affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir. Of course, Your Honor.
All right. So, Mr. Thrash, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity to either ask him questions or testify on your own behalf. All right?
Yep.
So, Deputy, if you want to pick up the narrative somewhere it makes sense and explain the issue in this citation.
Yes, sir. On 8/5/2023 at approximately 9:16 p.m., I was heading westbound on 102nd Avenue when I observed 2 vehicles approaching me at a high rate of speed. I was like, this time I activated my radar, which is calibrated at the beginning and end of my shift. And my radar high toned at 74 miles per hour. So I was approaching vehicles. Due to my training experience, I could tell that both vehicles were traveling approximately the same speed. I then turned on the vehicle and got behind Mr. Thrash's, or check that. It would be the other vehicle, Mr. Miller's vehicle. No, it was Mr. Thrash's. Activated my radar. Mr. Thrash pulled over, and I went around him and pulled over the front vehicle. Prior to that, I was pacing them at approximately 70 miles per hour. As I stopped the first vehicle, Mr. Thrash pulled in behind me. I then waited for him to go around, and I then told him to park in front of the other vehicle that I had just stopped, and he did. And at this time, I cited both vehicles citations for 5 over instead of the 19 over that they were going in the 55-mile-an-hour zone.
All right, and Mr. Thrash, what is it you'd like to tell me?
First of all, Your Honor, I don't know what I even got a ticket for in the first place. I was driving my normal speed. I've never had a speeding ticket ever in my life. I don't know. I just bought this vehicle. We were on the back roads in Allegan County somewhere. I'm from Kalamazoo. And all of a sudden, I seen the police officer coming at us, and he did a U-turn. He went around me, put the lights on, pulled my cousin over. The car that he pulled my cousin over is my other vehicle. It's also issued in my name. It's in my name. I have the registration. I have the proof of insurance. So I pull it over so I can give him the voucher for that because my cousin didn't have that in the vehicle at the time. So that's what I did. And upon doing that, he took my ID, asked me who I was. I presented my ID just so I can prove that these are my vehicles. And upon doing that, I got a ticket for 1 to 5 over. I was never pulled over. I just wanted to vouch that these were my 2 vehicles, and the one that he did pull over did have registration and proof of insurance.
Okay, well, just to be clear, you don't have citations for any of that stuff. That must have all been in order. What you have a citation for is going 1 to 5 over the speed limit on 102nd at that date and time.
Your Honor, I was never pulled over. I was never pulled over. I pulled over myself because the car that he pulled over is my vehicle. It's in my name. It's the insurance is in my name. The vehicle is mine.
I understand that, sir, but he's already testified what he issued you a citation for. So if you're contesting that citation, what you would be contesting is the accusation that you're speeding.
I was not speeding, Your Honor. I was going my normal speed. If I was speeding, I probably would have got pulled over. He went around me, pulled over the car in front of me, and then we both get tickets. I don't know how that works. I don't know. I don't understand it. Yeah, I'm not understanding it. I'm from Kalamazoo. I'm not from Allegan County.
It doesn't really help me when you say you're driving your normal speed, sir. The testimony from the officer is that. What's that?
I was going the speed limit. I'm driving my normal speed. I was just going the speed limit. I didn't think I was going 74 miles or whatever he's trying to say I was going. I was not going 74 miles an hour. I had a child in the car. Like I was not going 74 miles an hour.
So how fast are you testifying you were going?
The speed limit, 55 miles an hour.
All right. And what about the other car you were with?
I was not driving that car. That car was in front of me, and that car was in front of me almost a whole football field. So what did that have to do with me? It had nothing to do with me. Like I said,
I'm just asking you if you were driving faster, slower, or same speed as
no,
them.
No, I was driving. You know? Yes. I was. We were not driving neck and neck. We were not. I was not following him. He was in front of me, but when the police officer went around me and pulled over the vehicle, it so happened to be my vehicle, the one that he pulled over. So I was just doing the right thing and eliminating a whole bunch of other trash that would have went on because they couldn't show the proof of insurance or whatever. I didn't know if my cousin's driver's license was valid. Of course it was, but I just wanted to make sure everything went accordingly, you know?
And I understand that, but essentially, and we'll go back and talk to the deputy, but essentially the deputy, if he pulls you over first, guess what's going to happen to that lead car? It's going to go bye-bye. So essentially he pulled over the lead car. If you had never pulled over, he probably wouldn't have been able to have caught up to you and issued 2 citations. But to be clear, deputy, I wish you to articulate why you issued a citation to both of these vehicles at this stop.
Because when I activated my radar, when I observed them coming at me at a high rate of speed, it radared at 74. The two cars were the only two on the road at that time, and they were fairly close together, and I could tell that they were going approximately the same speed. And when I turned around the vehicle, when I got behind Mr. Thrash's vehicle, I did pace them approximately 70 miles an hour before I activated my overhead lights.
All right, and that's what I want to slow up for Mr. Thrash's edification. So when you're using that front-facing radar and you get to 74, the 74 would be the lead vehicle or the faster vehicle?
It actually on our radar shows both if it can pick them both up. But in that case, it was the front one.
All right, so the front one, you determine their speed with radar at 74. So what I heard you testify, but I want to break it down slower. Mr. Thrash being, well, you didn't know at the time, but you know now, the second car was keeping up with the first car. And that's how you determined they were going approximately that same speed you got the first car at.
That, and when I turned on the vehicle and started following them, I was pacing them behind them at approximately.
Yeah, I didn't want to get ahead of ourselves. So then you flipped on them,
yes,
but you didn't turn your lights on.
Correct.
You're going to catch up to them.
Correct.
Was it your intention at that moment to pull over which car or both cars or either?
Well, seeming the front one was the first one I got, I was going to pull that one over because I can only pull over one at a time.
All right.
And then when he pulled
and
up
then
behind
as
me,
you were behind them, you said you paced them. Can you put a little more meat on the bone of what you mean by pacing?
yeah, so when we get behind the vehicle and we're driving a speed limit and we get to a point to where we're not either catching up to the vehicle or we're not losing the vehicle. So we're in a sense, going the same speed as that vehicle. And I look down, I'm going approximately 70 miles an hour, which tells me that that vehicle in front of me is going approximately 70 miles an hour because I can't catch up to it and I'm not falling behind.
So then you passed up what essentially is Mr. Thrash's vehicle, right?
Correct.
And you pulled over the car in front of him.
Yes, sir.
Who it turns out was his cousin, I think he said. And then so Mr. Thrash voluntarily pulled himself over.
Yes, he pulled in behind me.
All right. But then you issued them both citations.
Yes, I asked him to go in front of his cousins because I don't want my emergency lights blocked from other vehicles that would be coming up behind me.
So at this point in time, Mr. Thrash, I need to find for an informal hearing that the officer has met the elements of the citation they charged you. Essentially, he's only writing you a 1 to 5 over, but he's testified 2 different ways now that he had your speed at, well, significantly more than that, at least 15 over, but they only chose to wrote you for 1 to 5. So I would find you responsible on this citation as it's written. Here's what I want you to understand, because it's probably what you're more interested in. You could accept my finding of responsibility, and then the only thing you would need to do here is to go ahead and make arrangements to pay those fines and costs. But should you decide that you don't agree with what just happened here and you wish to take this further to what we call a formal hearing in front of the district court judges with the prosecutor's office, then you must do 2 things, sir. One is within 7 days of today's date, you must formally ask for that formal hearing. That window of opportunity closes after 7 days. And 2, you must come in and ask for that in writing because you would need to post a bond. Do you understand your rights on appeal?
Yeah.
All right. Well, we're all set for what we needed to do here today. I'm going to go ahead and release parties. Thank you.
Thank you.
Oh, thank you.
Yes, sir.
All right, this is a citation that was issued on July 24th of this year on Patterson there, Wayland Township, Allegan County, state of Michigan. It says a violation of seatbelt law. Ms. Long, you are here on this citation to do one of 3 things. First is you could admit responsibility to the citation. 2, admit responsibility, but you'd like to provide some sort of explanation for the court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do? Ms. Long? Ms. Long, are you able to hear me?
I'm not sure if she's on yet.
Oh, Well, ma'am, you're in court as a party. You're not, I'm gonna have to boot you. You can watch this on YouTube, but only the people with citations are parties.
Well,
So you're
she's a
saying
minor, so she's a minor, and I just wanted to make sure everything went smoothly. And
all right. So you'd have to watch it on YouTube, ma'am. Only her attorney or her would be allowed in as a party. I'm gonna go ahead and remove you. Or you can remove yourself. All right, I'm gonna pop you back over in the waiting room. Apparently that wasn't her. Oh, no, here it looks like this is her. All right, Ms. Long, you able to hear me? I do
Yes,
need
I
you to
am.
answer out loud. Okay. This is a citation. It was issued on July 24th of this year on Patterson there in Wayland Township, Allen County, state of Michigan. This is a citation for a violation of seatbelt law. You're here on this citation, Ms. Long, to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to the court as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Could you repeat that, please?
Yes. So on this citation that you have for a violation of seatbelt law, you have three choices of what to do. One is you could just admit responsibility on the citation. Number two, admit responsibility, but you'd like to provide some sort of explanation to the court as to how or why this happened. Or number three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. Which one of those were you looking to do?
Detest it.
Okay, so then what I'm going to ask you to do is to raise your right hand, the same way I'm going to ask the deputy to raise his right hand and swear you in. Do you swear that anything you testify to here today will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. Ms. Long, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why he was issuing you a citation in the first place. But after that, you'll get a chance to either ask him questions or testify on your own behalf, all right?
Alrighty.
And then with that, deputy, if you want to pick up the narrative somewhere it makes sense, explain the issuing of this citation.
Thank you, Your Honor. As indicated on July 24th, 2023 at approximately 12:48 p.m. while working as a certified peace officer for the Allen County Sheriff's Department Traffic Division, I was traveling northbound on Patterson Road. I was nearing the signed intersection of Patterson and 136, in which I was traveling at a slow speed, being that I was approaching the signed intersection. As at this time, I then observed a vehicle traveling southbound that had just crossed over the intersection, in which time I looked over and noticed that the front seat passenger had failed to wear her safety belt. I then initiated a traffic stop, at which time the front seat passenger had fastened their seat belt. I then tried to question the front seat passenger as to why she had not been wearing it. However, she would not talk to me or make any comments. However, the driver stated that she did have it on, but she had the shoulder strap tucked behind her. The front seat passenger was identified as Miss Long, who's present here today. As a result of this incident, I did issue a citation number SD 21001 for fail to wear seatbelt, improper use. I have nothing further at this time, Your Honor.
Okay, and ma'am, what is it you'd like to tell me?
The seatbelt was on.
Okay, and can you just tell me what you mean by that?
When we were pulled over, the seatbelt was the strap part was behind me because I was reaching for something underneath, but the seatbelt was on.
Okay, and then essentially, here's what I need to explain to you, ma'am, or essentially why you got that citation. This happens every once in a while. There's lots of people that kind of ride around, they have the lap belt connected, but they put the shoulder strap behind them. That's considered the same as not having your seatbelt on. The seatbelt has to be on in the proper fashion it's designed for in order to count. And so essentially, you're both telling me accurate things, but when I hear both of them, What that would mean to me is the seatbelt was not on in a proper fashion, and therefore it doesn't count as being on. So you may not have known that. Hopefully you know that now. The good news is you were a passenger and or a seatbelt ticket doesn't count against your driving privileges anyway, but it is a fines and costs. So because I found you responsible on this citation, you would have a decision to make. One is you could accept my finding, then you would call the court to make arrangements to pay that fines and costs. Or you could say, I don't agree with what just happened there. I wish to contest this further. Go to the next thing, which is called a formal hearing in front of the district court judges with the prosecutor's office. If you wish to do that, you must do that within 7 days of today's date. That window of opportunity closes, and you must come in and do that formally in writing because you'd have to post the bond. Do you understand your rights on appeal?
Yes.
All right. Then you're all set, ma'am. I'm going to go ahead and release you.
Thank you, Your Honor.
And Ms. Long, just to let you know, you may want to call, I think it was your mom. She was trying to call because she wanted to be here. The thing we're doing now where you see the deputy, you see me, and I see you, that's for parties. In other words, like the person that got the ticket. What I told your mom she could do is this is also being streamed live on YouTube. Anybody, it's like a public courtroom. Anybody can go to YouTube and watch what happened, but they can't necessarily be here if they're just say a parent of someone who got the ticket. Does that make sense to you?
Yes.
All right, you may want to call her. I'm sure she's curious about what just happened. All right, thank you.
Must be in there by herself.
Yeah, she is. I don't know why it's not. It said, please join me. Just close the breakout room. Council, you can just come right up here. We're gonna call this first. Let probation know that there's a resolution, and so we would probably have to do a PSI right now since we already have the interpreter. I don't know. I'm sorry, I don't know what that. I don't know where that's coming from. Madam Interpreter, is that coming from your area? Yes.
Can you hear me?
I can hear you, yes. Okay, can you ask Mr. Kang if he can close the door there?
Okay.
I close it, yes.
It is closed.
Just close it, the door.
I don't know.
The carpet, you know?
Yes, I did.
Can you turn the volume down?
Why?
Volume to
I need to ask the police. I think the song, they want us to volume down or volume down.
Good morning, Deputy. There's a reverberation coming back through, so I think that maybe it may be a little too loud in there.
It's too loud.
Is that better?
I'm sorry, we had a pipe burst this morning. We had a flood. And it was in this area, so things are, it's been an interesting morning.
Yes.
Yeah, I
Can you,
can imagine. Okay, so.
How's that?
I think that's better, but we'll try it. Okay, thank you. All right, we are going to go on the record in the matter of the city of Riverview versus Lie Thing 231840A and B. And counsel, your appearance, please.
Good morning, Judge Danny Batty, appearing on behalf of Mr. Thing.
Okay, I'm going to need you to speak directly in the microphone and as loud as possible so they can hear you.
Good morning again.
Closer to the microphone.
Attorney Danny Batty, appearing on behalf of Mr. Thing, it's P84624, and I'm standing in on behalf of the attorney of record, Andrew.
All right, thank you. And Madam Interpreter, can you please state and spell your name for the record?
My first name is R.O. My last name is Lian. And then my interpreter ID 132318. Can you hear me?
Yes, thank you.
Okay.
Okay, and Miss Lan, how do you pronounce your last name?
Oh, Tang, T-A.
Yeah.
Oh, sorry.
I'm sorry, ma'am, how do you pronounce your last name?
Lian, Lian.
Leanne, okay. All right, so Madam Interpreter, can you please raise your right hand? You solemnly swear or affirm and promise to transfer accurately and honestly from English to Burmese and Burmese to English to the best of your ability?
Yes.
Okay. All right, thank you. You may lower your hand. So counsel, we'll each have to speak slowly and in sections, so Ms. Leanne can translate. Okay? What I'd like to do really is mute the jail while we're talking and your client is not. Okay? Mr. Thang, your name, please. Okay. There's no talking in court. If you have to talk, go out into the lobby, please. Yes, the two in the back. If you have to talk, you can go out into the lobby, okay, please? Okay, so I'm going to mute Mr. Tang while there's talking outside of Mr. Tang needing to speak, but counsel, but Madam Interpreter, I'm going to have you still interpret, okay?
The defendant speak English very well. I will only translate when he doesn't understand. So yeah, he will raise his hand or, you know, he will ask you a question if he doesn't understand. He pretty much understand English very well.
Oh, okay. All right. Well, for right now, I'm going to mute you, Mr. Tang, for a moment. Do you understand all that?
Yes, ma'am. Yes, Your Honor.
Okay. All right. That way, at least we can get through some of it without the reverberation. All right. And so, counsel, today is the date scheduled for the pretrial in this matter. And there's been a resolution?
That is correct, Judge. Our understanding is that in exchange for a plea of guilty to operating while visibly impaired, the original count of operating while intoxicated would be dismissed, as well as the civil infraction for the preliminary breath test refusal would be dismissed as well.
Tuပြောတာကြားနိုင်တယ်နော်အဲ့ဒါတော့ဘာသာပြန်ဖို့မလိုဘူးနော်သူပြောတာကြားနိုင်လား
Can you hit unmute or no? We have to maybe wait the 30 seconds. Okay. He's unmuted. So what was that, Madam Interpreter?
He cannot hear us.
Yeah, I can hear right now. Yeah.
Okay, he can hear us right now.
Okay. And so, Mr. Tate, you heard what your attorney placed on the record?
I wasn't here because his voice very low.
Okay, so I'm going to repeat in summary what he indicated. That you're going to be pleading to an amended charge of operating while visibly impaired, and the other two matters will be dismissed.
Yes, Your Honor.
Do you understand that?
Yes.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. All right, as to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Yes, Your Honor.
And interpreter, can you please interpret for Mr. Kane?
He said, yes, Your Honor, he understands.
Okay, so my question was, as to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Your voice is
How I
in and out. We cannot hear you, Your Honor. We cannot hear you very well.
Okay, I've never been accused of being quiet, but okay. Let me try it again.
Can I? Yeah, it's a lot of noise. We cannot hear you very well.
Can you repeat again, Your Honor?
Okay, so this is problematic because of all the reverberation from the jail. Can we try?
Yes.
The interpreter while you're talking? No, it's the jail. That's where it's coming from. But every time I unmute, we have to wait another 30 seconds because he doesn't have the remote himself. So I guess we'll just have to do it that way. Sir, as to the amended charge of operating while visibly impaired by alcohol, how do you plead? Hold on until you're unmuted, just a moment.
Okay. Kuna runga tu piora chana la. Piora chana na mati.
Yeah, ဘာသာပြန်ပေးပါအောင်သူဘလို့ဘာပြောရအောင်
Oh, eri kuna runga de kamya di amune patelu bono zunatin nak akong ka atu ka zay runga da ki
Madam Interpreter, excuse me, Madam Interpreter. I can't have the two of you having a conversation. Whatever he just said to you, you now have to say directly to me.
Okay, he said I am asking if he can hear you very well, Your Honor. We cannot hear you guys because of the connection problems, Your Honor. I cannot hear you very well, so I think I will excuse myself to let me go because of accuracy and the professionalism. I don't think that I can do this morning. I am so sorry, Your Honor. I cannot hear you guys very well.
No. That is not how that works. You are here to provide a service to the court for translating. So
Yes,
you need,
yes, Your
you
Honor.
need to stay until you're excused.
I cannot
We've
hear
already
you guys.
adjourned. Then please adjust your volume on your headset.
It does not work, Your Honor. I am so sorry, Your Honor. Please excuse me. Or
No,
I am.
I am not excusing you from these proceedings.
I cannot hear you guys, Your Honor. So I am not able to translate very well. If I cannot hear you, this is technology.
Then find another device to utilize for your sound.
Your Honor.
Can you hear me? Can you hear me better now?
I cannot hear you guys, Your Honor. Please excuse me to let me go.
No,
because
no,
I don't want.
No. Please get a different device. Can you hear me now?
I will try my best.
Try another device. Bless you. Can you hear me now, Miss Leanne?
Yes, please give me one moment, Your Honor. Let's try one more time. I think it's better, but I am not sure if it's still going through very well.
Ma'am, can you hear me, Miss Leanne? Can you hear me?
Yes, I can hear you, yes.
So I don't know what the problem is because earlier you didn't have an issue hearing me. So I don't know what the problem may be, but we've already adjourned this matter for a month so that we could find a Burmese interpreter. So I'm not going to excuse you. We are going to continue with these proceedings. Can you hear all of that?
I can hear that, yes.
Okay, very good. So we're going to try this again. As to the amended charge of operating while visibly impaired by alcohol, sir, how do you plead?
Your Honor, this is this question you asked the defendant, right?
Yes.
Okay. ကျွန်မပြောတာကြားနိုင်လားကဟုတ်နှစ်ထိတ်ခေါမှာ
We have to wait for him to unmute.
Can you hear me, defendants? Can you hear me?
Yes.
Okay,
Yes.
you can hear me? Okay, yes. ဟုတ်တယ်အခုနတုန်းက judge ပြောတဲ့ဟာကပေါ့နော်အတူအချင်းမိခါအတူအေcouple နဲ့တီမီဟိနှစ်ထိတ်ချင်မောစိတ်တစီတဲ့နှစ်ထိတ်ကို in mirang ho den rak chim cha. Yes, I'm done, Your Honor.
You're done with what?
I am done with telling him what you tell him. I am not sure if can you hear me, defendants? ကျွန်မပြောတာကြားနိုင်လား
ကြားပါတယ်
Okay, I can hear you, Your Honor.
That's great. I'm still waiting for the answer as to how Mr. Tane pleads to the operating while visibly impaired by alcohol. Do you plead guilty or not guilty?
I'm guilty, Your Honor. I'm guilty, Your Honor.
I am guilty, Your Honor. That is his answer.
Okay. Sir, you signed your advice of rights, correct?
Yes, Your Honor. Yes.
And you understood all of those rights?
Yes, Your Honor.
Do you understand that by entering into a plea, that you will be waiving your right to a trial?
Yes.
Do you also understand the possible penalties as a result of your plea?
Yes, Your Honor.
And those penalties could be in this court, any other court, or administrative agency. Do you understand that?
Yes, Your Honor. Yes, Your Honor.
You also could have some citizenship issues. Do you understand that?
Yes, Your Honor.
Or immigration issues.
Yes, Your Honor.
And knowing all of that, do you still want to continue with your plea?
Yes, Your Honor.
And Mr. Tang, do you understand everything that's happening right now?
Yes, Your Honor. Yes, Your Honor.
Please tell me what is happening right now.
I'm playing my
What is that,
I'm
sir?
agreeing whatever you said that could happen, affect my immigration or whatever it is. And yeah, I understand all this what you said, Your Honor.
Counsel, do you agree or not that your client understands all of his rights?
I would agree that my client understands all his rights, Judge.
Has anybody promised you anything or threatened you in any way for you to enter into a plea today?
Mr. Tang, tu piora ka bale suyeno de kamya ka bono vei lo ke ma kamo kapal tia chim dingin mi dang ni an chim na mo ti mi ka se mo nang ma nam mo na pal ti mi ka nai take mi da si ti mi se
Kematin kapal ka thay ko. Kematin kapal ka thay ko.
no, I know myself guilty. Nobody advised me.
Okay. Counsel, do you want the court to do the voir dire for the factual basis, or do you want to do that?
If you wouldn't mind, Judge, I prepared him for every question that you're going to ask.
Okay. And sir, on July 22nd, 2023, were you operating a motor vehicle in the city of Riverview?
Yes, Your Honor.
Prior to driving, did you consume alcoholic beverages?
Yes, Your Honor.
What did you have to drink prior of an alcoholic nature prior to driving?
Can you repeat again, please?
What alcoholic beverages did you drink before you got in the car and drove?
I do not remember how much I had, but I had some beers. Bud Light, I had some, yeah, Bud Light, but I don't know how many beers I had.
Okay. And did drinking those beers cause you to drive in a bad way?
Will you please repeat, Your Honor?
Did your drinking the beers cause you to drive a vehicle without turning your headlights on?
Yes, Your Honor.
Counsel, do you stipulate to a 0.13 for the alcohol content?
For purposes of the plea, Judge, we do.
Counsel, are you satisfied with the factual basis?
Satisfied, Judge.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. We will schedule this matter for sentencing.
Yes, Your Honor. Please give me a few minutes to translate that. Oh, Mr. Tang, atu na etching ni kana ti kama. Atu ka ati chang kan tila tu atu lolo fe tu ati chang I napal mi zong na thei volunteering na to mi si I atu napal mi zong ka mati jun sentence an chianak cha kan ti schedule and sweep yak chan la ti mi de chiman tu na. I am done, Your Honor.
Okay, we will schedule this matter for sentencing October 25th at 10:30 a.m. Does that work for you, counsel?
It will work, Judge.
Bond and conditions are continued. And I have our probation department on the screen. They were on the screen.
I'm calling her.
Okay. So that I can place you in a breakout room for the pre-sentence investigation.
Okay, I hope me kana tema atu kaju probation officer te heti bechim naka asilai ma di kajon breakout room danga kan an kan chat fan lai ma dan tat nu dan tat nak atua tu ni kan dan tat nak ti mi jo zai dan atua la akar la ka ti mi chim nak kan ma ni kan probation officer ni kan an tua piak la.
Okay.
I'm done, Your Honor.
Okay. All right, so I'm going to put you the two of you and my probation officer in a breakout room so that you can help translate, ma'am, if necessary.
Sure, Your
for the pre-sentence investigation.
Okay. Breakout room akan kal chang la mo ka join chang la I mati chung probation officer ko he kan ni ton khan la.
Okay.
Yes.
Thank you. Have a good day. Off the record.
Judge, I just have one question. It just has to do with appearance. Is he going to be brought in Zoom again for the sentencing?
I presume so.
And for Mr. Hubbs will be back. It's his appearance in person.
Yes. Somebody in person is helpful, but that was rough.
Your patience is great. Have a great day, Judge.
Okay, thank you. You too. Okay. And I apologize for everybody that's here in the courtroom for the wait at the end of this other in custody, and then we can continue with the rest of everybody. Yeah, then we'll have Sarah Kelsey. After that, after the in custody, it'll be just a moment, ma'am. I'm just letting you know what's next. Mr. Westmoreland, did you do the in custody?
Mr. Surratt. I did the felony in custody.
Oh, I'm sorry. Okay.
You want that now?
Oh, that's what we're doing now. Yes, we have the jail on. All right, let's go on the record as a matter of the state of Michigan, where's Vincent Schroeder.
Court does call the case of the people versus Marcus Murray.
Good afternoon.
On behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Murray. Mr. Murray, can you state your name for the record, please?
Excuse me, Marcus Murray.
Okay. What are we doing on this case?
Your Honor, today was the date scheduled for a pretrial on this matter. Mr. Murray was picked up on a bond violation on Friday. I believe the complaining witness in this matter is present and she would like to speak to the court regarding the bond conditions that are in place.
And Your Honor, I don't believe that that's appropriate at this time, given the bond violation reports that Ms. Weidling sent over to us for today's hearing.
That's on, I'll get my date on September 8th.
Good
Hang on, let me just-
Your Honor.
Hold
Ms.
on,
D,
ma'am.
please do not speak until the judge lets you.
I see that. Counsel, before I hear from anybody regarding anything, as to the bond violation.
Your Honor, Mr. Murray admits he had contact with Ms. G on Friday.
So he's admitting to the violation.
Yes.
What reason? Excuse me.
Yes.
Your Honor, I apologize, but it was a major situation for me to do what I did. Actually, I don't know if you were told or not, we have a child that's in foster care. I went and I actually went with Miss G to actually get inpatient, to get her meds straight. Get that situated, then turned over to clothing and everything that the actual foster care parents have wanted her to bring to the facility. And that's why I was there. And when I was loading her car up, they said that I was actually breaking in the car, which it turned out that I wasn't. And that's where, I admitted to the officer with the situation. I am not a threat. I am not a menace to society. Actually, a lot of people depend on me and my livelihood. And if I can say one more thing, on Thursdays is my visitation with our 8-month-old daughter. And the reason why it was a panic situation is because our daughter caught hand, foot, and mouth disease in foster care. And so I had to straighten a lot of things out.
Right. Well, I don't have any information regarding what you're indicating now to the court, sir.
Mhm.
What I will say is this. You were arraigned on August 10th, and the conditions were very clear, and you
Well,
could
they
not
told-
have contact. Well,
Yeah, but they
hold
told
on.
me.
Mr. Murray, do not interrupt the judge, okay?
Okay, my apologies.
And you were not to have contact. Were there something that could have arisen or did arise, then that's when you need to get in contact with your attorney or somehow or another try to figure out how this could be, because it's a clear violation.
Okay, can I say one thing? I actually was speaking to counsel, and then for some strange reason, our phone was actually disconnected when I was actually in Target to tell her all this. And then I actually sent a text message saying that it was very important for her to call me back. For the record, that's what happened.
Yeah, but okay, that's fine. And let's assume that's the case. You have to try to do something before the contact occurs.
Oh, well, I wasn't aware of that. All I know is it was an emergency situation for me to take her to Beaumont intake, and also to take the things that was actually the facility. Other than that, I would have been keeping my distance until we could situate the whole situation.
Well, again, you can tell me all of this, but I don't have any of that information. And if you were in a position that you could have gotten that to your attorney, then fine, then maybe this becomes a different circumstance. I'll give you the opportunity to provide that information to me.
Okay.
But so I'll set the sentencing on the violation for September 18th, 2023 at 12 noon. At this point, however, the bond will continue as denied with no bond, because all I've got is contact, and you were clearly not to be in contact. I will then set a pretrial for that same date at the same time.
So I'm trying to understand, because this is all new to me. I'm trying to understand it clearly.
What don't you understand?
Okay, I know I'm in violation of the no contact with me taking her to the actual hospital and do what I did, but I can get proof of that. But I'm saying, what you saying, you're denying the bond?
I'm leaving the bond there's no bond at this point, because all I have before me right now is a violation.
Okay, so what do I need to do?
Mr. Murray,
You need to talk to your attorney.
Okay.
So that they can get whatever information they need to try to get that to the court for the sentencing that I've set for next week.
Your Honor, may I speak?
Ma'am, I don't mind hearing from you, but it's not going to change my position at this point on it.
I can
And
provide
don't know-
the hospital documentation. If I can provide that, fax it to you, I can provide that.
Well, you might want to provide that then to the prosecutor's office, who can get it over to defense counsel.
At this
explain this.
point, we have a daughter in foster care, and I have no family support, and I depend on him for support. We have visitation with our 8-month daughter in foster care, and I don't have any family support, so I look up to him.
Ma'am, I understand what you're telling me. All right. I think that Mr. Murray indicated in essence the same thing to me. What I'm telling you, as I told him, I don't have anything in front of me to indicate that what you're telling me occurred on that day.
I have the paperwork in front of me right here.
All right, you can go ahead and keep talking because I'm not going to be interrupted. I'll explain to you where I am on this, but if you're going to interrupt me, I'm done then.
My apology.
So are you finished?
Yes.
So what I'm indicating to you is that all I have in front of me is the report. Rather than sentencing him on the violation, because I could just sentence him on the violation and probably wouldn't like that sentence. I'm giving an opportunity for Mr. Murray to provide the information to the court before I do anything else.
Okay.
That's why I set it to next week. Whatever information is out there that you can get to the prosecutor's office, maybe get to, so that they can get it to defense counsel. But if you get it to the prosecutor's office, maybe the prosecutor's office position changes regarding the bond violation.
Can I say
regardless of the fact, what I indicated to Mr. Murray is that while these certainly I can understand the circumstances may arise, he needs to get to his attorney before this happens to try to prevent this from occurring.
But I was
But
in a
right-
process. I'm sorry for interrupting, but I just want to let you know this court date that's set today, I was in a process of trying to tend to this court date to not pursue with charges because it's not worth it. It's not worth it. It's not.
Ma'am, that is not up to me at this point in time. These charges are pending. I'm not even going to go down that path with you at this point. What I've got before me is a bond violation. I'm indicating to you how that may be able to be corrected.
Okay.
So
I understand.
And that's the best I can do at this point in time because I don't have anything in front of me other than that. So I'm giving Mr. Murray the opportunity to get something to the court.
Okay.
And maybe that will change the court's position. You indicate, ma'am, you're in possession of certain things. Get those to the prosecutor's office. Maybe something prior to the 18th can be worked out. I don't know.
How can I get this to them today?
I think have you been in touch with the victim's advocate?
Yes.
Okay. I'd suggest working through the victim's advocate to try to get that information.
And what is it? Just the hospital documentation of the crisis I had over the weekend?
If there was hospital Mr. Murray has given to the court his explanation for why the contact was occurring. Anything that would bear on that, I think should provide to the victim's advocate as well as that Mr. Murray, to the extent he has access to it, can get it to his counsel.
Like I said, this is rough on me because I depend on him with this whole foster care setting.
Ma'am.
Listen, I'm understanding now. So basically, I'm here until sentencing, until the paperwork is presented before you.
Gee, I said that probably about 10 minutes ago.
Okay.
And maybe if everybody would stop talking and listen to what I'm saying and get the information to counsel, something may be able to be worked out prior to the 18th.
Okay.
But
thank you, Your Honor.
You can talk at me all day. I'm not moving on where I am.
Yes,
I don't have anything to move.
Can I speak to my counsel in the breakout room for a second?
Mr. Murray, I'll come to jail and meet with you, okay?
They'll come and see you. I'm done. Bond continued as I just indicated. Thank you. Okay, we're done till 1:14. Court does call the case of the People versus Marcus Murray.
Caitlin Kirby on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Murray. Mr. Murray, can you please state your name for the record?
Marcus Murray.
What are we doing on this case?
Your Honor, we are here for a pretrial and a bond violation sentencing. I can address both in the court, in the way that the court wants, either the pretrial or sentencing first.
Whatever your pleasure.
Okay. As for the pretrial, we are requesting that we set this for a final settlement conference.
Jury final settlement conference. October 13th, 2023, 9 a.m. Jury selection if necessary, October 16th, 2023, 8:30.
Thank you, Your Honor. And as for sentencing, I did submit a bond motion and sentencing memorandum. I would rely on that sentencing memorandum for sentencing, but happy to answer any questions that the court may have.
And Your Honor, I did provide Ms. Prenny with the information that you had asked the victim to get to our office. She did send it to the victim advocate. Proof that she was in the hospital that day. I did forward that to his defense counsel. My concern is that she made it here to try to get that information to us. So obviously she has other means of transportation that would have not been Mr. Murray given the no contact order. And then we heard from the defendant himself saying he understood that there was a no contact order, but in that situation, she needed to go to the hospital. It was urgent, and there was a necessity for him to contact her. We kept everything as is, as the court wanted to hear and see the information from the victim and hear from the public defender as well as the prosecutor. Unfortunately, as of this morning, since our last hearing, while waiting for that proof, Mr. Murray has contacted the victim 55 times in custody. So I have the phone calls, I have the logs. I can send that to Miss Prenny. It appears that under his inmate ID, her number has been dialed from 11th to the 17th.
I'm sorry, what was the last part you stated, Ms. Kirby?
Her number has been dialed the days since the hearing from September 11th to the 17th. So that the last call was yesterday at 6:47 p.m.
Counsel, anything you want to say to that?
Your Honor, I was not aware of that contact. Mr. Murray does seem shocked by that. I have not spoken about that with him. However, I do know Miss G is here. She was present last Monday, and she did want to request that no contact order was lifted. I did inform Mr. Murray again after last hearing that he was to not have contact with her. At this point, again, she does want the no contact order to be lifted. I did say explain in the sentencing memorandum about those previous contacts. I don't think Mr. Murray is a threat or there's any fear of physical harm coming to Miss G. I think Mr. Murray is eager to resolve this case, get this behind him, and again, Miss G is here again. I have not spoken to her since our last hearing, but again, she was, present, asking for that no contact order to be lifted last Monday.
Hang on a second. Thank you. Part of the court's concern is that while everybody was trying to get everything together to justify or at least give the court information regarding the previous contact, and counsel for the defendant prepared an extensive sentencing memorandum, it appears as though Mr. Murray can't follow the court's direction to continue no contact. Now I see him shaking his head. I mean, is he disputing what the prosecutors indicated regarding calls?
Can I speak? Am I allowed?
Well, you can if you want to, but you might want to talk to your attorney before you start saying anything.
Can I go in the breakout room for a second?
Well, given it that it's new information, and it's the last jail, right? I'll let it happen this time, but normally it's not how it works. So if we can put Mr. Murray and Ms. Brenny into a breakout room, I'd appreciate it. And court will stand in recess.
And I am sending the log to Ms. Perenni and to the court.
Alrighty, thank
Is
you. Yeah, okay. Okay. We're back on the record in the case of the People versus Murray.
Thank you.
Your Honor, I did speak with Mr. Murray and I did receive the log from Ms. Kirby. Mr. Murray does admit and would like to provide an explanation of why he had contact with Ms. G over the last week.
Okay.
So
he admits to these violations.
Yes, the contact, yes.
Okay, what's his reason?
So he told me that he was having contact with her because at the last hearing, he believed that he needed to get the documentation that was provided in the court, to the court in the sentence memorandum, and bond motion for bond reconsideration. And he thought he needed to work with her to get the court that information.
Really?
He believed that trumped in a way the no contact order, that instruction. I did reiterate to him that again, he was to have no contact with Miss G. He also stated that he was helping him manage his affairs. He had no one else to help him with manage his work, his bank account, things with their daughter who was in foster care. And that is why they had contact over the last week.
55 times to do all that?
Your Honor, my sister stays in Dallas and the other sister stays in Phoenix. And I sent money to one of them. I sent order for them to actually put money on their account so they can actually take care of my affairs. But for some strange reason, it wasn't working out. So my daughter is in foster care and I have an appointment tomorrow with a cancer doctor. So I've been calling to actually connect the dots. Honestly, I am not a violent person. I respect the court. My apologies to everybody involved in this misunderstanding. I don't even go through this. I don't even know how this stuff go. You know, I just want my daughter back and I want to take care of my health and do the right thing.
55 times?
Yeah, because some of those times I was on the phone with other people to actually make sure stuff is being done. I have contract obligations outside of here, and some of those contract obligations, Your Honor, that if I don't make through with them, then I'm gonna be, I'm gonna owe some people money on different things. I do. The court probably don't know anything about it. I do art projects and exhibits, and I also do a mentoring program with a couple of actual artists that actually go out and perform and stuff like that. So there's a lot of stuff outside of my regular life besides this mix-up that's very important. But the main one is my daughter. I visit my daughter every Thursday to actually get her up out of the system, which it was a misunderstanding with that we're working out. So my apologies to the court, and I'm asking for mercy. I don't care if I'm out on a
Mr. Murray, that's, I think you provided a sufficient explanation.
Thank you.
Yeah. It's like 11 hours of talking to do all that
Yes, sir.
over the past week. Well, let's see if we can make it any further. Because I'm adjourning the sentence on the bond violation, the previous one as well as this one. I'll set that for a special day, October 3rd, 2023 at 1 p.m. His bond will continue as revoked until he understands how he's going to operate. Thank you. Yeah. Can we go off?
I really don't like cases where they don't show the people who are talking. And in this case, there is a prosecutor in the courtroom as well as 2 witnesses. And that drives me crazy. But after watching the case, I really think it's worth the watch. This is a dog bite case. It's pretty interesting. Give it a chance.
For the people.
On behalf of the people.
All right. And then, ma'am, if you could state your name, spell your name for the record.
Camille Delaplane, Camille, last name Delaplane.
Camille is an E at the end, not an A?
Yes. Yes.
All right. I'll need to correct that. All right. So we're here on this file, and we are ready to proceed because the dog is with the Sheriff's Department at this time, right?
Yes.
All right. The people wish to make an opening statement?
Your Honor, to send people away of opening statement, just proceed to proofs.
All right. And so, Ms. Delaplane, you could either make an opening statement now or reserve it for when it's your turn for proofs. The people have asked to just skip that part and go right into testimony.
I will reserve my speech.
All right. People may call their first witness.
Thank you, Honor. The people call for Sergeant Johnson.
Want to come up to this seat right here. Before you do, I'm going to swear you in. So if you want to raise your right hand, you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth. All right, go ahead, have a seat. And I heard that your last name is Johnson, but if you want to state your full name, well, your first name and your last name. Johnson, I'm pretty sure we know how to spell, but maybe spell your first name.
Yeah, Cassandra Johnson, Cassandra.
All right, and Mr. McCullum, you may proceed.
Thank you, Honor. Ms. Johnson, do you currently have a dog?
I do.
What type of dog?
Dachshund.
Right, and how old is this dog?
She is 13 and a half.
Right, and did you have the same dog on July 25th of this year?
Yes.
Okay. And on July 25th of 2023, were you at the Tri-Ponds Campgrounds?
Correct.
And is that here in Allegan?
Yes.
And is that in Allegan County?
Yes.
Okay. On that day, did you have an encounter with did you and your dog have an encounter with another dog?
Yes.
Can you describe that dog to the court?
Looked to be a full-grown pit bull to me. Just not a very nice dog.
Can you tell the court what happened exactly?
I was walking my dog on her leash. I looked down at my phone to text my mother because it was her birthday. And next thing I know, I hear my dog cry, and this dog is just on top of her and won't let go. I kind of tackled him a little bit to the ground and rough handled him, and I couldn't get him off of her.
Gotcha. Did your dog sustain, due to this incident, did your dog sustain injuries?
Yes.
What injuries?
She had 2 smaller lacerations and 1 large one that they sewed up at the emergency vet that day.
All right. And these lacerations, were they caused by a bite or a scratch?
A bite.
A bite?
Mm-hmm.
All right. And did you yourself suffer any injuries?
I did get bit because I grabbed the dog, just injuries to my thumb. They didn't give me stitches because they didn't want to lock in the infection, but it was deep enough for stitches.
And you have permission to approach for the marking of evidence.
Okay. You already have them previously marked, or you mark them now?
Oh, not marking now.
Okay. 3 pictures.
Ms. Johnson, I'm handing you what's been marked as plaintiff's exhibits 1, 2, and 3. Can you take a look at those photos?
Okay.
Oh, can you take a look at each? Sorry. Do you recognize those photos?
Yes.
When it comes to people, plaintiff's exhibit number 1, is that a fair and accurate representation of the injury that you sustained due to this dog bite?
Yeah.
Okay. I'll just go to people plaintiff's exhibit number 2. Is that an accurate representation of the injury to your dog?
Yes.
And plaintiff's exhibit number 3, is that also an accurate representation of the injury that your dog sustained on July 25th, 2023?
Yes.
And at this time, the people move to admit all 3 of plaintiff's exhibits.
And Ms. Delaplane, do you have any objection to the people's entrance of those photos into evidence?
No, sir. I haven't seen the photos, or that I wasn't aware of the injury either. So, I don't know what to say to add to that.
Without objection, they'll be submitted into evidence.
Thank you. No further questions.
All right, so Ms. Delaplane, this is now your opportunity to ask questions of Ms. Johnson. Not necessarily for you to provide evidence that you wish to, that comes later in your case, but the people have just did a direct examination of this witness, Ms. Johnson. Do you wish to ask her any questions? It's your opportunity for cross-examination.
Okay. I don't have any questions.
All right. And then with that, there would be no redirect. The court does have a question. Ms. Johnson, you testified that your dog, the dachshund, you were walking the dachshund on a leash.
Mm-hmm.
Did you notice the other dog had a leash?
So we had walked past the campsite on the way to the pool. I had actually looked over at the dog and called it beautiful. I'm not against the breed. I know there's good and bad. It did appear the first time we passed that it was tethered. I don't know what happened to the lead on our way back through. It all happened so fast.
Okay. And does counsel, either Mr. McCollum or Ms. Delaplane have any questions based on what I just asked her?
No.
No questions.
All right. And with that, this witness may step down. Any reason why this witness could not be excused?
No, no objection.
Ms. Delaplane, do you wish to ask the court to keep her around for the rest of the hearing? Or do you have no objection to her leaving if she wished to? So Ms. Johnson, I would tell you, you could do with that what you will. If you wish to stick around, you can, or you're also excused if you wish to. All right. And with that, the case is still with you, Mr. McCollum.
Thank you, Honor. Good call, Rachel Bywater.
Peter, raise your right hand. You swear or affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Please have a seat. And if you could, your first name and last name.
Rachel Bywater.
And with that, counsel, you may proceed.
Okay. Ms. Bywater, where are you currently employed?
I am animal control with the Allegan County Sheriff's Department.
Okay. And how long have you been in that position?
I have been full-time since January, but I was part-time since last summer.
All right. And were you working on July 25th, 2023?
I was.
All right. And on that day, did you receive a complaint about a blue and gray Staffordshire dog?
According to Miss Delaplane's TikTok, the dog in question, whose name is Zoe, is a pitty. However, it's technically a Staffordshire Bull Terrier. And I found a website that looks pretty reputable. It's A to Z Animals that has a blog post that's entitled Staffordshire Bull Terriers versus Pit Bull. What are the differences? And the Staffordshire Terrier is a genetic blend of bulldogs, mastiffs, and terriers, while pit bulls contain the genes of their bulldog and terrier forebearers. Both breeds were originally bred for the purposes of bullfighting and dogfighting. However, Staffordshire Bull Terriers are energetic and good-natured, while pit bulls have brooding personalities. Staffordshire Bull Terriers are the stockier of the two, while pit bulls tend to be leaner and more muscular. Interesting.
We did, both myself and Deputy Kimber. I believe he is the one that went to the call originally.
All right. Can you tell us what occurred with that particular animal?
We got reports that the dog had torn like the tether out of the ground and had come after the dachshund. And then Deputy Kimber can explain more of the interactions he had with the victim.
All right. Were you able to ascertain the owner of that particular animal?
Yes, we were. We were able to, and I made phone calls and spoke with both the victim and the owner at a later date.
All right. And who was the owner of that animal?
That was Camille Delaplane.
And is that blue and gray Staffordshire, is it currently in the custody of Allegan County Animal Control?
Yes, it is.
All right. All right. That's no further questions.
And Ms. Delaplane, would you have any questions for this officer based upon what you just heard?
No, sir.
And with that, there would be no redirect. You can go ahead and step down. And any further witness? Is that the piece of paper that I was talking about? You just bring that right up. That's it. Thank you. And then Mr. McCollum, any further witnesses?
No further witnesses for the purposes here.
All right. And so with that, your 1, 2, and 3 are entered into evidence. Any further proofs that people arrest?
Yes.
All right. So Ms. Delaplane, at this time, the plaintiff has rested their case. This would be your opportunity to either make an opening statement, or you could just call witnesses, and that's kind of awkward to how you would do it if you're planning on calling yourself. If you call yourself to testify, you don't have to ask yourself questions. You'd be able to testify in a narrative fashion. Which pleasure?
Mhm.
You wish to testify?
Yes.
All right. And the first thing I'm going to do is swear you in. If you could raise your right hand. You swear affirm anything you testify to here would be the truth, the whole truth, and nothing but the truth.
I do.
All right. And then, like I said, you are able to sort of testify in a narrative fashion. Otherwise, it would be kind of silly sounding for you to ask yourself questions in the third person. I would just ask you that if you hear Mr. McCollum make an objection, then please just pause and allow me to deal with that before you would continue. But you can go ahead.
On the day of the event, my dog was tethered to the ground. She had a stake in the ground attached to a long line that was not long enough to reach the road where everyone was walking and biking. I had no reason to believe that she would be aggressive. She was doing great with any person that came by and wanted to pet her and give her attention. My child and I and my friend Jen and her daughter were about maybe 50 feet behind her in a little pond, just swimming and playing. I had got out of the pond and was sitting in a chair, maybe 25 feet, 30 feet closer to her. And that is when I noticed that she had pulled the stake out of the ground and she started running. I immediately got up and started running after her. I just couldn't catch up to her in time to prevent the incident from happening. The unfortunate thing is if I'm sorry, I don't know her name. The other owner would have not been looking at her phone and paying attention. She could have easily prevented it by picking up her dog, and then it wouldn't have happened. Not that it is her fault. So when I was able to catch up with my dog, I did my best to remove her from the small dog, trying not to jerk her to cause more injury, but trying to release her mouth from the other dog by, pulling on her neck. And
I thought this might be a good learning opportunity for us to, figure out what to do if our dogs ever attack another dog. So if your dog is actively latched onto another dog, what you do is you pick up their hind legs, so they're balancing on their front legs. Their mouth is still locked onto the other dog, but then you start walking them backwards. And this keeps them from biting you, and it also makes them let go of the other dog. It's called the wheelbarrow technique, and it's from the American Kennel Club. Today we learned something.
Gentleman came up on my right and started punching my dog in the ribs several times to try to get my dog to release as well. And eventually my dog let go. It was probably only a matter of 30 seconds or so. It seemed longer, but it was probably just about that short of time that I got her free. And I pulled her away quickly, caught my breath, and then I started taking her back to where my campground is to get her away from the hysterics. The other owner was screaming and being very frantic. I didn't feel that was good for either of the dogs. They needed to calm down and be separated. At that time, I believe her name is Rachel, the owner of Tri-Ponds, or manager, came up to me and said that if my dog is that aggressive, she needs to be removed. I responded that I did not realize that she was aggressive at all, but yes, I was leaving. And so I brought her into my tent to take off her leash and try to catch my bearings and figure out what I was doing. And then I loaded her in the car, where I was then questioned by animal control, or the manager who was talking to animal control. I'm sorry. It's been like a month since this happened, so I'm trying to remember the specifics. But that is exactly what happened. I also have a witness statement from my friend Jen that was there and did witness this event.
All right, but we're gonna hold up before you would proceed to that, because that's separate, almost like calling a different witness. So are you done with what you wanted to say on behalf of you?
Yes, sir.
All right, now Mr. McCullum would get a chance to ask you questions since you just testified, if you choose to. Mr. McCullum.
Oh, thank you, Your Honor. Ms. Delaplane, you indicated that that you actually saw your dog biting the other dog. Is that correct?
When I got closer, yes, I realized that she had a hold of the other dog.
All right. And that would be a bite, is that right?
I'm sorry, it's hard to hear you.
And that would be a bite, is that correct?
Yes.
All right. And you indicated that another person came out there and started punching your dog and it didn't release immediately.
I'm sorry, can you repeat the question?
You indicated that you another person, you believe you said a man came up and started punching your dog. I was asking at that time your dog did not release immediately. Is that correct?
To the best of my memory, yes, that's correct.
All right. And you're at the time that this occurred, your dog had freed itself from its restraints. Is that correct?
I'm sorry, I did not understand that question.
At the time that this occurred, your dog had freed itself from its tether. Is that correct?
Yes.
All right. No further questions.
All right, and then Ms. Delaplane, you would have a chance to respond, but just to the questions that you were just asked. Or you could choose not to, but you would get a chance to do what's called redirect.
I don't have any response to that.
All right, and then I think you said that you essentially had a witness statement you wish to read from another party.
Yes, or I could share my screen. Whichever you
Well, I
prefer.
think it would be easier if you were to proceed with that evidence by reading it out loud. Who is the statement from?
Jen Van Drought, I think is how you say her last name. I've always had trouble pronouncing it.
Any idea how to spell it?
I can get it for you.
We'll do it phonetically at this point. Any objection to her presenting this?
Okay.
All right. So I think it would be best for you just to read that out loud. In other words, we know this is the statement of a person who was also there witnessing this, right?
Yes, sir.
All right, go ahead.
I was camping with Camille when the incident happened. Leading up to the incident, Zoe had been acting very calm and non-aggressive. She was always on a leash or tied up at the campsite, and I never heard her bark or pull at her leash. I had no concerns with her around my 6-year-old daughter. She was laying very calmly by us at the opposite end of the campsite while we were watching our girls play in the pond by Camille's campsite. We suddenly heard her take off, and while Camille tried to stop her, she managed to pull the stake out of the ground, which she had never attempted to do. Camille ran over trying to get her to stop attacking the other dog, and another guy came running up to help also. He was hitting Zoe continuously to try to get her to stop. Once she let go of her dog, Zoe backed off from the dog instantly. Once she came back to the campsite after the incident occurred, she was once again very obedient and calm. When Camille was told that the dog needed to leave the campground, Zoe jumped right into the car very obediently. And I have her spelling, Jen, Jen, Van, Van, Drought, D as in dog, Ragt. And her phone number she left as well, 616-886.
Don't necessarily need to
Okay.
put that on record, I don't think.
Okay.
I want fans of the hearing who are watching on YouTube start calling your friend, so I don't think that's a necessary part. All right, so that was the end of the statement?
Yes, sir.
All right. And essentially, Mr. McCollum, I would give you an opportunity if you wish to inquire of Miss Delaplane any further information about Miss Drack.
No. Okay.
All right, then the case is still with you, Miss Delaplane. Do you have any additional testimony or evidence you wish to provide at this time?
Yes, Your Honor, if it's permitted, I just wanted to bring to the court that my dog has.
Well, Let me just interrupt you for 1 second. After this stage comes a time where you will make argument, just like Mr. McCollum will make argument, where you can essentially say anything that you want because it's not necessarily testimony. But just to be specific, that's coming later. What I'm asking you now, is there any further evidence or testimony you wanted to put on record that would essentially be under oath?
No, sir.
All right, so you rest at this time.
Yes, sir.
All right, people have any redirect? No. All right, then it would be the time for argument. Like I said, Ms. Delaplane, I'll kind of explain this a little bit to you just because you're not an attorney. Mr. McCollum will get a chance to make argument. Then you will get a chance to make argument. Then Mr. McCollum gets to make argument one more time. Then we would proceed with my ruling. All right, with that, Mr. McCollum.
Thank you. At this time, the people requested the court find that the dog is a dangerous animal. I understand that with these particular injuries that occurred, we're not necessarily saying that the dog caused a serious injury or death to a person or another animal. However, we would ask that the court find that this animal is a dangerous animal and order that Ms. Delaplane take reasonable steps to make sure that this type of event does not happen again. If that means not taking the dog to the campground, then she shouldn't take the dog to the campground, or she should make sure that she has a proper tether next time she does take the dog to the campground. The reasoning for our request that the court find that this dog is a dangerous animal. We're relying on a testimony of Ms. Cassandra Johnson, who testified that she was at the Tri-Ponds campground here in Allegan on July 25th, 2023. She testified that she was walking her own dog at the time. Sorry, I'm not really great at pronouncing the type of breed. She was walking her own dog at the time, and as this was occurring, Zoe, which is on blue and gray Staffordshire pit bull style dog, that was initially tethered to the ground, managed to free itself from its tether and bite Ms. Johnson's dog. Ms. Johnson tried to wrestle with the dog to get her dog freed, and both Ms. Johnson and Ms. Johnson's dog both sustained injuries due to that incident. It is this reason that we ask that the court find that the dog is that Ms. Delaplane's dog is a dangerous animal. Thank you.
And then Ms. Delaplane, this would be your opportunity to make argument. It doesn't necessarily have to be factual or under oath. You can essentially say whatever you want to say, but it's your opportunity to explain what you want out of this hearing and why you think I should do that.
Essentially, I just want my family dog brought home. I realize that we have a lot more training to do. And I have contacted my trainer about this incident, and she believes it's something that we can work on. I do not look to be bringing her to such a busy place as a campground anytime soon until that's resolved. She's also an emotional support animal to my daughter, so we're missing her at home.
All right. Anything further, Mr. McCollum?
No, Your Honor.
All right. So now at this point in time, this sort of shifts focus from back onto me for my ruling. Essentially, I do not have too much of a contested decision to make here today because the plaintiff in the case, just so you're clear, you may have heard a lot of wording, Ms. Delaplane, but not really understood it, is not asking for me to take custody of this animal and order that Zoe be destroyed. So we stopped short of that, all right? But I'm going to give you the sort of long explanation of how we got there and just how close Zoe came. One of the biggest well, first of all, I do want to get two things out of the way here. One part of these hearings is always where the event took place, all right? Now, if someone runs up into your yard yelling at you and Zoe goes and bites that person, that's almost like the least responsible that Zoe can be. That's Zoe's turf, and some stranger came up there and is doing something to agitate the dog, right?
Mhm.
The worst case scenario Zoe can do is Zoe goes into somebody else's yard completely unprovoked and just bites someone or bites the dog that lives there. All right, that's sort of the most egregious. This is right in the middle because everybody has a right to be at a public place like Tri-Ponds, right? It's like being at the park. Miss Johnson has every right to be there with her dog, all right? And she's being responsible walking her dog on a leash. You have every right there to be with Zoe. And I think this started out responsible. Zoe was staked. Now, Zoe got out of that situation. But here's where I want to be careful with you, all right? At the end of the day, this hearing is going to go kind of the way that you're hoping, right? Zoe's coming home. But I want you to be very clear here. And I know that the Staffordshire is a terrier, but everybody knows that that terrier family also includes what we call the pit bull. And you know all the, clouds surrounding that particular breed. But things like saying that Miss Johnson could have prevented this if she wasn't looking at her phone by picking her dog up, that is just a completely wrong attitude here. She doesn't have a proactive duty to prevent her dog from getting attacked. She's at a park. She should not be expecting her dog to get attacked. The problem here is what Zoe did, not anything Miss Johnson did, or even her reaction to the event. I can imagine that, being, I think, as you put it, hysterical, but, is completely understandable because big dog versus little dog could have gone way worse than it did. And it went bad enough because lots of people would be terrified to see this animal that they care about getting manhandled by a dog that they know is the dangerous dog. All right.
Ordinarily, I would think being admonished by a judge like that would really get it through your head. Okay, yeah, you're right. I need to take responsibility for what happened and make sure it never happens again. But for some reason, I don't think this lady is going to take that and do anything with it. This is a post from her TikTok. It reads, "Children are being murdered and you're worried about my dog. It's time to get your priorities straight." I really don't think the same people that are worried about your dog are the ones who can make a difference in that situation. Yeah, you need to be worried about your dog before it murders another dog. The problem is not the dogs. The problem is irresponsible owners. And this is a prime example of what leads to gorgeous, look at how beautiful this dog is, being destroyed because the owner doesn't take things seriously. The dog has an inherent nature to, be aggressive at times. So you have to train it not to be. Teach it to be a good dog. Don't put it in situations where things like that could happen. And when you think, my dog should have the same rights as every other dog, and my dog's the exact same as every other dog. Well, no, it's not. You chose to get this kind of dog. Now take the extra effort it takes to make sure that that dog's safe and all the other dogs are safe. It really infuriates me when owners are not responsible for their animals. Sorry, rant over.
Right. So I want to sort of separate those two parts of your argument. That's not good argument for you. Here's what is good argument for you, right? That you started out being completely responsible with Zoe. Zoe was tethered to the ground, essentially on a leash in control with you. All right. The problem here is that moment that Zoe got away with, Zoe chose to do with her sort of free time. Now, I will also say that the bite that occurred to Miss Johnson, to clarify that, I don't necessarily consider that to be Zoe deciding, hey, there's this person and I want to bite them. That's probably a lot more wrapped up in the whole confusion of trying to separate the dogs. What Zoe probably wanted to do is go for that little dog, which is exactly what Zoe did. So I'm taking the human bite as not so much a conscious thing that Zoe did, so much as a kind of in the middle of the havoc of what was going on. But going after the 13-and-a-half-year-old little dachshund, it was certainly a conscious act by Zoe. So essentially, here's what happens here. It's what happened and it's where it happened. The good thing for Zoe is that essentially, you know, I think this is an isolated incident. Do you live in Allegan or do you live in Holland? I have two different addresses here for you.
I live in Holland.
Okay. I don't know if there's been other incidences with Zoe up there. I wouldn't know that. That's something that their animal control would know, not necessarily Allegan Animal Control. So I want to be very clear about what the plaintiff is asking for and what I'm going to give the plaintiff is I am going to make a determination here that Zoe is what we consider to be dangerous animal. That in other words, this is Zoe's, if you want to call it first strike, fine, but really also last strike, because now Zoe has moved into category of dangerous animal. All right. So just like someone in the system that's sort of innocent till proven guilty, Zoe had before she was declared dangerous animal, and then this happened. We don't go from 0 to 60. But now this is what I need you to understand. Zoe is now labeled that dangerous animal. So if the same exact scenario happened again, my decision would be different, and my decision would be all the way to you losing custody of Zoe, because Zoe now has that sort of, it's sort of like dog probation, and it lasts forever. So I need you to understand how serious that is, right?
Sure.
And essentially, as far as when we talk about what conditions you're going to put in place for the future, I think that you already know this because you probably do it. But essentially, if Zoe's outside of your yard, Zoe needs to be on a leash, right? If you're walking Zoe, you walk Zoe with a leash. And if you take Zoe to the park, Zoe needs to be, I think, the way you already were planning on doing it, on a tether or on a leash. That's just going to be a permanent condition of Zoe's new life, right?
Yes, sir.
The second thing is, I do think that it sounds like there were expenses involved here on the part of Ms. Johnson, because vets don't work for free. I didn't know if there is a dollar amount or request for restitution, but I would certainly be prepared to order that. Do you have a number? So essentially, at the end of the day, I'm ordered that Zoe be, how they work this is, you're allowed to go pick up Zoe from the animal shelter. You know where that is, right?
Yes, sir.
And Zoe's going to come home with you. Here are the only 3 things that are happening as a result of this hearing. I would mark this and declare this, that Zoe's now in that other category. I've heard of Zoe. If I ever hear of Zoe again, it's going to be bad news. You understand what I'm saying, right?
Yes, sir.
2, I don't think it's fair to Ms. Johnson incurred expenses that are obviously the doing of Zoe, and I am going to order that you would pay that as restitution. I think you understand why I would do that, and that that's a fair thing to do. And third, it's less of a condition, so more as an explanation. Even dog running at large, which we would never say because your dog's running around the neighborhood but not doing anything worse than that, your dog's in trouble. But a dog who's already declared a dangerous animal can get in trouble just from running around loose. You need to make sure that when Zoe's in public, you are in control of Zoe on a leash or on a tether. And tell me you understand that.
Yes, sir. I understand that.
Right. Those are the 3 things that I'm going to find. We'll hear this amount and you would be able to say, you know, I need to see how we got to that number if it's, but.
Your Honor, Ms. Johnson incurred a bill from the Allegan Veterinary Clinic of $532.
Okay.
And the fee for the housing of the animal at Allegan County Animal Control is $250. That would be a total amount of $782. Ms. Johnson did give me an itemized copy of that receipt from.
And I'll ask Ms. Delaplane. Ms. Delaplane, essentially what I was going to say is if it's $30,000 vet bill, I'm not going to order that. You would have a right to say, I'm going to have a hearing. I find $532 to be completely sort of reasonable sounding given that these injuries required sutures and that there was at least 2 places on the dog, or I think it was 3 places. Do you wish to essentially, since we're on record, agree to that, or do you wish to contest that and see the bill and have that sent out to you?
I agree to that, Your Honor.
All right. And then I don't know whether you understood that, but essentially because the animal control shelter, the first condition of a show cause is we don't do the show cause till animal control has control of the animal, that they also have a boarding fee for however many days the animal was with them that you would be responsible for paying. If the dog is not returned to you, they don't necessarily order it. I think that that's sort of, kicking someone when they're down. But because that you are going to be getting Zoe back, that the fee that the animal shelter has for the care and custody of Zoe for the last couple of days here is $250. I would order that as well as what we call costs on this. All right, so you do have some money to pay. It sounds like I'm not going to order things like Zoe continue with the trainer, but I consider that to be a very sort of promising thing that you said. How old is Zoe?
It's 2 years old.
And also because Zoe's still kind of a younger dog, that there's room for improvement here and that you understand the seriousness of how close we came to a very different outcome, and that Zoe, I can't tell Zoe to handle herself differently, but I can certainly tell you to handle Zoe differently, that you understand the gravity of that.
Yes, sir.
All right, so those are the findings I'm going to make. I'm actually going to do this pursuant to 287322, and I'll just mark as under owner shall for paying restitution. Because I'm not going to order the dog destroyed or confined to a premise of the owner under 286A. So you will get a copy of my order sent out to you in the mail, but at this point in time, I think all parties understand the parameters of the ruling I just made, and that either they can just go to the shelter, or you want them to call you and kind of explain things to her? How do you want to handle that?
I'll contact the shelter immediately and she may go to the shelter.
All right, so the shelter will be aware that, later on today, you're going to come and get Zoe, all right?
Yes, sir.
Anything further put on record?
Oh, yeah.
Can return People's Exhibit 1, 2, and 3. Anything further, Ms. Delplane?
No, Your Honor.
All right, I'm going to write up the order, but I'll go ahead and release it. Thank you.
So I thought this whole breed-specific legislation was interesting. I've always seen it like on my homeowner's insurance policy, but it's never really, affected me, so I never paid attention. These are some of the breeds that are affected by it. American Pit Bull Terrier, American Staffordshire Terrier, Staffordshire Bull Terrier, Akita Doberman Pinscher, really? Cane Corso, Great Dane, Bull Mastiff, St. Bernard, Doggo Argentino, Boxer, really? Shar-Pei, Alaskan Malamute, Siberian Husky, American Bulldog, German Shepherd, Rottweiler, Chow Chow, English Mastiff, Mastiff, and Wolf hybrids. Wolf hybrids, well, duh. Some of those surprised me. And there was other ones where I was like, well, why aren't those on the list? And it was kind of interesting. So this website, the Stop the Breed Specific Restrictions, has a lot of information on there, and it's basically talking about where local jurisdictions can put in place restrictions related to owners of those specific dogs, making it necessary to muzzle the dog in public, or spay or neuter the dog, or keep the dog contained in a kennel with 6-foot chain link walls, place vicious signs outside your house, things like that. And I'm kind of curious what everybody's thoughts are on this issue in general. Do you think that those breeds of dogs are the problem? Or do you think that owners not properly taking care of the dogs are the problem? Let me know what you think in the comments, because I kind of want to dig into this deeper. This whole thing is kind of fascinating to me. All right. Thanks, you guys. Have a great day.
I just throw myself on the mercy of the court and you could throw it out, but that, I don't know if that's going to happen. I was guilty, you know, but I didn't really, but the thing about it though, when I was, I probably was going 71, there was a guy that passed me, you know, and I'm thinking, how come he didn't get him, you know? And, but I didn't really feel I was speeding all that much, but I guess I was, but yeah, I throw myself at the mercy of the court.
All right, Mr. Patak, you're late. We were just
Yeah,
about
I know,
to
I'm
leave.
sorry,
You
Your
already
Honor.
we had warrants out on these already.
I know,
But you're here.
sorry, Your Honor.
All right, I'm going to read this to you
Okay.
as I find it. This says that on or about August 24th of 2017 on 12th Street, Door Township, Allegan County, State of Michigan, that you are driving without a license. That is punishable by up to 90 days in jail and or $300 fines and costs. And then I think this must be a whole nother matter. They're so old I can't even find the original tickets, but I'm gonna look, so give me a second. There we go. The other one says on December 30th of 2017, on 138th Avenue in Salem Township, you were driving unsuspended. That is punishable by up to 93 days in jail and or $500 fines and costs. Do you understand these charges?
Yes, Your Honor.
Do you wish to enter a plea of guilty or not guilty to these charges at this time?
I'm not sure.
Okay, I need you to pick one. I really even shouldn't let you be in court here without a shirt on.
Oh, sorry.
You gotta plead guilty or not guilty.
When is sentencing?
Right now, if you plead guilty.
I'll plead guilty.
Anybody force you or threaten you to make you plead guilty?
No.
And are you pleading guilty because you believe you are guilty?
I'm pleading guilty because I want to get these charges done and over with.
Yeah, I cannot accept that. Are you pleading guilty because you believe you did do these things?
Yes.
On December 30th of 2017, were you driving a car here in Allegan County when the Secretary of State told you not to?
Yes, Your Honor.
And on August 24th of that same year, were you driving around Allegan County not having a valid driver's license?
Yes, Your Honor.
All right, so I do find that those are factual basis for me to accept your pleas and that your pleas are knowing and voluntary. Could just be fines and costs at this point. Driving while license suspended, that's $250 fine, $200 in statutory costs, crime victims' rights fee of $75, state costs of $50. You have 3 different bench warrants. So that's $225 worth of bench warrants. So that's $800. All right, right on here, you have 90 days to pay that. The other one is set at $450. I'm going to give you 90 days to pay on that as well. If you need more time than that, that's okay. You can ask the court to get put on a payment plan, all right?
Okay.
Other than that, you picked up 2 new convictions, misdemeanor convictions, and you owe money to the court. But other than that, you're all set.
All right, thank you. Will I receive something in the mail? Will I receive something in the mail? of cost?
You should. Is this a good address for you on 146th?
Correct, yep.
Yes, you will. All
All
right.
right, thank you.
Might as well
Thank
take
you.
the phone call. All right, I give everybody the same 10 minutes or so to be here on time for their tickets. We do have a few more minutes. We could wait for Deputy Ducklow, but Deputy Kling, you're able to testify to this ticket
Yes.
if needed? All right. Excuse me. So this is a citation issued on August 18th of this year on Lincoln Road there at Fillmore Township, Loudoun County, state of Michigan. It's a speeding citation on an actual 70 and a 55. However, deputy chose to write it only as a 1 to 5 over. Mr. Mottman, you're here on this 1 to 5 over speeding citation to do one of three things. First is you could admit responsibility to the citation. 2, you could admit responsibility to the citation, but you wish to provide some sort of explanation to the court as to how or why this happened. Or 3, you wish to contest this citation, in other words, fight the ticket at what we call informal hearing. What were you looking to do?
I would like to contest it, sir.
All right, then I'm going to ask both of you to go ahead and raise your right hand so I can swear you in. Swear and affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Mr. Mottman, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why he issued the citation in the first place. But after that, you'll be able to either ask questions or testify in your own behalf, all right?
Okay.
And with that, deputy, if you want to pick up the narrative somewhere that makes sense, explain the issuing of this citation.
Yes, sir. Me and Deputy Ducklow were conducting a stationary traffic patrol on Lincoln Road and 141st. We were on the east side of the road, stationary, facing north. We both observed a vehicle traveling at a high rate of speed going southbound. Deputy Ducklow activated his radar as the vehicle was going southbound before it passed us. When he activated his radar, he detected the speed of 70 miles an hour in a 55 mile an hour zone. After that, Deputy Ducklow conducted a traffic stop on Eric's vehicle, which was a white Cadillac. After our investigation, Deputy Ducklow cited Eric with a speeding citation for 1 to 5 over. Deputy Ducklow.
Posted?
Pardon?
Posted 55?
Yes, sir. Also, Deputy Ducklow's training. I am radar certified. The radar was checked before and after shift. Deputy Ducklow was operating the radar with me in the vehicle during training.
All right. And Mr. Mottman, what is it you'd like to say?
I feel like I had my cruise control set. I know M40, people tend to go fast, so I always put my cruise control on at 55. So I don't know if it was an error with the radar machine. I don't know what the angle of deflection was when he clocked me. It's just I feel like I wasn't speeding. So.
All right, but your testimony is you think you're going 55?
That's what I set my cruise control at, and unless my cruise control is off.
All right. Well, then let me crawl through it here with the deputy a little bit. So, deputy, when you were visually watching this vehicle, did the vehicle seem to you to be going faster than the posted speed limit?
Yes.
All right. And you said he got a radar reading of 70. Did it tone out as well?
Yes.
Was the tone consistent with a 70?
It was.
And when you said you checked, that radar was checked before and after shift, what do you mean by that?
At the beginning of my shift, I turn on my radar. I make sure that the radar matches my patrol speed while I'm moving and that the tone matches vehicles that I test while I'm traveling. I do the same thing at the end of shift.
And that's against your separately calibrated speedometer?
Correct.
if you had had an issue with the radar before shift that day, what would you have done differently?
If there was an issue with the radar before our shift, we wouldn't use it to track speed. And I would have to notify my supervisor that the radar isn't operating.
If you had written speeding tickets all day long, and then when you did the test after shift, there was an issue, what would you do differently?
I'm sorry, can you say it again?
Yes, if you were writing tickets all day, and then at the end of shift, when you did the self-test, there was an issue at the end of shift, what would you have done differently?
I'm not quite sure. I've never come across that problem. I guess I would have to, I'm not sure.
What would you do with citations you had issued on shift?
Talk to my supervisor, see if they need to be voided.
All right. And any other issue? It's 12:46 at night. You cleared unobstructed. Any other clear and unobstructed view of this vehicle?
No, we were parallel to the road. No obstructions,
Okay.
no traffic or construction or anything in the way.
So, Mr. Botman, for purposes of informal hearing, what I have to do is make sure that the deputy has met their elements. In other words, just so you're clear, that essentially what the officer's testifying to is about 3 different things as far as speed, not just sort of relying on that radar reading. But the first thing is they're saying, as far as visually, that they would have determined that your vehicle was traveling faster than the 55-mile-an-hour speed limit, but we don't let them just sort of guess what speed is, although patrol officers are probably pretty good at that. The other thing too is that radar, it tones out it basically makes a ping, and that the pitch on that ping has to also match the 70. If that's too high or too low from what they're hearing, then they know something's wrong with the reading they're getting. And then the other thing that they're saying is that radar unit, they test it, it goes through a self-actuating test before and after their shift, where it's calibrated, it's tested separately against their calibrated speedometer to make sure they're getting the proper speed check before and after shift. With all those things taken into consideration, I would find that they've met their burden here on this ticket that they only wrote for 1 to 5 over. But essentially what I need you to understand, your rights on appeal at this point, 1 of 2 things: either you agree with my finding of responsibility, you would call the court to make arrangements to pay fines and costs, or you could also say, I don't agree with what just happened there. I don't think I should have been found responsible. I want to take this to the next sort of hearing, which is what we call formal hearing, in front of the district court judges. It involves the prosecutor's office. You have every right to do that, but if you want to do that, you must do that within 7 days of today's date. That window of opportunity closes, and you must come in to court and ask for that formally because you need to post a bond. You understand your rights on appeal?
So if I don't agree with what you're saying, I have to go to jail?
No, sir. Let me start all over again, because that's certainly not what we mean. You would have 7 days from today's date to contest my finding and say, I don't agree with what just happened there. I want to go to the next kind of hearing, which we call formal hearing, in front of the district court judges with the prosecutor's office involved. But for you to trigger that, going to formal hearing, you have to do 2 things. One is you have to ask for it within 7 days of today's date, because that window of opportunity closes. And 2, you have to come into court and ask for that formally in writing to go to formal hearing, because they do make you post a bond. That has nothing to do with jail. You couldn't possibly go to jail on this. It's just a civil infraction. The bond is the same amount as the fine. So in other words, if you want to keep contesting it, you have to put up that $100, and then you would go to formal hearing. If you got found not responsible, you get your $100 back. If you get found responsible again at formal hearing, they just take the $100 as your fines and costs. Do you understand that?
Yes.
All right. And we're all set for what we needed to do here today. I'm going to go ahead and release parties. Thank you.